Yes, a warm welcome and a very good morning, good afternoon, whatever may be. First thing, we are here for a quick revision for CS EET legal aptitude. We are here to revise legal aptitude, and almost there are 5 chapters in your legal aptitude which we are covering. Today we are starting with the topic which is called as law relating to torts. Let me give you an idea what is a tort. Okay, the very first thing, tort means something wrong done with anyone. Tort means something wrong done with anyone. There is a word tort, there is another word tortum, and there is a word wrong. Everything means the same. The only difference is the language. Tort is a word from French language. English word is wrong and the Latin word is tortum. So can we tell tort is equal to tortum, that is equal to wrong? Yes or no, friends? Just put in the comment section. Tort means tortum, that is equal to wrong. So tort is a French word. Similarly, tortum is the Latin word and English word is wrong. So can I write this way? Tort is equal to tortum, that is equal to something wrong happened with someone. Okay, so tort is which word? If I'm seeing this, tort is French word. Okay. Tortum is which word? Tortum is Latin word and wrong is a common English word which means one and the same. So if any wrong happened to someone, if anything wrong done to someone, can he file a case of tort in the court of law? Can he file a case of tort in the court of law? Answer is yes. Answer is yes. So basically tort French word, tortum Latin word, and there is something which is called as wrong, which is an English word. So let me explain you this in detail. Let me give you more example. See, wrong are of two types: civil wrong, criminal wrong. Civil wrong means a wrong which is done to a particular person, and criminal wrong means basically a wrong done to the whole society. Suppose example, there is A who promised to sell the car to B, but A did not give the car but take the money. It is civil wrong or criminal wrong? Please put in the comment section. Yes, those are watching, tell me. I am repeating my question. A promised to sell the car to B. B has paid the money, but A did not give the car. Tell me, it is which type of wrong? Civil wrong or criminal wrong? It is civil wrong. Okay. A has promised to sell the car, but instead of selling the car, okay, but he go and murder the person. It is civil wrong or criminal wrong? If you go and murder the person, it is criminal wrong. So wrong is of two types. One is civil wrong and one is criminal wrong. Basically the wrong which is, understand here, any wrong can be divided into two types. The first wrong is civil wrong and the second wrong is criminal wrong. Okay. Civil wrong means what? Something which is wrong to a particular person. Wrong to particular person. Bear with my writing. I am repeating again. Okay, there are two types of wrong, that is civil wrong, criminal wrong. Civil wrong is done to a particular person, but when a wrong is done to large public, wrong to large public, guys, it is which wrong? Criminal wrong. So tort comes under which wrong? Does it come under civil wrong or it comes under criminal wrong? Tell me, friends, what do you think? Yes, it is a civil wrong. So basically in civil wrong there are two types of wrong. One is breach of contract. You promise something but you do not perform it, that is breach of contract. And others are tort. Others are tort. So basically we can tell tort is a type of civil wrong which is done but which is not breach of contract. Suppose there is a contract and I am promised to sell you the car. I did not sell you the car. That is a civil wrong and it is a breach of contract. But there is a car. I opened your car without your permission. I opened your car with a duplicate key and go and sit in your car. It is not breach of contract. It is tort. It is not breach of contract. It is tort. Do you understand this? Yes or no? So both are civil wrong, but one is breach of contract and one is tort. Are you understanding this? Yes or no, friends? Are you listening? Come on, guys, you have to answer. So basically, wrong are of two types: civil wrong, criminal wrong. Those wrong done to particular person is a civil wrong, and those wrong done to a large public is a criminal wrong. In civil wrong, there are two types: breach of contract and tort. When you promise something but you don't do it, that is breach of contract. And other, what is not breach of contract, is tort. So tort means tortum, that is means wrong. Tort is which word? Tell me. Tort is derived from which language? French language. Okay. Tortum is derived from which language? Latin, which equal to English word called as wrong, which means English word called as wrong. So this is the whole discussion of wrong. That is civil wrong, criminal wrong. Civil wrong means breach of contract and tort. Are you guys comfortable till here? Yes or no? Yes or no? Sorry. Yes. Now let us understand the further discussion. Now let us understand the further discussion. Let me explain you some more about detail in tort. For tort, there must be three elements. There are three elements. So what are the elements? Let me understand. For tort, there are three elements. Let me open. Yes, I'll come to this. For tort, there are three elements. The very first element for tort is elements of tort. To become tort, there should be three things. First thing is there is some wrongful act done, some wrong done. Wrongful act done. Wrongful act done. Second is it is a legal damage. And third is there is a legal remedy. Understand what I'm trying to tell. There is a legal damage and there is a legal remedy. Legal remedy. Sir, what is all these things? To become a tort, there should be three things. If these three things are present, it is a tort. If these three things are absent, it is not a tort. I am repeating again. To become a tort, there should be three elements. The first element is wrongful act. Second element is legal damage. And third is a legal remedy. Understand here. Sir, what is wrongful act? See, everyone have a right. Everyone have a personal right. What are the personal right? First right. Okay, the first right is right of reputation. Everyone should get a respect. You cannot tell, you cannot defame someone. You cannot blame someone for unnecessary reason. Second is right of property. You cannot enter anyone's property without permission. Right of property. And third is basically right of bodily safety. Right of bodily safety and freedom. Bodily safety and freedom. There are three rights. Suppose example, without any reason, you print any article against me and you're trying to defame me. Is it something wrong done to me? Yes or no? Or without any reason, you enter my home without my permission, come and sit for 20 minutes and go without my permission. You are entering my property. That is not allowed. That is my right of property. How can you enter? Without my permission, you are touching me or pushing me. That is not allowed. That is right of bodily safety and freedom. So if someone is defaming someone, or if someone is doing trespassing, what do you mean by trespassing? Trespassing means to enter the property without the permission. Trespassing means to enter the property without permission, or someone is touching someone without the permission. Tell me, friends, is it a rightful act or wrongful act? What is the answer? It is a rightful act or wrongful act. Again, I am repeating. If someone is defaming someone without any reason. It happened that, like Rahul Gandhi said a statement, "Chokidar chor hai." So by this statement, he is telling Prime Minister a chore. So against Rahul Gandhi, there was a defamation case. How can you defame? Prove it. How can you tell this way? Okay. Or anyone comes to my property without my permission, enter my hall and a kitchen without my permission. Rightful or wrongful act? It is a wrongful act, right? Similarly, anyone is touching anyone, pushing anyone, that is again a wrongful act. All these things are wrongful act, very, very clear. So if I'm talking about right of reputation, if you are defaming someone, defamation, it is a wrongful act. Right of property, if you enter the property without permission, it is called as trespassing, which is wrongful act. And right of bodily safety and freedom, there are two examples. One is battery and second example is assault. Battery and assault. So what is battery? What is assault? We'll talk. Okay. So all these things, if someone is doing defamation, if someone is trespassing without permission, they are entering a property, or there is battery or assault, then all these are basically wrongful act, which is basically wrongful act and will be considered as tort. So you write down this chart first. Please note on the chart. I'll zoom the chart. Is it done? Again, I'm repeating. For elements, there are three elements. One is wrongful act. Okay. Second is legal damage. And third is legal remedy. For wrongful act, there are three rights. That is right of reputation, right of property, and right of bodily safety and freedom. If someone, instead of reputation, they defame it, or they enter the property without permission, or they do battery or assault, then that is a wrongful act. Very clear, guys. I'll show you in the book also. Just hold on. See, understand here. We'll read what is taught. The word taught is a French equivalent word of English word wrong. The word taught is derived from the Latin word totum. The word taught is derived from the Latin word totum. Thus, simply stated, taught means something wrong. But every wrong is not taught. Every wrong is not taught. Example, there is a ad सर्फ एक्सेल, हर दाग बुरे नहीं होते, हर दाग टॉट नहीं होता. Every wrong thing is taught or not taught? Tell me. Anything wrong happened is a tort, or it can be breach of contract, is a tort, or it can be crime. Every wrongful thing is taught. True or false? Tell me. Every wrongful thing is taught. True or false? What is your answer? I'm repeating the sentence. Every wrong thing done is a tort. True or false? False. Every wrong thing is not tort. Some wrong thing is breach of contract and some wrong thing is crime. Some wrong thing is breach of contract, some wrong thing is crime. But tort is which type of wrong? Civil wrong. देखो, tort is really a kind of civil wrong as opposed to criminal wrong. Okay. Wrong in law can be either public wrong or private wrong. When it is a public wrong, then it is a crime. But tort is a civil wrong which is not breach of contract or breach of trust. Tort is a civil wrong which is not breach. If it is not breach of contract, then it is a tort. Are you able to get this? So basically, the tort means a civil wrong which is not breach of contract or breach of trust. Very, very clear. To understand this, elements. How many elements are there? Tell me. How many elements of tort are there? Question to you guys. Come on. Three elements are there. What are the three elements? The first element is wrongful act. Second element is legal damage. And third element is legal remedy. The first element is wrongful act, second element is legal damage, and the third element is legal remedy. There are three elements. If I am talking about wrongful act, everyone have a right of reputation, everyone have a right of bodily safety freedom, everyone have a right of property. If someone is defaming someone without any reason, if someone enter the property without permission, and if someone does battery assault, it is called as wrongful act. It is called as wrongful act. Please read this. Yes, guys, tell me. If someone is defaming someone, if there is what? Bodily safety and freedom. Someone is assaulting someone. See, there was a case by Arnab Goswami, a media editor. Obviously, he's a chief media head, and in Republic Bharat, where he was arrested from his house. He filed a case against the police for assault. The police is being threatening him to hit. He was claiming that he was being threatened to hit. So actually threatening to hit is assault and actually hitting is battery. If someone go and hit someone is what? Battery. If someone go and just show so that is what? Assault. So what is my point here? To be very frank, to be very clear, the first thing is that if someone is defaming someone, or someone is doing assault or battery, or someone is trespassing without means entering the property without permission, is called as wrongful act. Do you understand this? Are you guys listening? Please tell me yes or no in the comment section. Come on, faster. Yes or no? Yes. So what is my point here? For wrongful act, there are three things. Now, what is legal damage? In legal damage, second element, there are 2 points. Legal damage, there are 2 points. The first point is, that is what we call as, that is damnum sin injuria. Okay, you must have studied this. Damnum sin injuria and injuria sin damnum. How many know this? Please raise your hand. How many know this? Tell me. Very good. Fantastic. Okay. Okay. So there are two things. That is, first is damnum sin injuria, and second is injuria sin damnum. So what is this? See, damnum means damage. You know, there is money loss, there is comfort loss, there is some loss to you. But sin means without. What do you mean by injuria? Injuria means without impacting your legal right. Example, suppose I start a shop and I'm earning 20 lakh rupees per annum. I'm selling clothes. Mr. Ramlal, who now competing with me, he started the shop next to me and is competing with me. Because of Ramlal, my profit is reduced to 10 lakh rupees per annum. Now tell me friends, because of Ramlal, there is monetary loss, yes or no? Because of Ramlal, I have a monetary loss, yes or no? Tell me friends, what do you think? Because of Ramlal, there is monetary loss, yes or no? Answer is yes. So that is called as damnum. That is called as damnum, means there is a damage. But can I file a case against Ramlal to recover the loss? Yes or no? Can I file a case against Ramlal to recover the loss? Yes or no? No, because Ramlal has not done anything against my legal rights. Ramlal has not done anything against my legal rights, and therefore that is there is a damage. There is a monetary loss. but there is no infringement of my legal right. He is not contravened any of my right. He is just competing. So because of Ramlal, there is a discomfort to me. Because of Ramlal, there is loss of money also. But basically, if I'm talking about, Ramlal has not done anything to my legal right. Has he done defamation? No. Has he done anything against my right of property? No. Has he done anything against my personal safety and freedom? No. So basically, there is a damage, but there is no injury. I cannot file a case against Ramlal. In short, always every monetary loss you cannot file a case. If there is a monetary loss, it doesn't mean you can file a case. There should be contravention. There should be a contravention of the legal right. There should be a contravention of the legal right. Are you able to get this? Are you able to understand this? Yes or no? Yes or no? Are you understanding? So I'll take another example. Suppose, see what is damnum? Damnum means there is damage without injury, and injuria means there is injury without damage. I'll explain. Suppose example, one of these students, suppose Anisha enter my place without my permission. Anisha come to my place, sit, watch IPL match 2 hours and leave. She did not touch a single thing. She did not harm anyone. But she entered my property and for 10 minutes she is watching IPL match and then she leave. And I was worried because an unknown person is coming to my home. Are you able to understand this? This example. So my point is, did Anisha do any harm or loss to me? Yes or no? Do Anisha have done, or is Anisha have done any act by Anisha which is causing a monetary loss to me? No monetary loss to me. But if she has done any contravention of my right, if she has breached my legal right? Yes or no? Yes. Answer is yes. I have a right of property, and now Anisha cannot enter my property without my permission, even though she has not done any damage, but she has done injury. Even though she has not done any damage, but she has done injuria, I can file a case against Anisha and recover the damage. I can file a case of tort, even though there is no monetary loss. Even though there is no monetary loss, this is called as injury without damage. She has infringed my right. She has infringed my right, but she has not done any monetary loss. But still, I can file a case. If any other person has done monetary loss but not infringe, not contravene my right, I cannot file a case. So tell me, in which case you will file a case? Situation number 1 or situation number 2? In which case you have a right to file a case? Situation number 1 or situation number 2? Yes, guys, in situation number 2, I can file a case. In situation 1, I cannot file a case. Very, very clear. So, first thing, there should be wrongful act. That wrongful act must contravene your legal right, whether it is causing a loss or not causing a loss, whether there is monetary loss or no monetary loss. If there is a wrongful act through which your legal right is being infringed, then that is called as injuria. That is called as injuria. Whether with damage or without damage, you can file a case. Very, very clear. So, guys, in this case, I'll write an example here. A started competing. A started competing with B, due to which B is having reduced profit. A started competing with B, due to which B is having reduced profit. Can B file a case against A? Tell me yes or no. Can B file a case against A? Tell me yes or no. Answer is no. There is a damage. There is a damage, but there is no injury. There is no, B is not doing, A is not doing any wrong against the legal rights. Okay. But here example will come up. Example, A entered B's house without permission. My writing is little international, but I'll dictate it. Don't worry. A entered B's house without permission, but did not do any physical harm. I'm zooming this. I'll read everything. Legal damage are of two types. Legal damage are of two types: damnum sin injuria and injuria sin damnum. Damnum sin injuria means damage without injury, and injuria sin damnum means injury without damage. Very clear? Example is A started competing with B, due to which B is having reduced profit. A started competing with B, due to which B is having reduced profit. It is called as what? It is called as there is a damage, but there is no injury. But A entered B's house without permission, but did not do any physical harm. But still, you can file a case because there is injury, even though there is no monetary damage. Are you understanding this? Are yes or no? Are you guys connected? So first thing, how many elements are there? For tort, there are three elements. The first element for tort is basically the wrongful act, and that wrongful act is need not harm you, but if it is impacting your right, then you can file a case. Now when there is something wrong, then you have a right to file a case and recover the damage. Then there is a remedy. The first remedy is, can you claim damages from the party? Tell me yes or no. Can you file a case against the person and recover damage? Tell me yes or no. Yes, but which damage? There are two types of damage. One is liquidated damage and another is unliquidated damage. So what is the difference between liquidated damage and unliquidated damage? Tell me, friends. What is the difference between liquidated damage and unliquidated damages? See, when the damage is decided by the parties, it is liquidated damage. When the damage is decided by the court, that is unliquidated damage. There is a difference. Again, I am repeating. When the damage is decided by court, decided or fixed by court, so that is called as unliquidated damages. That is called as unliquidated damages. If it is decided by the contracting parties, it is called as dash. Tell me what dash. If it is and decided by contracting parties, it is called as liquidated damages. So when tort happens, the court will decide and the court will pay you which damage? Unliquidated damage. Second is, can you get a stay order? If someone is entering your house without your permission, can you get an injunction order stopping the person from entering your house or entering your property? Yes or no? So what is injunction? To stop someone. Injunction means to restrain someone and to stop someone. That is called as injunction. And third is, you need not go to court for self-help. Atmanirbhar Bharat. Some drunkard is entering your house and he is dancing that way. and he's having that bottle, he'll hit you. You want to protect your family. To protect your family, you just make a hit him and put him outside your house. Tell me, do you need to go to court for this, or self-help is the best help? Self-help is the best help. So there are three remedies. The first remedy is claim damage. Second remedy is take injunction order, stay order, and third remedy is self-help. Are you understanding this? So this, what are the legal damages? What are the legal remedies? The first remedy is unliquidated damages. Unliquidated damages. Second remedy is injunction, and third remedy is self-help. When there is a problem, there is a remedy. Do you understand this? Self-help is the best remedy. Please write down this three remedies. Unliquidated damages, injunction, so guys, how many elements are there? Tell me, repeat. How many elements are there? Tell me faster. How many elements are there? Three elements. What are the three elements? There is some wrongful act, there is some legal damage, the legal right is conferred, and there is legal remedy. How many remedies are there? Three remedies. First is claim damage, unliquidated damage. Second is injunction, get a stay order, and third is self-help. Very, very clear. Okay. Now, wrongful act. If there is a right, there is right of property, right of reputation, and right of bodily safety and freedom. If someone is defaming you, if someone enter your property without your permission, that is trespassing. And someone is basically doing anything against your bodily safety and freedom, like battery, assault, there is a wrongful act. And such things should be contravening your legal right. Whether you have suffered a loss or not suffered a loss, that is not important. If your right is being contravened, there is a tort. And when your right is being contravened, then you have a right to take a legal action, which is called as legal damage. And recover the money, recover damage, get the stay order, and self-help. Very clear. So let us discuss what are the things which are against the personal safety and freedom. What are the things which are against personal safety and freedom? I'll explain you one by one. What are the things which are taught against personal safety and freedom? Let me give you examples. Okay. See, the tort or the wrong which are against the personal safety and freedom, which is against the personal safety, battery. If you go and apply force, if you hit someone, if you push someone, if you touch someone without any lawful justification, without any consent. See, if you want to touch also, you need to take the consent of the party. Okay, suppose there is a small baby and he is belonging to some family. You go to a garden. Nowadays in COVID pandemic situation, everyone is like to be far away. If you want to take that baby and play with that baby, do you need to take the consent of the family? Yes or no? Tell me. Or you can directly grab him. You need to take the consent. So basically, if you go and hold anyone, touch anyone, push anyone, that is a tort and that is punishable, which is called as battery. Which is called as battery. Very, very clear. So battery means direct application of force. Battery means direct application of force either without consent or without lawful justification. There are two things. If you have, see, if by law court has ordered to arrest you, pick you up and put in jail, police is holding you and putting inside the jail. Is it a battery? Yes or no? My question is, there is a court order wherever you are in whatever situation, arrest you. And if you are not listening, push, pull and get him. And the police is now pulling you to get in the court because you are not ready. Is it a battery? Tell me yes or no. No, police with the court order is arresting you. That is not battery. But without any reason, police is putting you behind the bars just to harass you. Without any court order, they are arresting you for 20 days, detaining you for 20 days. Is it a battery? Yes or no? Yes, very clear. So for a battery, there should be application of force. See, now we are talking about tort or wrong, tort or wrong, which is against safety, personal safety and freedom, which is against personal safety and freedom. Okay, guys. So now the first is battery. And what do you mean by battery? Battery means applying force either without consent, without taking the permission, without consent, or without lawful justification. Without lawful justification. Without consent and without lawful justification, it is called as battery. Very, very clear. To apply physical force, touch, push, pull, hit, put a rod, that is a battery. Write down this. First is battery. What is second? Assault. Assault means trying to show impression that you will trying to do battery. Means you're not actually touching, but you're showing. Means you're trying to create an impression that you will do battery. But are you doing battery? No. But you are making impression. You are threatening the party not by hitting, but trying to hit, trying to show. Correct. So that is assault. So actually, assault, if the party then really hit you, then that is what called as. If the party really hit you, then that is what called as. Yes, Harshit, right? If the party really hit you, that is a battery. But if they create a impression that they will hit you, if they create impression that they will hit you, then it is called as dash. If they are trying to create impression, then that is assault. Very clear, Pavana. Very clear. That is assault. So if you see this in assault, there is a impression apprehension. The act creates an apprehension in the mind of the plaintiff. Plaintiff means who's filing a case that he is going to commit battery against him. Such type of tort is called as assault. Clear? What is assault? Any act which creates apprehension in the mind that, what do you mean by apprehension? Impression. Apprehension in the mind that the other party will do battery. If you want, we can write from this yellow part. Write down this. Any act which creates apprehension in the mind of the plaintiff that he is going to commit battery against him, then the tort is called as assault. Tort is called as assault. Very, very clear. Tort is called as assault. So battery means you are applying force. Assault means you are trying to create impression that you will be applying force. That is called as assault. False imprisonment, putting behind the bars without any reason, stopping the bodily freedom to move from one place to another place, detaining someone, keeping in the custody, locking in a flat, locking in a godown, tying the person and not allowing him to move, that is like hostage. Okay, they are being tied and they are banned in the room, they cannot come outside the room. Such things are against the freedom or in favor of the freedom. Such things are against the freedom of the person, and if without any reason you put the person behind the bars, or like there was a case where the party police arrest the party to harass him and put in jail for 10 days. You are playing with his constitutional right. Every person have a right of safety and freedom. If you are putting him behind the bars, you are what, you are just depriving him of 10 days of freedom to live his life. How can you do that without any reason? So if you put anyone behind the bar, or put someone a lock in a room, bathroom or house, or not allow him to move from one place to another place, such unauthorized thing is called as false imprisonment, and such is also called as a tort. Are you understanding this? Are you getting this? Yes or no, friends? So basically, what is that is false imprisonment means the unauthorized restraint on person's body. Are you in a permission stopping anyone, or you don't have a permission? Unauthorized, without permission, you are putting a restrictions on the person body, on his movement from one place to another place, and it is a serious violation of the person's right. See this, it is a serious violation of person's right and liberty, whether confined within the four walls or being prevented from leaving a place where he is. If you are locking a person in your house, is it a tort or not a tort? Please tell me. If you are locking a person inside the house, is it a tort or not a tort? Yes, correct. Swani Nahata. It's a tort. Very clear. Understand. Harshit, very true. Tort. Okay, you are not allowed to do so. So if I'm writing down, I'll just give you more examples here. Understand. Okay, I'll give you, what we are discussing. We are discussing the tort or wrong, which are against personal safety and freedom. The tort or wrong which are against personal safety and freedom. The first is basically battery. What do you mean by battery? Battery means what? Applying force without lawful justification or without his consent. Second is assault. Assault is any act which which creates impression that battery will be committed. And third is okay, first is battery, second is assault, third is false imprisonment. Okay, false imprisonment means restraining restraining anyone from moving from one place to another place is called as false imprisonment. Fourth is malicious prosecution. Malicious prosecution. So what is malicious prosecution? Can you explain me in the comment section? What is malicious prosecution, friends? Tell me. See, battery is applying the force. Assault means trying to create that he will apply the force. Okay. False imprisonment means to tie a person and not let him move. What is malicious prosecution? See, when the party, spelling mistake, when a party is filing a wrong case only to harass the other party, create discomfort. Suppose example, there is a fight between two friends. The one friend, just to bully the other person, is filing a case, a wrong allegation is put, and now this person time, effort, money, fame is being destroyed. Very clear. Suppose example, there are two friends. Suppose example, there are two friends. Suppose one, that is trying to harass the other person, and just to create discomfort, that is, the case is being filed just to create discomfort and to defame him, just to put him into trouble, harassment, and then later on court tell that the other party is right and this party is wrong who is filing a case. Such is called as malicious prosecution. Malicious prosecution means a wrong case just to trouble the other party. Don't you think because of your wrong case the other party time, effort, money is being wasted? The other party fame is being at a threat. Are you able to get this? Yes or no? Yes. So again, that is called as malicious prosecution. Let us understand this. So malicious prosecution means starting a judicial proceedings, generally criminal case, against another without any reasonable cause or probable cause, but just which result into defamation and damage to the personal safety, freedom. That is called as malicious prosecution. So it means what? It means starting a judicial proceedings against, generally which proceedings, criminal case, against another person without any reasonable reason, and it turns in favor of another person, but due to which he damages, due to which his reputation, freedom, liberty is damaged. Are you getting this? So this is called as malicious prosecution. Just write down this. Judicial proceedings is filed against another person without any reasonable reason, and it turns in favor of another person, but due to which his reputation, freedom, and liberty is damaged. Are you getting this? Yes or no? So first, what is against the person? That is a tort. That is a tort against personal safety and freedom is battery. Second is assault. Third is false imprisonment. Fourth is malicious prosecution. Fifth is nervous shock. What do you mean by nervous shock? See, nervous shock means you see some incidents which is not having a physical force on you, but it is creating a mental pressure on you. You have seen someone hitting your family and hitting in a very bad manner. Now you are into that stress, you are into that depression. You have seen an incident or accident by which you are going through mental trauma and you are really ill because of that. You are not able to sleep. You are not getting that. Yes, that is disturbance in the mental health. Very true, Sakshi. Correct. So what is my point? Such things which is not having a physical injury but a mental injury, and the person is really not happy with what he's seen, is really disturbed, going with a mental emotional trauma, that is called as nervous shock. Very clear? So understand here, only getting a nervous shock is not enough. Causing nervous shock itself is not enough. Some injury or illness must take place as a result of emotional disturbance, fear or sorrow. Emotional disturbance, fear or sorrow, that is called as nervous shock. Do you understand this? Yes or no? Yes or no? So you have seen an accident, incident, someone murdered and with hitting 20 times the knife, because of which you for 20 nights you are not sleeping. Is it a nervous shock? Yes or no? Yes. And the last is defamation, attacking on the reputation of the person. Attacking on the reputation of the person. Many defamation cases are filed by one politician to on another because they are just trying to defame the family. It is in Hindi called as manhani ka case. What we'll talk in Hindi, it is called as manhani case, defamation case. Okay, defamation case on Rahul Gandhi by Rahul Gandhi appears before the Surat court in defamation case. Rahul Gandhi appears before the defamation case is filed against Rahul Gandhi. Okay, this happened now in 2021 also. Okay, defamation case against Rahul Gandhi, reconsider BJP MLA plea to examine four witness to this. Something he said, something happened, and there was some whatever maybe. Okay, so what is the thing? Without any reason, if you are blaming anyone, without any reason, you are tarnishing their image, you are spoiling their image. You should have evidence. If you have an evidence, can you defame the person openly? Yes or no? If you have an evidence, can you defame the person openly? Yes or no? Answer is yes. But without evidence, without any reason, you are defaming someone. That someone, just imagine if your name is being spoiled in your society, people will look you in that wrong angle. They will not respect you. It is impacting your liberty and the freedom in your life. Understand here. So if someone is defaming you without any reason, you have a right to take action which is called as defamation. Do you understand? So defamation are of how many types? Defamation are of two types. One is libel and one is slander. When it is in temporary form, when it is in temporary form, it is slander. And when it is permanent form of defamation, that is libel. If you make a movie and defame someone with the help of a movie, that is libel. When you orally tell something which is not recorded, that is temporary form, that is slander. Are you understanding? So tell me friends, permanent form is called as libel. Repeating again, permanent form of defamation in the form of videos, cinematography, music recording. You are made a song and you are, in the song you are insulting someone. That is which form of defamation? Libel or slander? That is which form of defamation? Libel or slander? Yes, it is libel. Very, very clear. But if you have given abusive word to the person in oral form, that is which form of defamation? Libel or slander? Harshit and Anisha going right. Harshit, very good. Slander it is. Anisha, A, slander, correct. So guys, the more permanent form, more the punishment. More permanent form, more the punishment, and more the temporary form, less the punishment. Very clear. So understand here, punishment for libel is more. Punishment for libel is more and punishment for slander is comparatively less severe. Punishment for slander is comparatively less severe. So guys, we have done 6 points. What are the 6 points? What are the 6 points we are discussing about those wrong which are against, those wrong which are against personal safety and freedom? The first is battery, second is assault, third is what? Third is false imprisonment. Fourth is malicious prosecution. Fifth is false imprisonment. and sixth is basically defamation. In defamation there are two types, that is libel or slander. Please read this. Any query here? Please ask. Yes, that is nervous shock, correct. Fifth is nervous shock, correct, correct. Yes, bodily harm will come in battery. There's one comment, that is bodily harm, Swani, Nahata, it will come in battery. Is that fine? Fine. So with this, we have talked about what are the wrongs which are against the person's safety and freedom. Now we are talking about what are the remedies available to. What are the remedies available through court and what are the remedies available without the help of the court. Obviously, first you will try without the help of the court extrajudicial remedies. And if not possible, then only you will go to the court. In court, you will go and ask for damage. In court, you will go and ask for injunction, stay order. Getting my point? So remedies, when there is a problem, there is a remedy in the law, and the remedies are of two types. If I am talking about, okay, kahi na kahi, understand here, judicial remedy and extrajudicial remedy. When it is a judicial remedy, means what? Judicial remedy means there is a damage, there is injunction and restitution, taking back your property. Someone has taken your phone without your permission. Can you file a case and take back your phone? Someone has taken your phone, mobile phone, without your permission and is not ready to give. You have that secretive data, bank balance, everything. Can you file a case and recover the phone? Tell me yes or no. Someone is entering your property, land, without your permission. Can you get a court order to stop the party from entering the land? Yes, that is injunction. And someone has done tort. Can you recover damage from him? Yes or no? So all these are judicial remedies, that are damage, injunction and specific restitution of property. I am repeating, that is damage, injunction and specific restitution of property. Are you getting this? Yes or no? Are you getting this? Yes or no? Correct, guys? But without the help of the court, there are other six methods: self-defense, prevention of trespassing, re-entry of land, recapture of goods, abatement of nuisance, and distress damage feasment. Sir, what are these six extrajudicial remedies? What are these six extrajudicial remedy? I'll discuss that. Understand here. See, the first is self-defense. If a drunkard is entered your house and there is a risk on you, someone is found in your room without your permission, to protect yourself, can you attack reasonably and remove the person? Obviously you will give a warning first. If the person is not listening, can you have a reasonable force and remove the person? Court will come later on. First you will try to rescue yourself, right? So can you do self help and self defense and protect yourself? Answer is yes. Answer is yes. That is called as self defense. That is called as self defense. Are you understanding this? See this. It is lawful for any person to use reasonable force to protect himself or any other person against any unlawful use of the force. See, someone is attacking you, someone is entering your house, someone is coming and touching you. Can you do the self defense? Someone is touching your family member. Can you do the self defense and help the family? Yes or no? Answer is yes. Very, very clear. So, first tell me, how many remedies are there? There are two remedies. First is judicial remedies and second is extrajudicial remedies. What is judicial remedies? With the help of the court. And what is extrajudicial remedy without the help of the court? First, I want you guys to note down this chart. Write down this. start first. Write down this chart. Okay, so have you written this chart? The first is what? That is judicial remedy, and second is extrajudicial remedy. In judicial remedy is with the help of the court. It is with the help of the court. And extrajudicial remedy means without the help of the court. One by one we'll be discussing this. Are you guys connected? Please ping me yes or no. Tell me faster. Are you connected? Yes. Are you connected? Very good. Self-defense. Can you apply reasonable force to protect yourself and your family? Yes. Someone is entering your property without your permission. First, you will warn him. Please stay outside. Don't enter the house. If he's not listening, can you push him and remove the person? Yes or no? Or do you need to ask court, hello court, can we, there is a person entering our house without our permission. Please tell him to go. So basically, friends, my point is you cannot do that. You cannot do that. First thing is you will apply reasonable force and prevent the trespassing. Prevent the trespassing. It very commonly happens in open land. There is a private land and people, their private land which is being obviously fencing is done, but people use it for transport shortcut. You're not allowed. They put a board, this property is a private property, trespassing will be prosecuted. Have you seen such thing ever? In open land they put the board, this property belongs to Mr. So, and if any person enter the property without the permission or trespassing will be prosecuted and legal action will be taken. Yes. So can you prevent the party from entering the land? Yes, 100% yes. The first remedy is self defense, to protect yourself. Second is someone is entering your land without permission, can you stop him? Yes. Second is prevention of trespassing. Third is re-entry of land. Suppose example, I am on a holiday, so my parking is being occupied by someone else. When I come back, I see my parking is a private parking and anyone else has parked the vehicle. I click a photo and put in the society group and tell, please remove the car. Watchman come and remove that two-wheeler car. And now I park my car. Can I take back my parking and use my parking? Yes or no? Can I take back my parking and use the parking? Yes or no? Yes, that is called as re-entry of land. The person who is wrongfully dispose the land may retake the possession of land, and if he can do so in a peaceful and reasonable manner. Don't fight, don't hit him. First give him a notice, please remove your bike, please remove your car. Intimate him, give him a time to remove it. Don't come and do fighting, that is not allowed. But you can take back your parking, that is called as re-entry of land. Same way, someone has taken your mobile phone, friends do it. Lot of secret nowadays in mobile phone. So now you take your friend's mobile phone, snatch it, keep it to yourself, and now you're not giving or returning it. Can your friend take back the mobile phone? Yes or no? Can your friend take back the mobile phone, friend? Yes or no? Tell me. Yes. Like you can take back the parking. Can you take back the goods? Yes. That is recapture of goods. And there are more two things, that is abatement of nuisance and distress damage easement. Abatement of nuisance and distress damage easement. These two things students don't understand very soon, but I'll explain that, don't worry. What are the remedies? First remedy is self-defense. Second remedy is prevention of trespassing. Third remedy is re-entry of land. Fourth remedy is recaption of goods. Now I am talking about more two remedies. But before that, tell me, what are the remedies for what? Judicial remedy, judicial remedy and extrajudicial remedy. Judicial remedy is the first remedy is if I'm talking about okay claim damages. Second is injunction and third is restitution to take back. Correct. What are the extrajudicial remedy? In the this case, self-help, prevention of trespassing. Third is re-entry of land. Fourth is recapture of goods. Fifth is what is fifth? See, abatement of nuisance. Do you know this? Tell me, friends, yes or no. Do you know this? Do you know this abatement of nuisance? Tell me yes or no. Harshit is telling yes. Very good. Harshit, can you unmute and talk? What is this? What about others? Okay. I'm talking about abatement of nuisance. Understand here. What is abatement of nuisance? Suppose example, I'll just take example here. There are two bungalows next to next, which is there. There is a bungalow A and there is a bungalow B. In bungalow A, there is Ramlal and bungalow B, there is Shyamlal. Bungalow B, there is Shyamlal. Okay. In bungalow B, there is a tree which is having branches and spreading till bungalow A and entering A's house and creating a ventilation problem. Now, there is disturbance and there is a thought and there is something which is right of property is being deprived. So now A will give notice to B, please cut the trees. Now B is not listening even after giving notice. Can A go and cut the branches and save himself? Can he go and cut the branches like this and reduce the tree? Yes or no? Can he stop the nuisance on his own by cutting the tree himself? Yes or no? My question is, A has given a warning, B, please cut the branches. The branches is extended to his house. Okay, that is creating a disturbance. Now, in that case, can A give notice to B? And if B is not listening, can A go and cut himself the branches? Obviously, he should do very less damage to B, and obviously he should use a reasonable method so there is less loss. But to stop the nuisance himself, can A go and cut the trees? Yes, that is called as abatement of nuisance. See, for abatement of nuisance, there is example written: the occupier of land may lawfully abate, stop any nuisance which is injuriously affecting it. Thus, he may cut overhanging branches as spreading roots from the neighbor's tree upon giving notice, choosing the less mischievous method and avoiding unnecessary damage. By giving notice, selecting the less mischievous method and avoiding unnecessary damage, by this way, can they abate the nuisance? Yes or no? Answer is yes. Can he stop the nuisance? Can he hold the nuisance? Can he put a break to the nuisance? Yes, but he should give notice for that. He should use a reasonable method and less mischievous method, and he should avoid unnecessary damage. Then only this is possible. Please read this. And last is distress damage easement. See, again I'm telling how many remedies are there. Extrajudicial remedy, self-help. Okay, self-help. Then if I'm talking about prevention of trespassing, then re-entry of land, recapture of goods, and distress damage feasment. Okay, next is, that is distress damage feasment, and we have done abatement of nuisance. Now we are coming to distress damage feasment. Any idea what is this? See, till the time you don't get the damage, keep the goods with yourself. Till the time you don't get the damage, keep the goods with yourself. And the day you get the damage, return the goods. Sir, example, best example is Tarak Mehta Ulta Chashma, whereby Tarak Mehta Ulta Chashma, you see Bide and Tappu always fight on the cricket. Now Tappu hits a six, and which the ball is into Bide's home, and they damage and hit the window, and now window glass is being, the situation. Now Bide will come and take all the bat stump and tell, repair my window first, and then I'll return the bat ball stump. Otherwise, I'll not return. Now the things with which damage was done is being seized and taken into custody. The day they repair the window and the damage is being cleared, then he will return the goods. Such thing of seizing the goods till the damage is being paid is called as distress damage feasment. Example, if your cattle come to my land and destroy my farm, can I seize your cattle and tell, first pay me my damage, then I will give your cattle? Tell me yes or no. So what I'm doing, I'm taking in my custody your cattle to recover the damage. I'm taking in my custody your cattle to recover the damage. This is called as distress damage feasment. This is called as distress damage feasment. So occupier may lawfully seize any cattle or chattel which are unlawfully on his land doing damage therein, and detain them until compensation is paid for damage. This right of is called as distress damage feasment, which are doing damage. You can take in your custody all the things which are damaging it, and that is called as distress damage feasment. So with this, how many remedies we have learned? With this, how many remedies we have learned? How many remedies we have learned? Extrajudicial remedy, there are six. How many extrajudicial remedies? Six. And how many judicial remedies we are learning? Three. Okay. In judicial, there are damage, injunction, restitution. And extrajudicial, there are six. One is self-help. Second is prevention of trespassing. Third is re-entry of land, recapture of goods, distress damage feasment, and abatement of nuisance. Please read this. Yes or no? Now let us develop, understand. There is a very important concept called as vicarious liability. See what we have discussed. What is a tort? What is a tort? Tortum and wrong. Very clear. We have discussed elements of tort. Yes or no? We have discussed elements of tort. Then we have come to what are the tort which are against the personal safety and freedom. Then we have come to remedies of tort. We have come to remedies of tort. Now I am coming to vicarious liability. What is vicarious liability? Any idea? Please put in the comment section, friends. See, I'm going very fast because I need to cover up many things. I cannot sit across and play slow match. Regular batch is already done, right? So we are into quick revision marathon series, right? So my point is, what is vicarious liability? This is the question to you. What is vicarious liability? What is vicarious liability? Acha, how many knows that? Raise a hand. How many know this? Raise your hand. Vicarious liability concept. Okay, very good. One is Gagan. What about second? Anisha. Okay. What about others? See what happens. I'll tell you what is the concept. Generally, who do the tort is liable for the tort. Generally, who do tort is liable for the tort. Example, if I go and push someone, I am responsible. If I go and hit someone, I am responsible. If I defame someone, I am responsible. It means those who do tort are called as tortfeasor. Those who do tort are called as tortfeasor. Very clear. If Rahul Gandhi is defaming someone, then Rahul Gandhi himself is liable. Rahul Gandhi will be called as tortfeasor. But in vicarious liability, tort is done by one and responsible is another. But in vicarious liability, tort is done by one but responsible is another. There is a very Hindi popular song, तू प्यार है किसी और की तुझे चाहता कोई और है. Do you know? Matlab, done by one and responsible by another. I mean that. Tort is done by A, responsible is B. When this is happening, that is called as vicarious liability. When this is happening, it is called as vicarious liability. So understand here, what is the general rule? The general rule is who do the tort will be liable. But in case of vicarious liability, who does not do the tort or who does not do the tort will be liable sometimes. See, understand here. Let us make a chart for this. Vicarious liability. What is the general rule? The general rule is tortfeasor liable for tort. But in certain cases, that is vicarious liability, in certain cases there is vicarious liability, that is tort is done by one and responsible is another. Tort is done by one and responsible is another. Tort is done by one and responsible is another. That is called as vicarious liability. Now let us understand. In vicarious liability, there are four situations. See, what is the rule? Who do the tort will be liable. But what is vicarious liability? Who do the tort? Someone else will be liable. Let us take an example. The very first example is master and servant. If employee does something wrong, can the tort case be filed against master? If employee does something wrong, can the tort case be filed against master? Answer is yes. Answer is yes. See here. Okay. Simple. If master does something wrong, see, master is liable for the tort committed by the servant while he is acting in the course of job or employment. When the servant is acting in a personal capacity, then he is liable. But when the servant is acting during job and he does something wrong, can the tort case be filed against the master? Answer is yes. Very, very clear. So understand here, let us take the case that is Century India Company Limited versus Northern Ireland Transport Board Limited. What is the case? The director of the petrol lorry, while transferring the petrol to underground tank, he struck a matchstick for a cigarette and he lighted matchstick was thrown on the land, because of which petrol pump was under fire. Now, it was a mistake of the employee. Can the petrol pump file a case against the company? Yes or no? It was a mistake by the employee. Can the petrol pump file a case against the company? Tell me yes or no. Are you getting my question? I am repeating. See, there was a petrol truck, and from the petrol truck, the petrol was being transferred to underground tank. While this was happening, the employee of the petrol truck, he lighted a matchstick, put cigarette on, throw the matchstick on the ground, because of which petrol pump is under fire. Now the mistake is of the employee. Can the petrol pump file a case against the company? Answer is yes. Vicarious liability, any wrong thing done by the servant, any wrong thing done by the servant, master will be liable. Any wrong thing done by the servant, master will be liable. Vicarious liability. Same fashion. If there is principal and agent, if agent does something wrong, can the case be filed against principal? Yes or no? If agent does something wrong, can the principal file a case? Yes or no? Yes. There is again a landmark case. The case is Lloyd versus Great and Smith and Company. See, there was a solicitor but advocate firm, and they sent their clerk to a client lady, old lady. Clerk did what? He made a papers, fraud papers, transferring all the property of the client in his own name. And the lady under the trust signed the papers. Now, clerk did fraud during his job. Example, there is a firm of partners who are advocate and they send their client, send their clerk to the client. Clerk drafted all the papers in his favor, all the property. Lady signed the paper. There was a fraud done. If there is a fraud done by the agent, can the client file a case against the principal? Yes or no? If there is a fraud by the agent, can the client file a case against the principal? Yes or no? Yes, answer is yes. Read this case. Lloyd versus Great Smith and Company. The managing clerk of the firm of solicitors, that is advocate, by acting in ordinary course of business, committed fraud against a lady client by fraudulently inducing her to sign the documents transferring her property to him. He has done so without the knowledge of the principal who was liable because the fraud was committed in the course of employment. I am repeating again. The managing clerk of the firm of solicitors, while acting in the ordinary course of business, committed fraud against the lady client by fraudulently inducing her to sign the document transferring her property to him. He has done so without the knowledge of the principal who was liable because the fraud was committed in the course of employment. Read this case. Okay, are you understanding this? So this was your second case, that is principal and agent. Okay, there is independent contractor, and there is employer. I am asking you a question, you have to answer. There is independent contractor and there is employer. If any wrong done by independent contractor, employer will be liable or not liable? if there is independent contractor and there is employer, if anything wrong done by the independent contractor, employer liable or not liable? Tell me. What do you think? Suwani Nahata is telling no. What about others? Neha, Anisha. My question to you is, there is an independent contractor and there is employer. If any wrong done by independent contractor, employer will be liable. Vicarious liability there or not there? Answer is not there. I'll take an example. Suppose I am a mechanic. Example, I am a mechanic and I am repairing Amitabh Bachchan's car. His car is being repaired by me. I am the mechanic, I am the owner. Okay. Now I did not do the repairing correctly and there is a brake fail. Amitabh Bachchan car is driving on the highway and Amitabh Bachchan car hit Salman Khan's car. Okay. Salman Khan approached against Amitabh Bachchan in the court of law. Amitabh Bachchan proved that our car was technically not done correctly by an independent contractor. Our car was not repaired by an independent contractor, Mayur Agarwal, properly. So why we are responsible? He has done some wrong. So prima facie, Salman Khan can file a case against Amitabh Bachchan, but in the court of law, my mistake, will Amitabh Bachchan will be liable? Answer is no. Employer is Amitabh Bachchan. I am independent contractor. I do any mistake. Is Amitabh Bachchan liable as an employer? Answer is no. He can prove that the service was wrongly delivered. Please catch Mayur Agarwal and take action against him. He is not liable. Do you understand this? Yes or no? So if there is wrong done by independent contractor, employer liable or not liable? See, master servant, yes, there is vicarious liability. Principal agent, yes, there is vicarious liability. Independent contractor, employer, no vicarious liability. But in certain cases, independent contractor and employer, there is vicarious liability. The landmark case is Rayland versus Fletcher case. The landmark case is Rayland versus Fletcher case. Generally, if independent contractor does anything wrong, employer is not liable. Amitabh Bachchan is not liable. But in exceptional cases like Rayland versus Fletcher case, if independent contractor does something wrong, employer is liable. Do you know the case Rayland versus Fletcher case? Tell me. Yes or no? Do you know the landmark case Rayland versus Fletcher case? Yes or no? Waiting for your response. Tell me, friends. Anisha A is telling yes. What about others? Very important case. I am repeating again. See, if any employee does something wrong during job, is the owner liable? Yes. If agent does something wrong, is the principal liable? Yes. If independent contractor does something wrong, employer liable? No. But in certain cases, that is Rayland versus Fletcher case, if independent contractor does something wrong, then the employer is liable. I'll show you one of the video on from YouTube to explain you this. Hold up. You example and idea what is exactly Rayland versus Fletcher case. Understand. So there are two adjacent land. In this one land there is mill and another land there is coal mining. Okay. There is a mill and there is a coal mining. Very, very clear. Now let us understand this. Rayland versus Fletcher case. Okay. Now the mill belongs to B and the coal mining belongs to A. Now they wanted water reservoir. So they appointed C, an independent contractor, to make the reservoir. Now when they were digging the land, they have digged the land, but below that there was again a shaft, means a hollow place. The independent contractor did not check it. So if he would have checked it, so they would have covered the shaft. the gap. Okay, suppose this is the land. I'll just make a diagram. You'll understand it better. Okay, this is the land, and there is this digging. Okay, till there is land, and now below this there is a shaft, hollow place. Okay, and then again there is land. Okay, then again there is a land. They started digging it, and they have digged this much. They have digged this much for making a reservoir, but they did not check the shaft area. Now, independent contractor did not verify what is below the digging area. He filled the water filled in. They've gone to the shaft and gone to the neighboring area in the coal mine, and the whole coal was destroyed. So basically, now the neighbor filed a case against B. Neighbor filed a case against B. You have done something wrong. B is telling that it is not my mistake. It is the independent contractor who I have given the contract, I have paid money. It is his mistake. So this matter approach court of law. A is filing a case against B. B is telling that I am not liable. It is the independent contractor liable. Take action against the independent contractor. Court said that even though independent contractor has done tort, but we will held responsible the employer, and there is a vicarious liability against B. Are you getting this? There is vicarious liability against B, which happened in Rayland versus Fletcher case. For vicarious liability in Rayland versus Fletcher case, there must be two things: non-natural use of land. Non-natural use of land, and second thing is escape from land. If these two things happen, escape from land. Sir, what are these two things? See, reservoir was naturally already there or you artificially made it. See, certain reservoir was already there and naturally you fill the water and it burst out. Then that's not your mistake. You have done natural use of land, but you made a reservoir. So this is non-natural use of land. And when you fill something, you gather something, and the water you have gathered there and it is escaping, then that is your mistake. Even though independent contractor was at mistake, but we are creating vicarious liability. Employer will be liable. B will be liable to compensate A under Rayland versus Fletcher case. And now, if independent contractor does something wrong, in case of Rayland versus Fletcher case, employer will be liable. Employer will be liable. Are you listening, friends? Are you listening? Yes or no? Yes or no? So I'm repeating again. Generally, what is the rule? If independent contractor do something wrong, who is liable? Generally, what is the rule? If independent contractors do something wrong, who is liable? My question to you is, if independent contractor does something wrong, who is liable? Independent contractor is liable. But in Rayland versus Fletcher case, if independent contractor does something wrong, who is liable? Employer is liable. Very clear. For that, how many conditions are there? Two conditions are there. What are the two conditions? Please tell me. What are the two conditions? First condition is non-natural use of land, and second is escape from land. So understand here, let us see. Vicarious liability. Tort is done by one and responsibility is of another, that is vicarious liability. Servant does something, master liable, vicarious liability. Agent does something, principal liable, vicarious liability. Employer does something, independent contractor not liable, no vicarious liability. But in Rayland versus Fletcher case, employer does something, independent contractor liable, vicarious liability is there, for which there are two things. First is non-natural use of land, and second is what called as the second is escape from land. Do you understand this? Let us read the landmark case. See, the B, a mill owner employed independent contractor who have apparently competent to construct a reservoir on the land provided for water for the mill. There were old disused mining shaft under the site of reservoir which contractor failed to observe because they were filled with earth. The contractor therefore did not block them. When the water was filled in the reservoir, it burst through the shaft and flooded the plaintiff, means the neighbor who is filing a case, plaintiff coal mine on the adjoining land. This what happened? Read this. Now question, whether B is still liable even though he is not as at fault as the appointed independent contractor? This is the question. Read this. Okay, so let us read the case. What is the conclusion? What is the conclusion? The conclusion is, understand here, the conclusion is the true rule of law is that who is or for his own purpose brings on his land and collects and keep. If I keep some animal and that animal run and he go and bite the neighbor, who is responsible? Animal or me? If I get an animal and keep at my place, that animal is running from here and there and you bite my neighbor, who is responsible? I am employer responsible. Do you understand? So anyone get for his own purpose anything on the land and keep them to do mischief, if it escape, must keep a peril, and if he does not do so, prima facie he is responsible for the same. Are you able to understand this? So this was Rayland versus Fletcher case. Do you understand? But see, understand here. We are talking about vicarious liability. What is vicarious liability? What is general rule? General rule is who does the tort will be liable. But in vicarious liability, tort is done by one and the responsibility is of another. Servant does something, master liable. Agent does something, principal liable. But employer does something, independent contractor does something, independent contractor does something, employer not liable. But as per Rayland versus Fletcher case, with this exception, independent contractor do something, employer is liable, and in that case there is two rules. The rule is non-natural use of land and escape from land will be called, then the independent contractor does something, employer will be liable. But there are certain exception. What do you mean by exception? What do you mean by exception, friends? See, in exception, in case of exception, even if independent contractor do something, employer not liable. In case of exception, not liable. Suppose example, B constructed reservoir with the permission of A and for the benefit of B as well as A. B have made the reservoir with the permission of A. Now, if contractor do something wrong, is B liable? Tell me. I am repeating my question. I am repeating my question. If B constructed a reservoir with the consent of A for the benefit of A and B both, now if independent contractor do something, is B liable? Yes or no? Anisha, answer is no. What about others? Neha, Anisha, Sakshi. Sakshi is telling no. Very good. Answer is no. If B makes a reservoir, okay, B makes a natural use of land. There is a reservoir already there. There is a reservoir already there, and by rain the water fills, and there is a burst. The river burst out and go to the neighboring land. Now tell me, for this case, who is liable? Now tell me who is liable? Employer liable or not liable? He makes a natural use of the land. Who is liable? Employer liable or not liable? Friends, please tell me. Not liable. Very clear. Or there is natural disaster. There is so flood that the reservoir bursts out and go to the neighboring land. There is huge flood which is not in your hands. There is natural disaster now because of which you are not liable. Tell me, employer liable or not liable? Not liable. Very clear, guys. Right? So see, if you do make a reservoir, if you do anything with the consent, then you are not liable. If you make natural use, then you are not liable. There is natural disaster, then you are not liable. If you make a reservoir and your neighboring friend A come and destroy the reservoir on his own, and now only he is suffering, all the water is drained to his place. The dot is due to his own mistake. He comes and hit the reservoir with a rod, and now the reservoir is leakage is there, and the water is flowing to the neighboring land. Tell me now, employer liable or not liable? Employer liable or not liable? Please comment. Suppose I have a bungalow, and in the bungalow I have parked a horse, and there is a neighboring friend. I stay in bungalow A. There is neighboring friend B. I have parked a horse here. This is not a horse. Just example. Okay, diagram example. Now he comes and remove the rope of the horse. Now horse goes to his garden and destroy the garden. Who is liable? A liable or B liable? Employer liable or neighbor liable? It is the neighbor liable. Employer is not liable. It is the mistake of the neighbor himself. It is the mistake of the neighbor himself. Do you understand this? Yes or no? So there are certain exceptions which we have to talk about. There first, if you have done natural use of land, or you have made a reservoir with the consent of plaintiff, you have made a reservoir with the consent of plaintiff, or you are doing government duty, government has said you to make a reservoir, or government is making a reservoir, then you are doing statutory duties, or there is natural disaster, that is act of God, or escape is due to plaintiff's own default. The neighbor has come and hit the reservoir, or third party come and hit the reservoir. You have made it properly, but someone has hit it and damaged the reservoir, due to which the water is flowing to the neighboring land. All these cases are exceptions to Brilliant versus Fletcher case, and these are the exceptions to the Vicarious Liability. I'm writing down here. Just hold on. Exceptions to Brilliant versus Fletcher case. First exception: natural use of land. Second exception is consent of plaintiff was taken. Third exception is natural disaster. Fourth exception is statutory duties. Fifth exception is plaintiff's own default. And sixth exception, third party default. Okay, please read this, write this. Are you getting this? Are you friends there? See, again, natural use of land, I am not liable. I have taken the plaintiff consent, I am not liable. There is natural disaster, I am not liable. I am doing government duties, I am not liable. Plaintiff is at his own fault, I am not liable. Third party comes and damage the reservoir, I have taken all the action, I am not liable. So all these are cases where Raylan versus Fletcher case is not liable. Employer is not liable for any mistake by the independent contractor. Employer is not liable for any mistake by the independent contractor. Now I am coming to absolute liability. See, what law is telling that? Law is telling that as a landmark case, okay, there is a landmark case, MC Mehta versus Union of India and other case. Union of India means government case. See, law is telling that those industries who are handling dangerous nature of goods, dangerous chemicals, gases. Do you remember the Bhopal gas tragedy? It was the world dangerous industrial disasters. Okay, and now still we are suffering with that Bhopal gas tragedy. And after that case, we come to this landmark case, MC Mehta versus Union of India case. What happened in Bhopal gas? Whether there is natural use of land or non-natural use of land, whether there is escape or no escape, but because of them, if any life is at threat, there is absolute liability. There is no that two conditions required. See, for vicarious liability, there are two conditions. What are the two conditions? We have written down the two conditions. The condition is non-natural use of land and escape from land. The two conditions are basically non-natural use of land and escape from land. But whether there is natural use or non-natural use, if you're dealing in hazardous goods, these two conditions, whether you do it or don't do it, because of hazardous goods and hazardous chemical, if any life is at threat, you are liable. If any life is at threat, you are liable. That is under MC Mehta versus Union of India case. There is absolute liability, no delegable liability, no debatable liability. Who is dealing in hazardous chemical, whether they fulfill these two conditions or don't fulfill these two conditions, but still there is a liability which is called as absolute liability. Are you guys understanding? Are you listening to me, friends? Are you connected? Tell me yes or no. Yes. Pawan is listening. Okay. Okay. Achyut is listening. Okay. So let us read this. Sakshi is listening. We are of the opinion that enterprise which is engaged in hazardous or inherently dangerous industry which possesses a potential threat to the health and safety of the person working in the factory and residing in the surrounding owes an absolute and non-delegable duty to the community to ensure no harm result to them on account of any hazardous or inherently dangerous activity which has undertaken, which is MC Mehta versus Union of India case, whereby absolute liability, no question, no conditions, you are liable. Employer is liable whether your mistake is there or your mistake is not there, which is called as absolute liability. But for vicarious liability, there have to be fulfillment of two conditions, then only the vicarious liability takes place. Are you getting this? Yes or no? Okay, so we were discussing about vicarious liability and absolute liability. What is vicarious liability? The liability means the basically tort is done by one party and the case is on another party. That is vicarious liability. Very clear? I am repeating again. The tort is done by one party and the repayment or the case is filed on another party. That is vicarious liability. There are many cases where there is vicarious liability. If I'm taking an example, if servant or employee does something, master or employer will be liable. That is vicarious liability. Or agent does something, principal will be liable. That is vicarious liability. And generally, if independent contractor do something and basically employer is not liable, that is clear. But in Raylan versus Fletcher case, there was a situation whereby employer does something and basically independent contractor do something, but the employer was liable. In Raylan versus Fletcher case, when the independent contractor do something, the employer was liable, And to make the employer liable, there are two rules. First is non-natural use of land, and second is the basically if I'm talking about the first is non-natural use of land and second is the escape from land. As per the Raylan versus Fletcher case, then guys, for that case, who is liable? Independent contractor liable or employer liable? Tell me in the comment section who is liable. That is employer liable. There are certain exceptions whereby I am repeating what we have done. Okay, just going through it again. Okay, what we have done I am repeating again. There are certain exceptions whereby vicarious liability is not applicable. It means even though independent contractor has done something but employer is not liable. So what are the exceptions? When the employer has done the natural use of land. Second is that natural use of land. Second, if I'm talking about the employer has done with the consent of plaintiff. Third, he is doing statutory duties. Fourth, if I'm talking about natural disaster. Fifth, basically plaintiff's own default. And sixth, third party default. All these cases, vicarious liability is not applicable. Then we have come to absolute liability. And the landmark case MC Mehta versus Union of India case. What this case have set the benchmark is that those industries who are dealing in hazardous chemicals and dealing in the dangerous goods are responsible even whether they are mistake or not mistake. If anything happens, there is absolute liability on them and this liability cannot be delegable. They are themselves liable in MC Mehta versus Union of India case. Okay, so now we are coming towards understanding of vicarious liability of the state. We are coming towards the understanding of vicarious liability of the state. So what exactly is the vicarious liability of the state? I'll give a understanding. What do you mean by state? Means government, central government, state government. See, if police commissioner do something, is the government liable? If any government employee do tort, can you file a case on the government? This is the question. Answer is yes or no. Some answers are telling no sir, some are telling yes sir, some are telling no and yes, mixed opinion. Okay, yes no, okay. See, let us take what is the situation. Let us take what is the situation in England because our law is majorly based on England law. Okay, so what is the position? What is the position in England earlier? Earlier, if employee does something wrong, public servant does something wrong, the crown, the king, the government not liable. But by the passing of the law, Crown Proceedings Act, after passing the law, Crown Proceedings Act, do you understand this? Crown Proceedings Act 1947. Crown Proceedings Act 1947. After this law is passed, now, if any public servant or government employee does tort or do tort, then the crown and the king will be liable in England. Do you understand? So tell me, earlier, was there a vicarious liability or there was not vicarious liability? Tell me. Earlier, there was vicarious liability or no vicarious liability? What do you think? There was a vicarious liability or no vicarious liability? No, but now with the passing of the law, Crown Proceedings Act, okay, now there is a vicarious liability or no vicarious liability? Yes, there is vicarious liability. So now this before Crown Proceedings Act, Crown Proceedings Act 1947, and now after Crown Proceedings Act, Crown Proceedings Act 1947, before no vicarious liability. After passing this law, there was vicarious liability. There was vicarious liability. Very, very clear. Do you understand this? Are you getting this? Correct. So before this there was no vicarious liability, but now there is vicarious liability which is there. To be very frank. Okay. Okay. Now, what is the position in India? If any public servant does something wrong, if any public servant does something wrong, can you file a case against the government? If employee do something wrong, is the government liable? Yes or no? Let us see. Position in India. Position in India, to be very frank. What is the position in India? Okay, very simple. One, they are doing statutory duties. Means for the people, by the people, statutory duties. And one, they are doing commercial duties, like they are making profit, government companies and all. Commercial duty. Okay. If they are doing statutory duty, then no vicarious liability. And if they are doing commercial duty, then there is vicarious liability. Very clear. So basically, and if any case on central government, it will be filed in the name of union. And if any case on the state government, it will be filed in the name of the state itself. Union of India and the state. Okay. In this case, it will be filed. But if they are doing any statutory duty, that is for the people, that is called as they are not liable. Government is not liable. But if they are doing commercial duty, they are liable like a private person. They are liable like a private person. But the case will be filed. Suppose it is the central government, the case will be filed in the name of union, and when it is a state government, the case will be filed in the name of state. Do you understand this? Write down this. Okay. So now with this, we are done with vicarious liability. Now we'll understand certain more concept, and we are ending the topic law of torts in detail. Yes, there is a word called as mens rea. The word called as mens rea. What is mens rea? Mens rea means guilty mind. It is a Latin word which means guilty mind. Do you understand? It is a Latin word which means guilty mind. Okay. So mens rea means guilty mind, whereby if anything is done with intention. Example I'll take. Someone is attacking me. To protect myself, I've taken a rod and hit him. Is it a mens rea or not a mens rea? Tell me. It is mens rea or not mens rea? It is a mens rea or no mens rea? See, if I am doing my self-help, I am protecting myself. I am not done with a wrong intention. So there is no mens rea. There is no mens rea. And there is a guilty act. I know I have done something wrong. There is actus rea, means I have done a wrong act. But is it done with a bad intention or a genuine intention? It is done with a genuine intention. Guys, So now, as per law, there is no crime. But I'm playing knife. I'm catching this knife. There is my enemy going on. I intentionally throw knife on him. There is a guilty act with a guilty mind. There is a guilty act with a guilty mind, which is called as mens rea. Which is called as guilty mind is mens rea and guilty act is actus rea. All these together is called as crime. All these together is called as crime. Do you understand this? So again I'm telling, for any crime, there should be obviously a wrong act, that is actus rea. That is actus rea, which means guilty act. Which means what? There is guilty act followed by mens rea, that is guilty mind. Guilty mind, that will be crime if you have done a wrong act without any wrong intention. Means to protect yourself, you have hidden the person. A drunkard is inside your house and he is making that nuisance in the house. You are pushing him, throwing him. Okay, so you have done a guilty act, but is it with a wrong intention? It is with the right intention, right? So that is not a crime. For any crime, one of the essential element is one of the essential element is mens rea. Are you understanding this? Are you understanding this, friends? Please tell me yes or no. Yes or no. Are you connected? Are you listening? Yes or no? Tell me, tell me, tell me. Yes, fantastic. Okay. So, see, understand here. So, with this, the major topic of tort is done. We are jumping towards company law. Company law is one of the very important topic for you guys because you are obviously going to be the expert into company law when you come to executive level, and you have to have the very base of company law when you come at the executive level. Very clear. So let us understand the Companies Act very well. See, in the whole Companies Act, there are almost 470 sections and 29 chapters and 7 schedules. So what do you mean by sections? Every paragraph given a number and the paragraph is identified by a number. That number is called a section number. And 10-20 sections group in one area, that is one chapter. So, common topic come under one area, that is chapters. And at the end of the act, there are some formats, list, format of balance sheet, list or something, detailed list that is in schedules. That is in schedules. I'll just show you. I'll just go to the Companies Bear Act and I'll show you how this is taking place. Just hold on. So what do you mean by Bear Act? The Bear Act means which is passed in the parliament. That exact drafting is called as a Bear Act. Okay. So I'm opening this Bear Act. And yes, guys, in this Bear Act, if you see, I'll just come to the index. Companies Act 2013. See, common section like incorporation is one under chapter. Okay. Then if I'm talking about prospectus is under chapter 3. Okay. Then basically share capital, chapter number 4. Okay. Shares under one topic, all share related section and one deposits under chapter number 5. This way, total in the Companies Act, there is 470 sections. There is, can you see this? 470 sections. There are 29 chapters and 7 attachments, that is 7 schedules. 7 schedules. Let us proceed. So with this, what is the act applicable to whom? Companies Act, like Partnership Act is applicable to partnership. Companies Act is applicable to companies. So applicability is dealt in section number 1. Always in every act, section 1 is introduction. Like what is the name of the act? The extent is what? Okay. So my point is, what is the title? This act is called as Companies Act. It extends to whole of India. When it will commence? Actually, it commences on 30th August. President Pranab Mukherjee signed it on 29th August and it was effective from 30th August. But they did not introduce the whole Companies Act on the first day. They introduced the whole act in installments. Some sections, 200 sections, then 100 section, then 100 section. So they are telling that section 1, which is introduction, will be applicable from the first day and remaining section will be applicable from the date whichever the government will notify will be applicable. I am repeating again. Section 1 which we are reading is an introduction section which is applicable from the first day itself, that is 30th August 2013, but remaining sections of Companies Act will be applicable from the respective date whichever government notify, whenever government inform, notify. See, this section means section 1 shall come into force at once and the remaining provision shall come into force from the date as the government may notify. Remaining provision will come into force on that date as the government may notify. Government will intimate, inform you. That is called as commencement. And to whom this act applies? All the companies which are registered under 2013 Act. Okay, all the companies which are registered under 2013 Act and the companies which are registered under previous company law. Do you know which is the oldest company? One of the example, there are many companies. Tata Sons Private Limited. It is the oldest company in 1868. It was registered under Companies Act 1866. There are so many Companies Act which are registered under old act and old law. You won't believe. I'll just show you. See, previous company law. What are the all laws? 18 Companies Act 1866, Companies Act 1882, Companies Act 1913, Register of Transfer Company Ordinance 1942, Companies Act 1956, etc. Register of Companies Sikkim Act 1961. All these are previous company law. Getting my point? So some companies were registered. Certain companies were registered under old act like Tata Sons Private Limited is the holding company. Okay. And Tata Sons Private Limited, it was established when? Let me check. Tata Sons Private Limited. Wikipedia. We'll ask Wiki Baba about the answer. Okay. So Wikipedia is giving one answer. Let us see. It was founded in 1868. So tell me, friends. Okay, I'm repeating. Tata Sons Private Limited was incorporated in 1868. So my question to you is, Tata Sons need to fulfill Companies Act 2013 or need not fulfill Companies Act 2013? Tata Sons Private Limited was registered in 1868. So Tata Sons Private Limited need to do or need to comply Companies Act 2013 or need not comply Companies Act 2013. Tell me, friends, in the comment section. Harshit is telling it need to comply. What about others? I'm repeating my question. Tata Sons Private Limited was incorporated in 1868 under the Companies Act 1866. Under the Companies Act 1866, so Tata Sons need to comply with the Companies Act, new Companies Act, or need not comply or fulfill the new Companies Act. What is your answer? Answer is whether the company is registered under new act or Old Companies Act, they all have to comply and fulfill the Companies Act 2013. They all need to comply and fulfill the Companies Act 2013. So Companies Act is applicable to all those companies which are under Companies Act 2013 and previous company law. It is applicable to insurance company which is registered under Insurance Act 1938, banking company which are under Banking Regulation Act 1949, electricity company which is under the Electricity Act 2003, and the companies which are governed by the special act of the parliament like LIC. Okay, and all those body corporate whichever government notify, all these people need to comply and fulfill Companies Act 2013. All these people need to comply and fulfill Companies Act 2013. I'm repeating, Companies Act is need to be applied by those companies which are under Companies Act 2013 and companies old previous company law, insurance company, banking company, electricity company, or company under special act of the parliament, or the companies which are notified by the government. To all these companies, we need to fulfill the companies law. Read this. Please mute yourself, friend. Neha Puri, the screen, maybe internet issue at your end, or you just click on the, speaker view and click on my screen. Okay, so now I'll proceed. So this is about to whom the Companies Act is applicable. Now let us start one by one and one by one all the companies. First is, what do you mean by public company? Public company means which is not private company. Under section 2 subsection 71, let us go to the Bare Act and let us see what is a public company. Come to section 2 subsection 71. Tell me, Reliance Industry is public or private? What do you think? Reliance Industry is public or private? Harshad is telling public. See, what about others? Aditi is telling private. Mahesh is telling private. Okay, understand. Public company means a company which is not private. So let us understand what is private. Certain companies are private, then all others are public. So what is private? We need to understand private, and let us jump to this. The private company, which is section 2 subsection 68. Are you getting this? Public company means a company which is not private. Which is not private. So now understand, public company means a company which is not private. Means, let us understand what is private. Private is defined under section 2 subsection 68. Private is defined under section 2 subsection 68. Private company. Do you understand this? So now what is the meaning of private? I am explaining you. Understand here. See, private means 3 points. Private company means 3 points. The first point is restrict, second point is limit, and third point is prohibit. So what it restrict? Transferability of shares. Can I transfer the shares of Reliance very easily? Just click of a button. Can I sell the shares of Reliance? Yes or no, friends? Yes or no? Tell me. Just click of a button. Can I sell the shares of Reliance? Yes or no? Can I sell the shares of Tata Motor easily? Yes, I can sell these shares. See, do I need to ask Mukesh Ambani? See, I am holding shares in your company. I want to sell it. Please give the permission. Do I need to ask him, or just click of a button and sell the shares? Do I need to ask him, or just click of a button I can sell the shares? That is the point. Tell me. Beta, understand here. Reliance, Tata Motors, every these companies, we can sell the share without asking. Just click the button and you can sell the shares online. Second, private company have only 200 members, not more than 200. Is Reliance is having only 200 members or more than 200 members? Tell me. Reliance is having 200 members or more than 200 members? Tell me. More than 200. And can Reliance invite public? Share, take shares. Can they invite public to subscribe their shares? Yes or no? Can they invite public to subscribe the shares? Yes or no? But a private company cannot invite public to subscribe their shares. They cannot give to the large public. They can only do among family business. 3, 4 people, 10 people who are close friends are running private company. When a public exposure is there, that is a public company. Do you understand? So basically, understand here, if there is restriction on transfer of shares, if you limit the members to 200 and you prohibit public from subscribing to the security, such companies are private. If there is no restriction on transfer of shares, if the limit is more, not limit up to 200, there is no limit, and you can invite public to subscribe the share, that is a public company. See, I'll give you an example also. One more example. See, Sybase, this is one of the software companies. Sybase Software Private Limited. Let us see this. Sybase Software Private Limited. It's a private company. It means that in Sybase Software, if someone is a shareholder, they need to ask the directors to sell the shares, whatever may be. Then only they can sell the shares. Second, there is not more than 200 members. Third, they cannot invite public to take the shares. Okay, this company was started by two Sindhi brothers, and that is Arun Nathani and Deepak Nathani. And it is a private company where public exposure is not allowed. They are doing very well with around 6,600 employees. Are you understanding this? So what is my point? Sybase Software Private Limited is a private company which fulfills the 3 point. What are the 3 point? Restrict, limit, prohibit. Restrict, limit, prohibit. Restriction on transfer of share. You are allowed to sell the share, but with restrictions. Limit the members to 200 and prohibit public from subscribing to the security. Prohibit public from subscribing to the security. But when it comes to Reliance Industry, it is, see, you have also learned private company ends with the word private limited and public company ends with the word limited. So Reliance is ending with the word limited. So Reliance is which company? Public or private? Tell me. Reliance is which company? Public or private? Yes, it is public. Can you transfer the shares easily in Reliance of Reliance? Yes or no? Can you transfer the shares of easily of Reliance? Yes or no? Yes, very clear. Can you limit up to 200? Is the member up to 200? Tell me yes or no. No. And one more thing. One more thing. Can you invite public in Reliance to take the shares? Share. Yes. So Reliance is basically what? See, whenever in the law it is written as prescribed, it means that act is telling refer rules. There is Companies Act, there is company rules. So whenever everything is not written in act, it is not practically possible. Getting my point? So whenever in act there is a word as prescribed, it means that it is telling to refer the rules. Okay. So tell me, to make a private company, how much capital we require, and to make a public company, how much capital we require? Minimum capital. Tell me. To make a private company, how much capital is required, and to make a public company, how much capital is required? Tell me. Harshit is telling to make private we require 2 lakh rupees. See guys, understand. What is the definition telling? Let us go to the Bare Act. Bare Act. Private company means a company having minimum capital as may be prescribed and which by its article restrict, limit and prohibits. Restrict, limits and prohibits. Very clear? So private company means a company having minimum paid up capital as may be prescribed and which by its article. So have a minimum capital as the rules will prescribe. As on this date, the rules has prescribed nothing. You can start private company with 5,000, 10,000 rupees also. Earlier, to make a private company, you will require 1 lakh rupees. You require 1 lakh rupees, which is deleted in 2015. And now you need not require 1 lakh minimum capital. You can make private company with 5,000, 10,000 also. There is no minimum capital. Same with public company. When you come to public company, it is not a private company and has a minimum paid up capital as may be prescribed. But earlier, to make a public company, you require 5 lakh rupees. But now, which is omitted in 2015, you don't require a minimum capital in case of public company. Are you understanding? So guys, my question to you is, Reliance Industry Limited invested money in Sybage Software Private Limited. Okay, they have invested 80% money in private company. And suppose example, now Reliance is holding company, Sybase Software is subsidiary company. Sybase Software will be treated as dash. Option A, private company. Option B, public company. Option C, I don't know. Option D, jingle alone. Tell me. Reliance Industry invested 80% money in Sybase Software Private Limited. Sybase Software Private Limited will be treated as dash. Option A, private. Option B, public. Option C, I don't know. Option D, jingle alone. Yes guys, answer is even though by articles it is private, but if holding is public, then the subsidiary is also assumed to be public. Even though by articles of association, Sybase Software is a private company, but if the holding is public, the godfather is public, then the subsidiary will also be assumed to be public, even though by documents it is private. So Sybase Software will be treated as public company and not private company. Sybase Software will be treated as public company and not private company. Are you getting this? Where it is written, I'll show you. The drafting is in public company definition. See here. Section 2, subsection 71. Section 2, subsection 71. Provided that a company which is subsidiary, a company means which company? Sybase Software. Sybase Software is a subsidiary of a company, means Reliance Industry, which is not private, means Reliance is what? Public. Sybase Software is a subsidiary of Reliance which is not private, shall be deemed to be public for the purpose of this act, even where such subsidiary company continues to be private in its articles. Shall be deemed to be public, shall be deemed to be public for the purpose of this act, even where the subsidiary company, that is Sybase, continues to be private as per the articles of association. Guys, are you understanding? Are you listening to me? Yes or no? So in short, conclusion, if Reliance Industry has invested in Sybase Software Private Limited, then Sybase Software Private Limited will be deemed to be public or deemed to be private. Yes, it is deemed to be public. Very true. Perfect. Perfect, guys. Let us proceed. Now, in case of private company, there is certain further clarification about 200. See, what is a private company which has a minimum capital as may be prescribed and which by its article restrict, limit and prohibit. I'm repeating, private company means a company which has a minimum capital as may be prescribed and which by its article restrict, limit and prohibit. Restrict, limit and what? Prohibit. Do you understand this? So restrict is what? Restriction is on transfer of share. Limit is on the members, that is up to 200, and prohibit the public from invitation. They don't allow the public to invite. The company cannot invite public, come and take a share. Okay. But there is some clarification about 200. Suppose example, I and my wife jointly take the shares of private limited. We are joint shareholders, like people take property, people buy land, building under joint ownership. Okay. So maximum in share, 3 people can jointly take the shares. Okay. So for example, we are taking Cybet Software Private Limited. We are taking share, that is husband and wife. There are joint owners, but for the purpose of this clause, for the purpose of 200 clause, they will be counted as single member. They will be counted as single member. Do you understand this? For the purpose of this clause, they will be counted as a single member in case of 200. See, if example I'm taking, there are 190 members who are single members, means alone they are taking share, and there are 10 couples, that is equal to 20 people who are jointly taken the share. Okay, so really speaking, there are 190 people and 20, there are 210. So, Cybet Software Private Limited, Cybet Software Private Limited need to take or need to convert into public or need not convert into public? Tell me. Cybet Software Private Limited need to convert into public or need not convert into public? Tell me. Yes, answer is need not, because this will is 190 and this is single member 10, that is equal to 200. Okay, so when there are more than one shareholder who are jointly owning a share in the company, whether one share or more share, they will be treated as single member. They will be treated as single member. Let me come to the definition. Let me come to the private definition, and in private definition we'll be discussing. See, understand here. See, limit the number of members to 200, provided that where two or more hold one or more share in a company jointly. Two or more hold one or more share in a company jointly. See, obviously, like MRF is a public company, obviously. MRF, is a one share is equal to 80,000. I cannot buy it, but I and my wife together can buy the share every month, save it and buy the share. Do you understand that? Let me give you example. What is the MRF share price today? Almost 79,000. But if I put 40,000, my wife put 40,000 and we buy one share or we buy 10 shares. Now, is it practically possible? Yes. Now it is practically possible to buy it. So certain shareholders jointly buy the shares and now they are jointly buying the share. Understand? We'll read again. See, provided that where two or more hold one or more share in the company jointly, they shall, for the purposes of this clause, that limit clause, be treated as single member. Be treated as a single member and not two or three members. In a company, maximum joint holding can be done by 3 members. In a company, maximum joint holding can be done by 3 members. But if there is 3 or 2, they are treated as 1 in case of 200 limit. Are you understanding this? There is one more clarification for this. So first is provided that Now it will come provided further that. First it is provided that, now it will come provided further that. So what is this provided further that? See what happens. I'll give you an example. Many company nowadays, instead of giving bonus in the form of cash, they give shares to the employee. So employee who is getting shares, like Cybet Software is having 6,600 employees, and every year the employee 10% employees who are performing better will get the shares of the company, now as a bonus they are getting, when they are getting as an incentive, that is called as ESOPs. So 6,600 employees, out of which 10% employees, that is 660 employee, will get the shares in the form of ESOPs, employee stock option plan. Understand here? So that is the story. Now what is happening here? That is ESOP. Now what is the exact story? Understand very well. Okay. So are they really putting money inside the company, or it is just a bonus to them? Tell me. Are they real investors, or they are just getting the bonus? My question to you is, this 660 employees are getting shares. Are they getting as an investor or as a bonus to them? They are getting as a bonus. So is company really raising capital, or it is not raising the capital? Is company really raising the capital or not raising the capital? Tell me. Not raising the capital. But unnecessary, this Sybase software, if there are 20 owners and they add up this 660, it will become 680. Unnecessary, they have to convert it into public. That is not needed. So law is telling that whether the present employee or the former employee who left the company, who ceased the employment, who left the company whose job is ended, but were the members and are the members of the company during employment, they become members by taking shares during employment, will not be counted. This will not be counted in the limit of 200. If they are counted, it will become difficult for the companies to unnecessarily convert into public and comply with more things. Are you getting this? So employees who are getting shares during employment, whether a present employee or former employee, tell me one thing very clear. If they are getting shares, are they counted in the limit of 200? Yes or no? Answer is no. But if out of 660, 200 employees decide to invest and take the shares, now they will be counted in the limit of 200 as an investor. But as an employee, if they are getting shares, whether they have leave the job, see, Amazon is a highly paying company nowadays, and it is in IT obviously. Amazon gives ESOP. Every employee gets shares in the company. The employee know that even if he leave the job, but he will not leave the shares. The share will grow one day. The 20 lakh share they receive will become 1 crore share. Do you understand this? So my point is that they will never leave the share because they see a future in the company. They may leave the job but not leave the share. Such employees who have left the job and still have the shares, who are in the job and still having the share as employee, will not be counted in the limit of 200. See, read this. Provided further that person who are in employment of the company, present employee, and person who having been formerly in employment of the company, was employed, but were the members of the company while in employment and continue to be the members even after employment ceased, even if they left the job, shall not be included in the number of members. Guys, are you connected? Are you listening? Because I'm going very technical. You have to grow a lot. You have to grow a lot. Are you understanding? Tell me, friends. Yes or no? Very good. So this is the conclusion about C. First, what is the clarification for 200? If there is joint holding, they will be treated as single member, and the employee who are in employment or who were formerly in employment but left the job and were the members while in employment shall not be included in the number of members. This was the private company definition. So guys, private done, public done. What is public? Which is not private and have a minimum paid up capital as prescribed. Is anything prescribed today? No. Private company means which is not public and which has a minimum paid up capital as prescribed. What is private? Means a company having a minimum paid up capital as prescribed and which by its article, three things. Articles, three things. The first thing is limit up to 200, prohibit the public from inviting for the securities, and restrict on the transferability of shares. Restrict on the transferability of shares. These are three things. Are you getting this? Yes or no? Are you getting this? Yes or no? Correct. Now, in case of 200, if there is a joint holding, they will be treated as a single member. And if it is an employee, whether former employee or present employee, they will not be included in the limit. Okay, that is a very clear case. Okay. Now, let us jump to the next definition. Let us come to the next meaning, government company. In those company, which is basically minimum 51% is held by central government, state government or governments, and partly by central government and partly by state government or governments. Such companies in which not less than 51% is held by the government, it is called as a government company. It is called as a government company. Do you understand this? Example, Bharatiya Heavy Electrical Limited. See, government do work in three fashion. Either government make a department which is called as ministry, Ministry of Railway, Ministry of Post and Telegram, Ministry of Foreign Affairs, Ministry of Internal Home Affairs. Getting my point? So that is ministry. Either government pass law and make a body, statutory body. Okay, that is SEBI, RBI, or either government register a company under Companies Act and put money and start doing the work. There are three ways government do the work. The very first type is make a ministry, okay, make pass a law and make a statutory body, RBI, SEBI, ICSI, ICAC, or register a company under Companies Act, invest money in the company and start the work. When the government is investing in a company more than 51%, whether alone or with the other state governments or state government alone, that is company is called as a government company. Very, very clear. See, it may happen that Maharashtra government, Karnataka government, Rajasthan government form a company, put money to make highway and connect the three states. So it is a government company. It may happen that Maharashtra government alone make a company to supply electricity to the people. That is again a government company. Or it may happen that central government and Maharashtra government come together, make a company and make a port. They make a airport. That is again a government company. So it may happen that central government is alone investing. One of the state government is alone investing, more than one of the state government are investing, and central government and one state government, central government and one or more state governments are investing in a company which is not less than 51%, which is called as government company. Section 2 subsection 45. I'll give you example like Hindustan Aeronautics Limited. See this, Hindustan Aerospace Company. This is again a government Indian state-owned aerospace and defense company, headquarters in Bangalore, established in 1940, one of the oldest and the largest aerospace and defense manufacturing in the world today. Okay, so this is there, which majorly money is held by, okay, that is by the government. Same way, if I'm giving an example, that is another example is Bharat Heavy Electricals. Yes. Bharat Heavy Electricals Limited is Indian government-owned engineering and manufacturing enterprise based in New Delhi. Getting my point? So this is Bharat Heavy Electricals Limited, which is there, and it is one of the government company. Getting my point? So what is government company? Let us come to the bare act and understand section 2 subsection 45, whereby what is a government company? Understand here. Government company means a company in which not less than 51% of the PIDA capital is held by central government or by state government or governments, or partly by central and partly by one or more state governments, and includes a subsidiary of the government company also. See, I'll explain. Suppose example, central government invested in Hindustan Aeronautics Limited 80%, and Hindustan Aeronautics Limited invested in Bharat Heavy Electrical Limited 60%. This is holding, this is subsidiary, and this is holding, this is subsidiary. But government companies, okay, not this is not holding, sorry, central government is not holding, but central government is investing in Hindustan Aeronautics Limited 80%. So this is subsidiary, government company. In our language, it is a government company. Subsidiary of the government company will also be treated as government company. Like subsidiary of a public company will be public, even though it is private. So subsidiary of the government company is also treated as government company. Do you understand this? Yes or no? Are you guys listening? Come on, respond. So read this. Government company section 2 subsection 45. Let us proceed there. See, government company means a company in which not less than 51% of the paid-up capital is held by central government, state government or governments, partly by central government and partly by state governments, and includes the subsidiary company of the government company. Very, very clear. Now, what is a foreign company? Those company which is not registered under Companies Act 2013 but registered under some other law in other country, but they are doing business in India. Amazon, they are not registered. Amazon stock market is, Amazon shares is available in NSE, national, not NSE, sorry, in the New York Stock Exchange. Okay, but Amazon is doing business in India. Whether they do business through themselves, they put their own outlet, or they do business through franchisee agent like McDonald's. McDonald's may open their own outlet, company's outlet, or McDonald's may appoint a franchisee who are running it. Okay, whether they are doing business on their own or whether they are basically what, whether they are doing business own or whether through agent, whether they are doing business physical mode or electronic mode, they are doing business in any other manner, but their registration is done outside India. They are not incorporated in India, they are incorporated outside India, is called as a foreign company under section 2 subsection 42. is called as a foreign company under section 2 subsection 42. So those company or a body corporate which is incorporated outside India, which is registered outside India, but which has a place of business in India, whether they are doing business on their own or through agent, whether they are doing business physically or online mode, and they do business in any other manner, is called as foreign company. Is called as foreign company. Do you understand this? Yes or no? Let us see section number 2 subsection 42 foreign company in the Bear Act. See, foreign company means a company or a body corporate incorporated outside India, which has a place of business in India, whether by itself or through agent, whether physically or electronic mode, and conduct business activity in any other manner, is called as foreign company. Foreign company means a company or a body corporate which is registered outside India, which has a place of business in India, whether through itself or through agent, whether electronic mode or physical mode, conduct business in any other manner, is called as a foreign company. So this, let us proceed. Government company done, foreign company done. Section 8 company. See, in India, you can do charity in 3 types of organization. The first type is basically trust. Second type is cooperative society. And third type is Section 8 company. And nowadays, Section 8 company is becoming popular. Understand here. See, if you want to do business, then there are different types. If you want to do business and if you want to do charity. Okay. If you want to do business, there is corporate type to do business and there is non-corporate type. Corporate type has 2 types, company and LLP. And non-corporate have sole proprietorship, partnership and HUF. Sole proprietorship, partnership and HUF. But in charity is done in 3 types. That is basically trust. Okay. Section 8 company. Trust. Section 8 company. And if I'm talking about the same way, that is society. So what you want to do? Charity, there are 3 types. Business, there are 5 types. Are you understanding? If you're not understanding my writing, I'll repeat here. Just look up. See, if you want to do business, first type is sole proprietorship. Second is partnership. Third is Hindu undivided family. Fourth is company form. And fifth is LLP. If you want to do charity, the first is trust. Second is society. And third is Section 8 company. Are you understanding? So these are the way. When you are doing charity, Section 8 company is the best. Section 8 company never use the word limited or private limited. They generally use the word foundation, federation, council, electoral trust. One of the best example would be, for your easy understanding, is Reliance Foundation, your Tata Steel Foundation. Okay, all these are Section 8 company which are focusing on charity. Every time you need not make money, sometime you have to do for the society. Can you see this Reliance Foundation? The founder chairperson is Nita Ambani. See, they are providing meals for those who are below the poverty line. They are providing mask. See this, free of cost COVID. They are providing ICU, setting up intensive care treatment. They are providing you with vaccinations. Okay, free vaccination, providing oxygen free of cost. So same way, they are providing lot many things, mobile medical unit. Okay, they are doing a lot of things for you guys, for the society. Like not only Reliance, Tata is also the biggest known name for doing charity always. Okay. So when they want to do charity, they contribute to a Section 8 company. There is Reliance Foundation or Reliance Industry. Everyone will give donation to Section 8 company, and this will focus on charity. You cannot mix two things, doing business also and doing charity also. Like in Companies Act, certain company have to compulsorily do charity. So for example, Tata Motor have to do charity of around suppose 20 crore. Then Tata Steel have to do charity of around 30 crore. Tata Consultancy Services have to do charity 15 crore. Let us make a Section 8 company and let us donate all the amount here. Let us this focus on charity and let us this focus on the business part. The such companies will be called as Section 8 companies. Do you understand this? So Section 8 companies do not distribute dividend, do not distribute any dividend to the members, and if any profit earned by them, they will apply for the charity and the object. They will never distribute dividend among them. Sir, how they will earn profit? If they are doing charity, they are not doing any business, how they will earn profit? Suppose example, say this Tata, yeah, Reliance Foundation got 100 crore. They don't require 100 crore today. They put in FD 20 crore. On this FD, they earn interest. This interest they will apply for object. Suppose they have a 1 acre land and some 20,000 square feet is not usable. Now they use only 80,000 square feet. So they have given on rent. This rent is a profit. They will apply for the object. If they earn by chance, if they earn by chance, they will apply for the object of the company. That is called as Section 8 company. Understand here. So let me come to this Section 8 company. Let us come to the Bare Act and understand Section 8 company. See, Section 8 company has the object of promotion of commerce, art, science, sports, education, research, social welfare, religion, charity, protection of environment, and such other objects. Intends to apply the profit, if any, for the object and prohibit the payment of dividend. Prohibit the payment of dividend. These 3 points are there. Again, I am repeating: promotion of commerce, art, science, sports, education, research, social welfare, religion, charity, protection of environment. Profit, if any, intends to apply in promoting the object and prohibit the payment of dividend. All these are Section 8 companies. Very, very clear. Read this. Okay. Is it clear with everyone? Please, are you understanding? Please connect. Please tell me. Are you understanding, guys? See, I cannot take a break and I need to keep on doing. Break means I need to talk. I cannot interact with you guys now because I have to cover up so many things. Do you understand? So let us come to this again. Section 8. Now let us come to the further types. What is a small company? See, small company means, see what happened in Companies Act. They understood certain business are very, very small, but they are trying to grow, but they have not grown that much. Let us give them some privileges and benefits and let us discount them certain formalities. So Companies Act is telling that first thing, never a public company declare as a small company. Public company, can Reliance be a kacha limbu? Can Tata be a kacha limbu? No. So public company cannot declare themselves as small company, but other than public company means private. Those private company where the capital does not exceed 50 lakh and the turnover does not exceed 2 crore, such companies are basically what? Small company. The capital investment in the company does not exceed 50 lakh and the turnover does not exceed 2 crore, such capital has been basically what said to be a small company. Understand here. I'll give you an example. Small company means other than public, company where the paid up capital does not exceed 50 lakh. This limit is being changed, okay, and turnover does not exceed 2 crore rupees, then such company will be called as small company. Can the government prescribe the higher limit? Yes, they can prescribe the higher limit. They have changed the limit. 50 lakh they have made 2 crore, and 2 crore they have made 20 crore, and now these companies are small company. Till what amount they can change? This 50 lakh they can make up to 10 crore, and 2 crore they can make up to 100 crore, but now presently they have changed to 2 crore and 20 crore. Okay, so small company means a company which is basically having a paid up capital up to 50 lakh, which is changed to 2 crore, and does not exceed basically what? 2 crore, which is up to rupees, okay, now exceeded to 20 crore. Such companies will be called as small companies, and now certain more companies cannot apply for small company. Section 8. Already section 8 is given more privileges as compared to small company. Section is given 20 privileges, small is getting 5 privileges. So why to do double formality? Already they are more benefited, so need not apply for small company. Those company under a special act of the parliament like LIC, does it look good where we called Lok Sabha, Rajya Sabha made a company and now that company is a small company. So those body corporate which is under the special act cannot apply for small company, and those company which are either holding or subsidiary. See, one is holding and he's telling I'm small. How can you be small? You are investor. One is subsidiary, he's telling small. How can you small? There is a godfather on you. So holding subsidiary cannot apply for small company. That is all written in basically, let me show you, section 2, subsection 85. See, small company means a company other than public where the paid up capital does not exceed 50 lakh, which is not updated, and turnover does not exceed 2 crore. Okay, and provided that nothing in this clause shall apply to holding subsidiary registered under section 8 companies and body corporate under the special act of the parliament. Read this. Okay. So now let us proceed. Did you any query till now? I'll wait for your queries. Small company done, section 8 company done, public done, private done. Okay, government company done, foreign company done. Guys, are you getting it? This is your basics. Please respond. Are you listening to me? You have to make the efforts. Come on. You have to take a lot of efforts and grow. Then only everything is possible. Okay. So this is about small company. This is about your small company. Let us proceed further. Let us proceed further. Let us see more things and more discussions are to be done. Wait, hold on. Elements of company law. Okay. In elements of company law, applicability. What is the title? Companies Act. Extent whole of India. Applicable insurance company, banking company, etc. Okay. Next is types of companies. Chartered company means under the king and the queen permission. Those company under the king and queen permission is called as chartered company. But nowadays king queen permission is not there. It is government permission. Registered in the Companies Act. So earlier it was king queen permission, which is called as chartered companies. The best example would be East India Company. Statutory companies which is established under the special act of the parliament. Statutory companies which is established under the special act of the parliament, and registered company means under Companies Act 2013. So chartered company means king queen permission. Statutory company means special act. You have established under the special act, and registered company means under Companies Act 2013. Okay, very clear. Then private you have done, public you have done. OPC. Nowadays the law wants small businessmen also to take the benefit. So a single member now also can make a company and do business, that is OPC, one person company, under section 2 subsection 62. Let us come to the OPC part. Under section 2 subsection 62, that is OPC. Check this. OPC means a company which has only one person as the member. OPC means a company which has only one person as the member under section 2 subsection 62. Are you understanding this? Yes or no? Yes or no? That is OPC. Yes or no? Correct. Then we have done small company. Okay. We have to do holding subsidiary associate. Section 8 is done. Okay. Government company is done. Foreign company is done. See, private done. Detail is given here. Public is done. Let us see this. Then we come to OPC. Then we have come to charitable companies, government companies, okay, foreign company. Now we come to associate, holding, subsidiary, small company done, okay, small company done, dormant company will do, needy company will do. Understand? See, first thing. Now I'll give you a chart, and through that chart we'll understand three concepts. What are the three concepts? The first concept is holding, subsidiary, and okay. Yes, obviously, sole proprietorship. See, there is a separate legal entity in OPC, and there is no separate legal entity in case of sole proprietorship. I'll give an example. I opened OPC and started a restaurant. Restaurant has taken a loan of 2 crore. If restaurant does not pay 2 crore, Mayur Agarwal liable or not liable? I opened OPC, okay, and through that OPC private company, I have taken a loan of 2 crore. I have not taken, that company has taken. If restaurant does not pay the loan, can they recover from my personal asset? Yes or no? Kirtana will answer. Can they recover from my personal asset? Yes or no? Answer is no. But guys, if I open a sole proprietorship and open a restaurant, and that sole proprietor firm has taken a loan, and the restaurant does not pay the loan, then can they recover from my personal asset now? Yes. So that is a major difference between sole proprietorship and OPC. Just see this chart. Just hold on and just see this chart. See this chart. I'll just zoom it for 1 minute. Yes, guys. Have you seen this chart? I'll tell you what is happening in this. There is Tata Sons. Tata Sons have invested 28% shares in Tata Motors, and Tata Motor has invested 100% shares in Jaguar Land Rover. See, when one company is having significant influence in another company, when one company is having significant influence, major influence. Sir, when will one have significant influence, major influence? When one is holding more than 20% shares. When one is holding more than 20% share, such companies which are having significant influence is basically we can tell that is associate company. But if one is holding more than 50% shares, like Tata Motor is holding 100% shares in Jaguar Land Rover. So basically, such companies holding more than 50% shares will be called as subsidiary company, and the person holding it or the person having subsidiary company will be called as holding company. Let us take an example. Tata Sons investing in Tata Realty. Tata Realty is dash of Tata Sons. Tell me. Tata Realty is dash of Tata Sons. Yes, it is a subsidiary, and Tata Sons is holding. Same way, Tata Sons invested in Titan 25% shares. Tata is invested 25% share. What is the relation between Tata Sons and Titan? Associate company. Very true. So 20 to 50% share associate, above 50% share, above 50% share is basically the holding company. Above 50% share is basically the holding company. Very, very clear. Now, example, suppose example if I take Tata Sons invested in TCS 73% and TCS invested in CMC 100%. Tata Sons invested in TCS 73% and TCS invested in CMC 100%. What is the relation between Tata Sons and TCS? What is the relation between Tata Sons and TCS? That is holding and subsidiary. And what is the relation between TCS and CMC is holding and subsidiary. But what is the relation between Tata Sons and CMC? What is the relation between Tata Sons and CMC? Yes, whether you are holding share through yourself directly or through your one of the subsidiary. Your holding share through directly or through your subsidiary is also holding and subsidiary. Are you getting this? Is also holding and subsidiary. Example, Reliance Industry Limited invested in Reliance Natural Resources Limited is 80% share, and in Reliance Jio they invested 30% share and natural resources invested 30. Now you are investing more than 50% either on your own or together with your RNRL. So that will be called as subsidiary company and this will be called as holding company. Getting my point? So basically in the Companies Act they will use the word either subsidiary or they will either use the word subsidiary company. they will use the word either subsidiary or they will use the word either subsidiary company. It is one and the same. Understand here. So whether it is you are using the word subsidiary or you are using the word subsidiary company, it is one and the same. I'll just show you. That is section number 2, subsection 87. Subsidiary company or subsidiary. Can you understand subsidiary by studying one company or you compare it with other companies? Can you understand subsidiary by studying one company or you compare it with other companies? Tell me. Can you understand subsidiary by comparing itself or you compare it with other company? You have to compare with other company in relation to another company. In relation to another company, as per our example, in relation to another company, compare the TCS as compared to Tata Sons. That Tata Sons will be called as holding. That Tata Sons will be called as holding. That is to say holding company. That is to say holding company. Compare with the other company. That other company will be called as holding. Means a company in which means a company means TCS, in which other company Tata Sons is doing what? Controlling the composition of board of directors. They are controlling the board of directors and they are controlling half of the total share either on its own or through its subsidiaries. One and the same. I am repeating again. Subsidiary company or subsidiary in relation to other company, that is to say holding company, means a company in which the other company control the composition of board of directors or exercises or control more than half of the shares either on its own or together with one or more subsidiary. Do you understand this? It's just the language. See this chart. Are you listening? Come on, friends. Are you listening? Yes or no? Yes. Very good. Subsidiary company or subsidiary in comparison with one or more company means a company in which the holding company, what it does, control the composition of board of director, exercises control more than half of the total voting power either on its own or together with one or more subsidiary. I'll just zoom this slide. Just see it for once. Okay. Now let us come to associate. Now let us come to associate. Means a company which is having a significant influence and but which is not subsidiary. Having influence but not that much influence that it becomes subsidiary. Means a company which is having influence but not that much influence that it becomes subsidiary and includes a joint venture company also. Like what is significant influence means at least 20% of the voting power or control or participation in business decision. 20% of the voting power or control or participation in the business decision, then there is significant influence. Let us discuss this. See, associate company. Section 2, subsection 6. Associate company, section 2, subsection 6. Associate company in relation to another company means a company in which the other company has what has it? Significant influence, but which is not subsidiary having such influence, and includes a joint venture company also, and include a joint. What is significant influence? At least 20% of the voting power or business decision. Very clear. And what is holding? Section 2, subsection 46. See, subsidiary 87. Section 2, subsection 87, subsidiary. Section 2, subsection 6, associate. And section 2, subsection 46 is holding company. Section 2, subsection 46 is which company? That is holding company in relation to one or more company. Compare with other company means a company of which such companies are subsidiary. If the company is having subsidiary company, then the company which is having subsidiary company will be called as holding company. In compare with other companies, such companies are subsidiary, means this company is holding. That is section 2, subsection 46. Do you understand this? Yes or no, friends? Section 2, subsection 46, in relation to one or more companies means a company of which such companies are basically subsidiary company. Read this. Okay, so guys, with this we are done with what? Subsidiary company, we are done with what? Associate company, and we are done with what? Holding company. Subsidiary company or subsidiary in relation to other company, that is holding company, means a company in which the holding company control the directors and control half of the share capital. Subsidiary company. Holding company means in comparison to the other company of which such companies are subsidiary. Those company having subsidiary will be called as holding. And associate company means in relation to the other company which has a significant influence, but not that much influence which it becomes subsidiary. Significant influence means at least 20% of the voting power. At least 20% of the voting power. Now let us come to dormant company. Now let us come to dormant company. What is dormant company? Let us understand dormant company in detail. Okay. Those companies, see many times what happened, like one of my clients, okay, they had 4 crore rupees. Both the partner 2 crore, 2 crore, they made a company, put 4 crore, purchase a land, but they don't have money for construction. They will be starting construction after 3 years after accumulating some more money. So now they have made a money. They have put into a company. The company purchased a land and now nothing is going on. Now some friends want to do business in the future. So now only they are doing the paperwork so that after 2 years they start a business. Or a friend who want to, he have invented, he got a patent. He invented a technology. He got a patent. Now he registered a company, registered a patent in the name of the company, and now he's searching for the investor who will invest into his technology. That will require time. Such people who have formed a company, such people who have registered a company for future, such people have registered a company to hold intellectual property. Such people who have registered a company to hold asset, but there is no significant accounting transaction, no major accounting transaction, no movement, no commercialization, no business. Such companies can apply to get themselves registered as dormant or inactive company. Such company can themselves register for dormant or inactive company. For how many years this company can be inactive? Any idea? For how many years this company can be inactive? Can you put or guess something? It is for 5 years, not more than 5 years. You can enjoy the dormant status. So, what is the benefit of getting dormant? There are little bit of exemptions. Instead of 4 board meetings, hold 2 board meetings. There are other benefits. So, such companies which is for future project, such company which is just holding asset and holding intellectual property, and there is no significant accounting transaction, such companies which are formed and registered will be called as dormant company. Very, very clear. So dormant company means not having any SAT, significant accounting transaction. What is SAT? See, if this 4 is happening, if this 4 transaction is happening, it is not SAT. But other than these 4, that is a SAT. Example, if you are paying ROC fees, you do business or you don't do business. You have to pay ROC fees. It is not SAT. If you are allotting share, you need to accumulate money. That is very common. Then only you start business. By allotting share and collecting money, did you start any business? No. You are doing fulfillment of law, auditor fees. You have to do it whether you start business or don't start business, or you are maintaining an office, keeping records. For that you are expending something, that is you have to do. All these 4 are not SAT, except the 4 other things are SAT, significant accounting transaction. All these 4 are not SAT, except the 4 are SAT, which is called as significant accounting transaction. Do you understand this? Yes or no? Are yes or no? Yes or no, friends? So all these 4 are not SAT. What are the 4? Payment of fees to ROC is not SAT. Allotment of share is not SAT. Payment made to fulfill the requirement of law is not SAT. Maintenance of office and record is not SAT. Okay. If I purchase raw material, SAT. If I do marketing, SAT. If I start selling goods, SAT. Okay, so these 4 is nothing but just accounting transaction, and other than these 4 are significant accounting transaction. What is needy company? Needy company is under section 406 of Companies Act. 406 of Companies Act, that is a needy company. Let me discuss this. 406 of Companies Act. 406. Are you listening? See, needy company accept deposit from members and lend to members also. Needy company accept deposit from members and lend to members. Then what is the difference between needy company and a bank? Needy company take deposits and lend money. Take deposits and lend money. Take deposit at 5%, lend at 8%. Take deposit at 4%, lend at 10%. That is their business. But what is the difference between needy company and banking company? Tell me. Yes, Harshit, right? It deals with member only. Example, it will take deposit from member only and give to member only. It provide loan to member only. Believe me, people did not trust the banking system earlier, and therefore they were feared. See, but if you known people come together and form a needy company, you develop among yourself the habit of saving. Everyone contribute to the needy company, and the person who is in need of money will be given loan. Now he will be under a peer pressure to pay the loan on time. But to become to lend money from to borrow from HDFC Bank, do you need to buy the shares of HDFC Bank? Yes or no? To buy the shares or to take loan from HDFC Bank, do you need to buy the shares of HDFC Bank? Yes or no? Answer is no. But to become you to lend money from needy company and to deposit, you have to first buy the shares of needy company. One of the example is very common example which I give in every class is Pune Multi Nidhi Limited. See this Pune Multi Nidhi Limited. Okay, this is one of the needy company, Pune Nidhi Limited or Pune Multi Nidhi Limited, which is into the accepting deposit from member only, and see, so it is a mutual benefit company. We are for the member, by the member, of the member. We don't deal with non-members. We only deal with members, which is called as needy company under section 406. Under section 406, which is a needy company. Do you understand this? So let us see this, understand here. What is a needy company? Needy company means a company which is registered as needy and with the object of cultivating the habit of thrift, cost cutting and saving amongst the member, receiving deposits and lending to members only for the mutual benefit and which comply with the rules provided by the government. Central government has provided needy rules 2014. Central government has provided needy rules 2014. I'll show you needy rules 2014, which needy company, see needy rules. Okay, 2014. They need to comply with the government rules, and they are also called as mutual benefit company, social benefit company, and this is happening, which is under section 406, which is under section 406. Very, very clear. Read this. Okay, let us proceed. So this was about your needy company. Okay, so we are done. Now let us see what are the types left. Okay, dormant company, yes. Small company, yes. Subsidiary, holding, associate company, foreign company, government company, charitable company, public company, private company. Understanding this? Yes. Now, what is company limited by shares and limited by guarantee? Very simple. Understand. My question to you is, if shareholder invest money, so what is his liability towards company? One is no liability, no liability. Second is limited liability, and third is unlimited liability. What do you think? Generally, what is the story? He is not liable at all. He is liable up to a certain amount and he is liable completely. Shareholders' responsibility towards the company is dash. Is no liability, limited liability and unlimited liability. Yes, friends, he is having a limited liability. But how a shareholder will come to know what is his liability? Whether he is having limited liability or unlimited liability, from where he will come to know what is his liability? Which document will help you to tell you what is the liability of the member? Can you tell me? Which document will tell you which is the liability of the member? Yes, Harshit, very true, perfect. That is memorandum. That is the memorandum of association. Very, very clear. So that is the memorandum of association. Memorandum of association will tell you what is the liability. This is limited by share, and there they will put in the liability clause. When I'm coming down, I see a liability clause, and the liability of the member is limited. So what is your liability, whether limited or unlimited, will be mentioned in memorandum of association. One of the very important document which talks about your responsibility towards the company. So suppose Reliance do not pay 10,000 crore loan and I am one of the shareholder. Can the state bank come and sell my property and recover the loan? Yes or no? Can they sell my personal property and recover the loan? Yes or no? Answer is no. Very, very clear. They cannot sell my property and recover the loan. Answer is no. Very, very clear. So that is the first thing. Okay. The liability is limited and now they can only recover what I promised to pay on the share. Suppose I said I will take 1000 rupees 20 share, I will give 20,000. I have given only 5,000. Pending is 15,000. They can recover only 15,000 which is unpaid on the shares. They cannot recover extra 1 rupee single extra from me, only recover 15,000 which is called as limited liability. Which is called as limited liability. Do you understand this? Yes or no, friends? Which is called as limited liability, which is clearly mentioned in the memorandum. Which is clearly mentioned in the memorandum. Okay. So if I have paid the money 20,000 rupees share, I have already paid 20,000. Can they recover anything from me? No. If not paid, then they will recover. That companies where member liability is limited, those companies where members liability is limited, how much limited? Up to the amount unpaid on the share, not paid on the shares. Up to the amount unpaid on the shares, not paid on the shares, that is called as limited by shares. Just hold on, I'll show you. Yes, see this. Section 2, subsection 22, company limited by share. It means a company having the, it means a company having the liability of the member limited. How much and who is telling this? The liability is limited by the memorandum. And how much amount they are telling? To the amount if any unpaid on the shares held by them. To the amount if any unpaid on the shares held by them, that will be called as limited by shares. To the amount unpaid on the shares held by them will be called as limited by shares. Very, very clear. Read this. See, what is the member liability? Limited or unlimited? Limited. Who is telling memorandum? How much is? If any amount which is not paid on shares, unpaid on the share, they have to pay that much only. That is called as limited by share. But unlimited company can also take place. Member is ready to take the whole responsibility. This is not popular. The popular is limited by share. So those company where members liability extend to the whole liability of the company, he will contribute, he will sell his personal asset and pay all the liabilities of the company That is unlimited company, section number 2, subsection 92. Section number 2, subsection 92. If I'm coming here, unlimited company means a company not having any limit on the liability of the member. Unlimited company means a company not having any limit on the liabilities of the member. Very, very clear. Okay, very clear. Are you understanding this? Yes. So, if there is a limit, and what is the limit? Up to the share money, limited by share. If there is no limit and you are completely liable, unlimited company. And there is one more company, section 2, subsection 21, limited by guarantee. Section 2, subsection 21, limited by guarantee. I'll give you an example for this. You will understand it better. Example, Ramdev Baba and his partner incorporated a company, and under that company they are researching a cancer medicine. Ramdev Baba and his partner has invested 1000 crore. Ramdev Baba and his partner has invested 1000 crore and they are researching, and they require more 2000 crore. They approach a bank. Bank is telling that if the research is not successful, how will you pay money? Our money is at a threat. Ramdev Baba is sure that they will get the medicine. Ramdev Baba is telling that, see, 1000 crore I have invested and I guarantee 1000 crore more. If company need to be shut down, I will pay more 1000 crore as a guarantee amount. If company is not able to pay your money, I will personally pay 1000 crore. We both will personally pay 1000 crore. So Ramdev Baba has taken two commitments. One, to pay the share money, and second is the guarantee amount. And the guarantee amount can be recovered only on winding up liquidation, only when the company need to shut down. And the day company shut down and banker do not get their money, they will personally pay the guarantee amount 1000 crore. Now banker is confident. See, Ramdev Baba invested 1000 crore. Ramdev Baba and his partner are ready to give guarantee of 1000 crore. So now they are ready to give 2000 crore and take the risk. So when what is happening, member liability is limited. Who is telling limited? Memorandum. How much? Up to the amount they contribute in the event of winding up. They are ready to contribute in the event of winding up. Such is called as limited by guarantee. Read this. Company limited by guarantee means a company having the liability limited to the memorandum to the amount which members respectively undertake to the contribute to the assets in the event of being wound up. If the company is wound up, they are ready to contribute extra amount, some fixed amount, that is called as limited by guarantee. Read this. Okay. Okay, so this is done with the types of company. So now we are talking about what is a company. Company is derived from Latin word. Let us come to the basics of company. Company is derived from which word? Latin word. Come means all come together, and pani means to spread and have a common object. All people coming together for a common object. What is a common object? To earn profit. So when the people have a company of each other, they all come together with a common objective, that is called as company. That is called as company. Let us understand this. So basically, it is a Latin word. The word company is derived from Latin word come, means to come together, and pani means to have a bread, and it is originally referred to association of a person who come together to take a meal. Everyone should come together to take a meal. Now the company word is come together to make profit. That is a company. Very, very clear. And what does Companies Act define company as? Let me take to the Bare Act. And the Companies Act, section number 2, subsection 20 means whenever in the act the word company means all those companies which are registered under this act. What do you mean by this act? This act means Companies Act 2013 or previous company law. Previous company law means Companies Act 1866, Companies Act 1882, Companies Act 1912, Companies Act 1942, Companies Act 1956. Those registered under this act, those incorporated under this act, those registered in the previous company law, those incorporated under previous company law, all that is a company. All that is a company. So what is a company? Company means a company incorporated under this act or previous company law. Section 2, subsection 20. So all that, whether Tata Sons, whether incorporated old act, whether Reliance Industry under 1956 act, whether Mako Private Limited under 2013 act, all those registered under old act or new act will be called as company. Do you understand this? Are you understanding this? Yes or no, friends? Tell me, are you understanding this? Are you understanding this? So company means all the company under this act or previous company law. The company word is derived from the Latin word where people used to come together and have meal together. That is a company. Very, very clear. Now in a company, there are various applicability we have done. Okay. We have done about the applicability. Question to you is, in a partnership firm, I am asking a question. Understand? In a partnership firm, minimum we require two people. Minimum we require two. What is the maximum we require? What is the maximum we require? Tell me. In a partnership firm, minimum we require two. What is the maximum we require? What is the maximum we require? What is the maximum allowed? See guys, Partnership Act is silent. Partnership Act is not telling, but Companies Act is telling that under section Companies Act 400 and Companies Act 2013, that is section 464, is telling that those association and those partnership which is exceeding the limit as prescribed, which is exceeding a limit as prescribed, but the government cannot prescribe more than 100, should register themselves as a company. If a partnership is exceeding a limit as prescribed, who will prescribe? Rules will prescribe. Like we said, public company means a company which is not private and which has a minimum capital as prescribed. Whenever it is written as prescribed, who is prescribing? Act is prescribing or rules are prescribing? Tell me, friends. Act is prescribing or rules are prescribing? Act is prescribing or rules are prescribing? Whenever the word as prescribed is written, tell me what exactly is the status? Yes, whenever in the act it is written as prescribed, it means refer rules. So can the section 464 is telling limit as prescribed, limit will be set by rules as prescribed, but rules cannot prescribe more than 100. Rules can set up to 100. This is the maximum. So basically rules has prescribed up to 50. So in short, they can prescribe 60, they can prescribe 70, 80, 90, up to 100. As on this date, what is prescribed 50? Whenever in a partnership, if there are more than 50 partner, or whenever in an association there are more than 50 people that need to convert into company, and if it is not converted into company, then it is illegal association. Court will not help you. Then that is illegal association. Court will not help you. Are you understanding this? So I am repeating again. Understand here. What is my point? The first thing is, whenever it is more than 50, whether it is a partnership or whether it is association, whether it is a partnership or it is association, convert into company, and if you don't convert to company, then it is illegal association. Understand? So understand here, what is section 464? 464 is telling that partnership, firm or association of person, if exceeds limit as prescribed, but they cannot prescribe, they have set a limit on the rules, they are not prescribe more than 100, so guys, what are the which rules? It is company miscellaneous rules. Companies miscellaneous rules have prescribed up to 15, but there are exceptions. There are exceptions to whom this does not apply. Exception is HUF. If there is more than 200 people in HUF, joint family, do they need to convert into company or they are exempt? Tell me. If there are more than 200 people in HUF, Hindu undivided family, 10 sons, 10 sons, getting up, then they are 4 sons. If there are 200 people in HUF, do they need to convert into company or they are exempt from converting? They need not convert, they are exempt, and the body which is having professional people. See, like ICAI, ICSI have 1 lakh member, 2 lakh member, 50,000 member. Understand? Example. Do they need to convert into company? No, they can continue as a professional body. Association of person who are professionals. So they need not convert into company. So basically section 464, whether it is a partnership or a group of people, association of person, they have exceed 50, convert into company. Can the rules prescribe more than 50? Can they prescribe up to 100? Yes. But as on this date, what they have prescribed? They have prescribed up to 50. Very, very clear, guys. So understand here, section 464. As per section 464, no association or a partnership consisting more than such numbers as may be prescribed shall form for the purpose of carrying on business by association or individual unless it is registered as a company. Now, the maximum they can prescribe is 100, but rule 10 of company miscellaneous rule prescribe is 50. Section 464 does not apply to HUF and association under a special act by the professionals. Are you understanding this? Are you getting this, friends? I am repeating again if you're not getting it. Okay, I'm repeating it. See, what is the concept? If certain association is having more than the numbers as may be prescribed by rules, what is the number prescribed by rules? Tell me. What is the number prescribed by rules? What is the number prescribed by rules? Tell me, friends. Yes, Neha N, correct. That is basically 50. But act is limiting how much maximum the rules can prescribe up to. Maximum the rules can prescribe up to what? 100. But what are the rules? Which rules is prescribing? Rule 10 of company miscellaneous rules has prescribed how much? 50. Rule 10 of company miscellaneous rules have prescribed how much? 50. But this 464 is not applicable to HUF. They need not convert into company. And those association by professionals, they need not convert into company. They can continue as it is. Other need to convert into company. Section 464 is completely done. Do you understand this? Yes or no? Now proceed. Let us proceed. Now, what is the requirement to make a company? Just hold on, I'm opening one of the slide. See, formation of a company. To make a company, we require how many people in public company, how many people in private, and how many people in OPC. How many minimum people require in public? This you have studied in 11th 12th also. Tell me. We require how much? How many members in public, private, and OPC? We require 7 members for public, 2 for private, and 1 for OPC. In Companies Act, where this is written, in Companies Act, where it is written in section number 3. It is written in section number 3 to form a company. To form a company, it is written in section number 3 to form a company. Under section number 3, we will come down to this. Section number 3, 7 or more to form a public company, 2 or more to form a private company, and 1 person when the company is OPC. We require 7, section 3 to form a company, 7 or more for public, 2 or more for private, and 1 for OPC. Sir, how they become member? They sign. See, company is not into picture now. Company is being made. So they promise to take the shares. They sign the memorandum and they sign the articles. They subscribe the memorandum that once the company is formed, we'll take shares. We are ready. We commit to take the share. They sign the memorandum and the articles, and they become subscribers to the memorandum articles, and they promise that they will take share. By this method they become the members. Are you able to get this? So as per section number 3, if you see this section number 3, when to form a public company you require 7 or more, to form a private company you require 2 or more, and to form OPC you require 1 person. Okay, and how they become member? By subscribing their name or his name, their names or his name, plural singular, for OPC it is his name, to the memorandum and complying with the requirement of the registration. Let me show you the memorandum. Let me show you the memorandum. See, memorandum is one of the important document. So see this. This is a memorandum. This is memorandum of association. When you see at the end they sign. See, this is one of the examples. Jaswinder Singh 1667 share, Mahendra Kumar Soni 1667 share, Parag Anand 1666 share, Rahul Bamri and Priya. These are the share they promise and they sign that they will take the share by subscribing their name or his name to the memorandum and complying with the requirement of registration. They form the company. So as per section 3, if I'm talking about as per section 3, 7 or more for public company, 2 or more for private company, and 1 person for OPC. That is very clear. And whatever company you form under section 3.1, 3.2 is telling that 3.2 is telling that you will either make either make that private company or public company or OPC as limited by share or limited by guarantee or unlimited company. The picture is speaking louder than words. Limited by share. How much share amount you take, you cannot ask more than this. Limited by guarantee. How much guarantee I've promised I will give on winding up. And unlimited company, I will give everything. I will give everything. So under section 3.1, when you make a public company, you require 7 or more When you make a private company, you require two or more, and when you make OPC, maximum one, minimum one. And whatever company you form under 3.1, under 3.2, it will be limited by shares, limited by guarantee, or unlimited company. Are you understand this? Check this. Are you guys listening? Are you understanding? Yes, very good. Okay. So 3.1 is telling that to form a public company, you require 7 or more. To form a private company, you require 2 or more. And for OPC 1, and whatever company you make under 3.1, 3.2 is telling that it may be either limited by share, limited by guarantee, or unlimited company. So this was about formation of company, very, very clearly explained to you. Now let us come to some characteristics and certain characteristics of a company. Very clear. Understand here. So one of the very important landmark cases, Salomon versus Salomon and Company Limited. What happened in Salomon and Salomon? Salomon was a boot manufacturer. He was doing a sole proprietary business. He sold his sole proprietary business to a company formed by him. He sold. See, one day everyone will grow. One day everyone will grow. They will expand their business. And what will happen? Understand here. They will make OPC, then they'll make private, they'll make public. We want to grow in life, right? They will make sole proprietor, they'll make partnership. They keep on growing. So sole proprietorship, I have a business, I want to expand my business. I made a company, sold my whole business to the company, sold my whole business to the company. And now what is happening? Understand here. Now company is being registered. I have in return getting 20,000 pound shares in the company, 10,000 pound debentures in the company, and some cash of 8,700 and 8,000 pound in the company. So basically, I'm getting 20,000 pound shares, 10,000 pound basically debentures, and roughly the cash of 8,000. Roughly, I'm getting almost 38,000 something in return. So what I've got? I've got shares, I've got secured debentures, and I've got cash. And what I did, I appointed my wife, suppose Salomon, I'm talking about Salomon, appointed wife, daughter, one daughter and four sons, as one share were allotted to them. Four sons, one daughter, wife, and himself, 7 members. And he appointed himself as a managing director and other two sons as the other director of the company. This way he completed public company, that is 7 members and 3 directors. 7 members and 3 directors. Are you understanding? Are you understanding this? Yes or no? Yes or no? Yes. Now, see, business is nothing permanent. It will grow and one day it will come down and grow. So now he started doing company, running the company. Company is into losses. Now, after some year, when the company is into losses, there is a need to shut down the company. There is a need to shut down the company. On shutting down the company, this was the position. What was the position? The position that company had only assets of 6050 pound and company had a liability of 18,000 pound. Out of 18,000, 10,000 pound is outstanding towards secured debentures of Salomon, and 8,000 pound is outsiders money, that is unsecured creditors. That is unsecured creditors. Are you understanding? So basically now the company is into difficulties whereby company had an asset of only 6050 pound and company had a liability of, basically if I'm talking about liability is roughly about 18,000 pound. Now there was a confusion. Other creditors are telling please pay us. Salomon is telling please pay me because money is asset is not sufficient now. See this, only 6050 pound asset and liability is 18,000 pound. That is not sufficient. Very clear. So in that case, understand here, in that case, now there is a confusion. Other creditors are telling that Salomon is the owner and Salomon is a debenture. He will not get the money. Other creditors are telling that Salomon is the owner and Salomon is a debenture holder. He will not get the money. He should not get the money. Salomon is telling that I should get the money. Who will win the case? Salomon will win the case or other will win the case? What do you think? Are you getting the question? See, the company had only 6050 pound. 6050 pound, but the liability is 18,000 pound. Out of 18,000, 10,000 is outstanding towards Salomon and 8,000 is towards other. See, very simple example. If Mukesh Ambani is the shareholder of Reliance and Mukesh Ambani is given a loan also to Reliance, now if company need to be shut down, Mukesh Ambani can claim money because he is an outsider. Company is separate, Mukesh Ambani is separate, Salomon is separate, and Salomon and company is separate. Court said that Salomon is separate and company is separate. Company have its own personality. Company have its own legal existence. Company have its own independent quality. You cannot link the two. Mukesh Ambani taking loan means Mukesh Ambani taking loan. Company taking loan means company taking loan. It is not vice versa. Getting your point? In this case, law said that separate legal entity, Salomon and company is different from the member. Salomon family is separate and Salomon is separate, and the debenture holder should be paid in priority. Salomon should be paid in priority. This was the case. Salomon versus Salomon and Company Limited. Same case was Lee versus Lee Air Farming Limited. Same case, Lee versus Lee Air Farming Limited. Lee was registered a company, Lee Air Farming Limited. He was the shareholder, he was a director as well as the head pilot, chief pilot. Lee was flying the flight and he met with the accident and he died in the air crash. Okay. Now, widow of Lee is telling that the employee died during the job. The company should pay compensation under the law, Workmen Compensation Act. The company should pay the compensation under the law, Workmen Compensation Act. Now, company is arguing that Lee Air Farming Limited is arguing that my lord, Lee was the employer and Lee was the employee. How can we claim the compensation? How can we pay the compensation? Lee was the employer and Lee was the employee. How can we pay the compensation? Are you getting this? So now court said that no. The employer was the company and Lee was the employee. Owner is separate, company is separate, company is employer and Lee is employee, and the compensation should be given separate legal entity. See, understand. If Reliance Industry buy 50 BMW car, is it Mukesh Ambani buying it? But if Mukesh Ambani buy 10 Lamborghini, is it Reliance Industry buying it? No. Both are separate in the eyes of law. Reliance Industry is Reliance, Mukesh Ambani is Mukesh Ambani. Even though Mukesh Ambani invested money, but there is a separate existence in the eyes of law, separate legal entity is there, and that is in the case of Lee is separate and Lee Air Farming Limited is separate, Salomon is separate and Salomon and Company is separate. Separate legal existence is there. That is the landmark case for separate legal entity. Are you understanding this? Are you getting this? Yes or no, friends? See, this is not a regular batch. This is a quick revision, marathon series where you have to focus. I cannot just do. So, what are the characteristics? First thing, company is made by birth, company is made by incorporation, registration, or company is made by agreement. Tell me. Company is made by birth, company is made by incorporation, registration, or company is made by agreement. What do you think? Yes. See, HUF is made by birth. You take a birth in the family, you are part of HUF. Very clear. HUF is made by birth. Okay. Second, if I'm talking about HUF is made by birth. Second is partnership is made by agreement. And company compulsory registration is to be done is called as incorporated association. Is a company called as a person? Is a company a person in the eyes of law? Yes or no? Yes. Like we take loan, company can take loan. We give loan, company can give loan. We buy asset, company can buy asset. We sell asset, company can sell asset. We file a case, company can file a case. Case can be filed against us, case can be filed against company. So company is also person because company is having the rights as well as obligation. But company cannot think like us. Company cannot talk like us. Company cannot sign like us. Therefore, company is not natural person, it is artificial person. And is the company having its own independent existence? Is Reliance Industries separate and Mukesh Ambani separate, or it is one and the same? What do you think? It is separate. We have discussed this in Salomon versus Salomon and Company Limited case, Lee versus Lee and Farming Limited case. They both are separate. Companies having a separate and existence in the eyes of law. Similarly, if I'm talking about liabilities of the members are generally what? Limited. Generally limited. Up to what amount? Up to the amount unpaid on the shares of the company. Up to the amount unpaid on the shares of the company. Very, very clear. And like we sign, company cannot sign. Therefore, company have an official signature, that is common seal. And nowadays, common seal is optional. If on behalf of company, two director and one CS sign, that is signature. Again, I'm repeating, like we sign, company cannot sign like us. Therefore, the official signature of the company is the stamp, which is common seal. But nowadays, common seal is not compulsory everywhere. Common seal is basically optional. Now, if two director and one CS sign on behalf of company, it means the company is signing. And company is having its own life, like this tree in the diagram. The leaves come and leave, but tree is intact at its place. Member come, member may go. GRD Tata made Tata Group. GRD Tata is no more, but Tata Group is still there. Dhirubhai Ambani made Reliance Industry. Dhirubhai Ambani is no more, but Reliance Industry is still there. See, understand, company life is separate, members life is separate. You cannot mix the two life. Company have its own life. Who made the company? Law. Who will wind up the company? Law only. Member life and company life cannot be mixed, which is called as perpetual existence. And company can buy property in its own name. Can there be an agreement? Reliance Industry versus Mayur Agarwal, the land deal or something. Can then be company buy car in its own name? Yes. Company can buy property in its own name. Company can have its own life. Company is having own signature. Company's member liability is limited, and company share are generally easily transferable by click of a button, except private company. Except private company, their shares are transferable subject to restrictions in articles, and in company owners are shareholder, managers are directors, board of directors. There are two separate teams, one investor and one managers. Investors are shareholders, owners are shareholders, but managers are board of directors. Separation of ownership and management is there, and company can file a case. Reliance Industry versus Mayur Agarwal, or anyone can file a case on company. Company can sue or be sued. These are the certain characteristics. Are you understanding this? See, corporate personality, separate legal entity. Then I am talking about limited liability, perpetual succession, then transferability of shares, capacity to be sued or be sued. Are you able to get this? Company have a contractual rights. Okay, separate management and it is association for profit, and only by law they can wind up, otherwise it cannot be winded up. These are the certain characteristics of company. Now we are coming towards shares of the company. What is a share? How many types of shares are there? Tell me. How many types of shares are there? Kinds of share. Any guesswork? How many kinds of shares are there, friends? Tell me. Two kinds. One is equity share and one is preference shares. Equity share and preference share. And how many kinds of equity share are there? Two types. Voting right and differential voting right. See, what is a public company? Which is not private. What is equity? Which is not preference. In a family, I always tell this example, parents and kids are owners of the family. They are the shareholders. But parents are equity shareholders and kids are preference shareholders. Kids get everything in preferential treatment. Food is made according to them. Anything they want to buy, they get according to them. And then parents think about themselves. So kids are like owners who are preference shareholder, who are getting preferential treatment. Who are getting what? Preferential treatment. That is very clear. What preferential treatment? Preferential treatment in case of dividend and preferential treatment in case of repayment of capital. Whenever dividend is to be distributed, first preference will get it, then equity will be given. Whenever there is repayment of capital, refund, first preference will be given and then equity will be paid back. Are you understanding? So those shareholder who are getting preferential right and the preferential treatment in case of dividend income, they are getting first preference, VIP treatment, and they are getting first capital, that is preference shareholders. Otherwise all others are in the category of equity. All are in the category of equity. All this is in section 43 of Companies Act. I'll show you. All this is in section 43 of Companies Act. I'll come to this. See this. Kinds of shares. Kinds of shares. First kind is equity share, second kind is preference shares. Now, what is equity? Equity means all share capital which is not preferential capital. All share capital which is not preferential capital. And what is preference share capital? Preference share capital means that part of capital which carries preferential right with respect to payment of dividend and repayment in case of winding up. They get priority VIP treatment in case of dividend and in case of repayment of capital. Now dividend can be a fixed amount. Dividend can be fixed amount or it can be fixed percentage. Either 2 rupee per share or 10% per dividend per share. Okay. So fixed amount or fixed percentage. Are you listening, friends? Are you there? Yes or no? Yes. Very good. Okay. Anisha is active. Neha active. Neha Kore also active. Neha N. Neha Kore. Nisara active. Okay. Very good. What about others? Fatima, Preksha, Pujita, KS. Okay. Achut is active. I don't know the pronunciation. Achut, I may be wrong. Karthike is active. Swastik, Navami, Pavana. Very good. You have to listen a lot. Pavana, Sakshi is active. Sudiksha. Okay, Hitesh. Very good. Nice to see your name. Pavitra. Pavitra S. Ashlita. Harshit. Harshit, you're active. 1, 2, 3. Who's 1, 2, 3, 4? What's your name? 1, 2, 3, 4 is active. Okay. So, right, those shareholders who are getting first priority whenever dividend is distributed and priority in repayment of capital, those are preference. Those who are not getting priority are equity. Now, equity is of two types. What is equity of two types? With voting rights and differential right to dividend and voting. That is DVRs. With voting rights, and second is DVRs. Okay, with voting rights and DVRs. So what is DVRs? I'll show you example. See, I open a website. So let us take to money control and just I'll zoom this. This is Tata Motors Limited, right? Tata Motor Limited. Okay. Now I'll show you Tata Motor Limited DVR. Tata, see, there are two things. One is Tata Motor and Tata Motor Limited DVR. Can you see this differential voting right? Are you able to see it? Yes or no? Yes. So this is DVRs. Tata Motor Limited DVR. See what happens. Suppose example, I have taken 10 shares of Tata. 500 rupees into 10 share. That is equivalent to 5,000 rupees. Okay. Now, really speaking, Tata Motor called meeting in Mumbai 3 times a year, 4 times a year. All the way travel to Mumbai, come back. One time cab charges is 3,000 rupees, and 4 time charges would be roughly almost 12,000 rupees. I have invested how much money? I have invested roughly. I have invested roughly. If I'm talking about 5,000, but for attending meeting, I have to pay 12,000. Do you think I will really attend the meeting? Yes or no? Do you think I will really attend the meeting? Yes or no? Answer is no. Very, very clear. Answer is no. That is a fact story. Okay. Answer is no. But why I'm there? See, I'm not participating into management. I'm not voting. I'm not attending. I'm not active. I'm only there to make my money. I'm there to buy the share at 500 and sell at 600. And secondly, I get a good dividend income. So guys, understand here, company will tell you take DVR, then you will get less voting rights. You will get less voting rights, but the benefit would be you will get little more dividend than a normal equity holder. If they are getting 10%, will pay you 11%, and will provide you share at little discount. Maybe 500 share you will get at 490. So now I am getting shares at discount, little bit of discount, and I am getting more dividend. I am getting more dividend. So my purpose is fulfilled or not fulfilled? Fulfilled, because I am here to make money, not to take participate in decision making. Now company cost will be reduced. Company need not call me for the meeting, need not arrange hotel and everything. So now company is reducing the cost and I am increasing my income. So those shareholders who are not active in the company should take what? DBRs. And those who are involved and those who want to participate in the company should take the equity with voting rights. They should take what? Equity with voting rights. That is very, very clear. Understand this. So there are two kinds of share. One is equity share with voting rights and with differential voting rights. Whereby in DVRs, I will get some discount and I'll get more dividend, but I will surrender some voting rights. But in voting rights, I will participate in each and every decision. So there are two types of equity with voting rights and differential voting rights. These are the kinds of share. These are the kinds of share which is there in the company. Do you understand this? Yes or no, friends? Are you understanding this? Are you understanding this? Yes or no? I'll show you. Just hold on. Okay. Now I want to explain you what exactly I'll show you. Hold up. See. What is equity? What is equity? Equity is those equity share with reference to company means all the share capital which is not preference. All the share capital which is not preference is equity. What is preference? With reference to company means which part of each which carry preferential right, with respect to dividend and repayment in case of winding up. It carry preferential right with respect to dividend and in case of repayment of capital in case of winding up. That is preference. Very, very clear. Now let us come to the background of the Companies Act. What happened in the historical and what was the story? Just hold on. First thing, company is derived from the Latin word, right? Company is derived from the Latin word. Come means to come together and pani means to have bread. Okay. There are so many Companies Act 1866, 1882, 1913, 1942, 1956. Okay. Now, first the background of Companies Act 1956. Who drafted Company Law 1956? It was drafted by H.C. Baba, Homi Baba, the popular name, along with 12 members. There was a committee of 13 people. Homi Baba was the chairman, and along with him 12 members. They drafted Companies Act 1956. They submitted their report in April 1952. Then in the Lok Sabha, Rajya Sabha, it was debated and the Companies Act 1956 come into picture. Companies Act 1956 had 658 sections and 14 schedules. Present Companies Act, how many sections? Tell me. Companies Act 1956 have 658 sections and 14 schedules. Present Companies Act have 470 sections and 7 schedules. Understand here. So this was about the Companies Act 1956. Let us go to the notes. What is there in the module? The Companies Act 1956 was enacted to view the consolidate and amend all the relating laws to Companies Act. See, there were so many laws. Companies Act they removed and made one law. Okay, this act came into force on 1st April. 1st April 1956. It came into 1st April 1956. Okay, and basically, if I'm talking about, okay, it was under the Bhabha Committee, Homi Bhabha Committee, who submitted their report in March 1952, and now the Companies Act consists of 658 section and they have written 15 schedule, follow 15 schedule, not 12 schedule, okay, not 14 schedule. So basically, it old Companies Act came into force. MCQ can come up. 1st April 1956. It was under Bhabha Committee and they recommend a lot of changes whereby okay, lot of amendment has been done and now the Companies Act 1956 contain 658 sections and 15 schedules. Read this. Okay. Now let us proceed. So this was the Companies Act 1956. Some MCQ can come up. Now 2013, what is the background? See 2013 MCA, Ministry of Corporate Affairs. See government different ministries. The ministry is basically the Ministry of Corporate Affairs, Ministry of Home Affairs, Ministry of Foreign Affairs, Ministry of the Defense, Ministry of Finance. So Ministry of Corporate Affairs look after Companies Act and LLP. Okay, they decided to review the Companies Act because a lot of liberalization, privatization, lot of changes was needed in the, because the old law was rigid and was not flexible enough, and therefore on 4th August 2004 they decide to review the Companies Act. Then 2nd December 2004 they formed a committee under the chairmanship of Dr. J.J. Irani along with other members. Expert committee was established. Who is Dr. J.J. Irani? Dr. J.J. Irani is one of the pillar director and of the Tata Group. He had a lot of experience. He was in the committee. Now they drafted and they presented the company's bill. Whenever the law is not passed, the draft law is called as bill. They passed in Lok Sabha on 18 December 2012, and on 8th August 2013 they passed the bill in Rajya Sabha. Then on 29th August 2013 President Pranab Mukherjee assented and approved the bill, and 30th August the bill became Companies Act 2013. I am repeating again. 4th August 2004, they decide to review. 4th August 2000, this is summary. We'll go in detail again, the notes. 4th August 2004, they decide to review the Companies Act. Then 2nd December 2004, they formed a committee under the chairmanship of Dr. J.J. Irani, and it was called as Irani Committee. And 18 December 2012, Companies Bill 2012 was drafted and was passed in Lok Sabha. Then Rajya Sabha it was passed on 8th August 2013. President Mukherjee signed the bill on 29th August, and 30th August it came into picture. That is basically Companies Act. With this, there was almost 470 sections, 29 chapters and 7 schedules in the Companies Act. 470 sections, 29 chapter and 7 schedules in the Companies Act. See what they have done. See, concept paper of Company Law 2004 and J.J. Irani report. J.J. Irani report. Are you getting this? The committee was formed on 2nd December 2004 under the chairmanship of Dr. J.J. Irani, the director of Tata Sons. He was that time the director of Tata Sons. Then they submitted the report to the government. Okay, and then again there was a discussion going on. 3rd August, the company was bill was introduced in Lok Sabha. Okay, then they formed a Parliament Standing Committee who reviewed it and made changes in the company's bill. And again, it was passed in Lok Sabha on 18 December 2012. It was passed in Rajya Sabha in 8 August 2013, and then it became the company's bill finally became Companies Act on President signed on 29th August, and it was officially declared on 30th August. And now with time, there were so many amendments from 2013 till now. Companies Amendment 2015, Companies Amendment 2017, which keep on improving the Companies Act for people understanding and better understanding. Do you understand this? So this was about historical background. This was about historical background. Now let us come to shareholders meetings. Guys, meetings are of three types: AGM, Annual General Meeting; EGM, Extraordinary General Meeting; and class meeting. In your portion, there is only AGM. AGM is under section 96, extraordinary general meeting is 100, and class meeting is a different class, preference, equity, they come up. So AGM is under section 96. What is AGM? Whenever shareholder meet once a year, annual general meeting, Varshik Am Sabha, that is annual general meeting. Do you understand this? Once a year, that is annual general meeting, Varshik Am Sabha, that is annual general meeting. Do you understand this? Yes or no? Yes or no? Okay. So now let us see section number 96. Let us see 96. Yes, guys. 96. Just giving you 1 minute time to think about AGM points. Then I'll be fast revising it. Just 1 minute time. I'm just pausing it. Okay. Yes, guys. So now we are coming towards AGM. We are coming towards AGM. See, first thing, see who those investors who have put money, 10 crore, 100 crore, 5,000 crore, don't you think they want the financial position of the company? Don't you think they require what is happening in the company? AGM is the opportunity to ask what is happening in the company and what is the future. They will ask what you have done, how much profit you earned, show us the balance sheet, show us the profit and loss account. At the AGM, they have the right opportunity to ask each and every damn thing and then proceed with the company. Do you understand? So AGM, there are two types of AGM. Annual general meeting, it is once a year. AGM is of two types, not two types exactly. There are two kinds. That is first AGM, the very first meeting of the company, first AGM, and then every year there will be subsequent AGM. The first AGM should be held within 9 months, within 9 months, 9 months of financial year. From the end of financial year, it means suppose the financial year is, generally it is April to March. April to March a year considered. Therefore, it is April to March, June, April, May, June, July, August, September, October, November, December. By December, we need to conduct the first AGM within 9 months from close of financial year. From close of financial year. Very, very clear. Do you understand this? From close of the financial year, it should be held within 9 months. Do you understand this? But now, subsequent AGM should be held within how many months? Within 6 months from close of financial year. Within 6 months from close of financial year should be held. See, first AGM, first impression. And the first time they may require time. But later on, we are giving them 6 months time. Suppose there is 1/4/2020, 31st March 2021. The subsequently from this 6 months, April, May, June, July, August, September. April, May, June, July, August, September. Till September, they should conduct the AGM. But being the first AGM, you are required, you are given more time. That is called as the first AGM. That is the first AGM, you are given more time, that is 9 months. But normally, you are given 6 months. Again, see, first one AGM is held in September 19. Second AGM is held in September 20. Suppose example. Next AGM is held in May 21. Then next AGM. The gap between two AGM should not be more than 15 months. Maximum gap allowed between two meetings is 15 months. And every year, one meeting should be held compulsorily. every year one meeting should be held compulsorily. The gap between two AGMs should not exceed 15 months, and every year one meeting should be held compulsorily. Do you understand this? Yes or no, friends? Yes or no? Are you listening? Again, I am repeating. First AGM within 9 months from the date of closure of financial year. Subsequent AGM within 6 months from the closure of financial year. Correct? First AGM, subsequent AGM. Okay. And next is first AGM and subsequent AGM. Now, gap between two AGMs. All this is written where? Section 96. Two AGMs is basically maximum 15 months gap. Maximum 15 months gap is allowed. Then one AGM in every year. At least every year one AGM should be held. So these are the things which are about AGM. Then if I'm talking about place, time and day. What is place? Place you can keep, if you have a big office, there are 50, 60 people, keep the meeting at office, registered office, head office. If you have 10,000 people coming for the meeting, you don't have space, then wherever your head office there, in that city, town, village, you can keep anywhere, hotel, stadium, no problem. So it can be at registered office, or city, town or village where there is registered office. What is the time? Can you keep AGM at night 3 o'clock? No, not allowed. During day 9 a.m. to 6 p.m. anytime. During business hours, that is 9 a.m. to 6 p.m. And day, any day which is not a national day, not on national holiday, you can keep any day. Okay, so these are the things which we have to understand. First AGM should be held once the year end within 9 months. Subsequent AGM should be held within once the year end within 6 months. Okay, the gap between two AGM should not be more than 15 months, and basically one AGM every year. Where is the place where the registered office is situated? Business hours 9 a.m. to 6 p.m. and day which is not a national holiday. Section number 96. Are you understanding? See, at AGM, there will be two things to be discussed. Business transacted. One is ordinary business. Second is special business. See, four things are ordinary. Which will happen means happen. You need not tell only. In every AGM, this will happen. That is ordinary. There is routine. Every year, you get the balance sheet. That is financial statement. You will decide about dividend, what profit to distribute or not. You will decide about directors who will run the company, and you will decide about auditor who will check the books of accounts. Four things are ordinary, which is routine. But except this four, which is not ordinary, special, which is not ordinary is special business. Understand here. What is my point? Which is not ordinary is special business. Which I am talking about. Understand here. What is the point here? Again, I am repeating. Understand. Ordinary, to give the balance sheet, financial records, dividend declaration, director appointment, auditor appointment for the next year, who will look after the company. Is every year procedure which will happen means happen. Now, if company is thinking that, directors are thinking that at AGM, let us take the permission to take loan. Let us take the permission to take loan. That is what? Ordinary or special? Tell me. That is what? Ordinary or special? That is what? Ordinary or special? Tell me, friends. Yes, that is not routine business. Now they are thinking that let us sell the factory, take the permission from the shareholder. That is ordinary or special? Tell me. That is ordinary or special? That is special. Understand? What is not ordinary is special. Not something which is extra to be discussed is special. These four are every year to be discussed, every AGM. That is basically ordinary. Apart from that, that is special business. All this is mentioned in 102 of the Companies Act. I'll show you, don't worry about it. So suppose, see, suppose first AGM happened on 30th September 2018. Second AGM happened on 30th September 2019. Just example. Third AGM happened on 30th September 2020. Fourth AGM happened on, suppose, 30th September 2021. Now, suppose in January 20, they think, or January 21, they think that they need to take some decision. But now they cannot wait for some 9 months. AGM will happen in September and we have to take a decision in January. We cannot wait for 9 months. At that time, when the meeting is called, that meeting is called as EGM, Extraordinary General Meeting. That meeting is called as EGM, Extraordinary General Meeting. The meetings which takes place between two AGMs, the meetings which takes place between two AGM is called as, tell me friends, will be called as EGM, Extraordinary General Meeting. Do you understand this? Yes or no? So EGM is discussed under section 100, calling of EGM. EGM is extraordinary special, that is 100, and AGM is which is in 96. And what I was talking about, at every EGM, there are two meetings, there are two things. One is AGM and another is EGM. Okay, so now at AGM there will be ordinary business and there would be special business. But in EGM, there would always be special business, which is something not ordinary routine work. At AGM, four things are done every year. So basically, that is ordinary. But apart from that, four things, if they conduct other things that is special, EGM is not routine work. They are called for a special reason, and therefore it is a special business. So let me show you what I'm trying to tell you. See this. Business to be transacted, ordinary and special. What is not ordinary, other than ordinary, will be special. What is other than ordinary will be special. Do you understand this? So what is ordinary? Four things are ordinary. Consideration of financial statement, declaration of dividend, appointment of director and appointment of auditor. All these are ordinary. Apart from all these four are special. Please read this. Are you getting this? Are yes or no? Tell me, friends. Are you connected? Yes, friends. So this is under section 102. I'll show you Companies Act. And in Companies Act, I'll show you 102. See, 102. See this. In annual general meeting, all transactions at AGM, all transactions shall be deemed to be special other than the following: financial statement, declaration of dividend, appointment of director, appointment of auditor. In any other case, all business shall be special. In every AGM, it is special, but apart in annual general meeting, it is special as well as ordinary. These four are ordinary, others are special. Very, very clear. Now, see what is happening. If you don't keep the meeting, if you contravene section number, Companies Act 96, 97, 98. 96 is for AGM. If company is not holding AGM, 97 tribunal will hold the AGM. 97 tribunal will hold the AGM. And if tribunal is not holding AGM, tribunal will hold AGM and tribunal is holding EGM. You have to listen to tribunal. Tribunal means court. Court means NCLT, National Company Law Tribunal. Do you understand this? I'll just show you. NCLT. Okay, so this is NCLT, in which everything is happening here. NCLT. This they are ordering company. Why are you not holding AGM? Call AGM. Why are you not holding AGM? Call AGM. And company is not listening to section 96. Company is not listening to section number 97 tribunal order. Company is not listening to section 98 tribunal order for EGM. 97 tribunal calling AGM, 98 tribunal calling EGM, 99 will tell penalty. What is the penalty? Let us see the penalty clause. The penalty is under section 99. If you contravene 96, 97, 98, then company who is in default shall be punishable with a fine from 1 lakh rupees, and in case of continuing default, which may extend to 5,000 each day for continuing default. Do you understand this? So every company and every officer, see what is the penalty. Section number 99, penalty for non-compliance of 96, 97, 98. Then company and officer in default, company and officer in default for one-time penalty and continuing penalty. One-time penalty 1 lakh rupees and continuing penalty, how much you don't listen, 5,000 rupees per day, that is 99. Read this. Are you getting this? Are yes or no, friends? Yes or no? Tell me, friends. Tell me. Penalty for non-compliance of section 96, 97, 98. Company and officer in default, one-time penalty 1 lakh rupees. Continuing default 5,000 rupees per day will be the penalty. Now we are jumping towards the new discussion, CSR. See, every company have to take some social responsibility. See, you are earning from society to do something for society. You have to see, certain companies did donation on their own wish, they were not forced, but many companies did not contribute anything. So by law, every company have to contribute for the society welfare, which is called as CSR. Social responsibility means society responsibility, and corporate social responsibility means our responsibility, company's responsibility towards society. And every company, those are fulfilling the threshold limit, need to form a separate committee who will focus on CSR, who will focus on CSR and the corporate social responsibility work. They need to form a separate committee itself. If the company's net worth, paid up capital, is 500 crore or more, or the company turnover is more than 1000 crore, or the company's profit is more than 5 crore, then such committee should form a CSR committee, separate committee who is looking after charity, and which is, this committee will be formed with minimum 3 directors, and at least one director should be independent director in the same. So this committee, there is auditors committee, audit committee who will look after audit. There is nomination remuneration committee who will look after what is the qualification for becoming director, what is the remuneration for director, and there is CSR committee which will look after the social job and social responsibility. That is basically those companies who are fulfilling the above criteria, net worth is more than 500 crore, or turnover more than 1000 crore, or profit more than 5 crore, need to form a CSR committee. And about this committee, every board report should contain the details. About this committee, every board report, who are the part of the committee, who are appointed. See, there are one financial statement, one is auditor's report, one is secretarial audit report, one is board report. In auditor's report, who will write? Auditor. If auditor want to talk something, he will write in auditor's report. Director want to talk something, that is board report. The board report should contain the details of CSR committee, who are the part of CSR committee, and basically the committee will do what? Committee will make CSR policy. We will look after education, will look after medical issues. They will tell the money should spend where the profit. See, every company profit 2% need to spend for society welfare. Every company should spend profit 2% for the society welfare. So they will tell where the company money should be spent, and they will check whether the company is actually doing it or not doing it. So first they will make recommendations. Second, they'll make policy, and they will take which activity will do. See, I'll show you Companies Act. Under Companies Act, there is last schedule, Schedule 7. In Schedule 7, when you see this, in Schedule 7, very clearly it is mentioned here. Okay, if I'm talking about activities which are CSR, which are as a CSR, when you remove hunger and poverty, when you promote education, when you are getting gender equality, when you are reducing child mortality and maternal health, when are you fighting HIV, when you are getting environmental sustainability, in social project, contribution to Prime Minister Relief Fund, all these things are CSR. So now this committee will recommend what should be our focus area. What should be our focus area? Okay, are you able to get this? Are you able to get this? Yes or no, friends? But this committee, what the CSR committee will do? Three things. CSR committee will do three things. First thing is recommend CSR policy or formulate CSR policy. Second is formulate CSR policies. Second is recommend where the money should be spent, exactly what we'll do. For suppose example, we decide to promote education, How we'll promote education, whether we make college, whether we make school, whether we provide donation, they will go. What exactly? So what we, how we'll spend? Recommend the expenditure and monitor whether company is doing or not. Monitor the work. Monitor. Okay. So this work, first thing, the details of the committee must be mentioned in board report. What work they will do? They will formulate the CSR policy. They'll recommend the amount of expenditure to be incurred and they'll monitor the CSR activities. Now, how much they have to spend? Whatever the profit is, suppose example, amount to be spent. How much they have to spend for social welfare? Amount to be spent. If company existed for more than 3 years, 3 years, then 2% of the average profit for last 3 years. Whatever the last latest 3 years, take average profit. So average profit is 100 crore, 2%. You have to spend 2 crore rupees for. If it existed for less than 3 years, I hope you are listening and writing with me. You have to be involved. Make chart, make diagram, underline. Existed for less than 3 years, then 2% of the average profit of whatever the company existed. If it existed for 2 years, 2 years average. If it is for 1 year, then 1 year. So basically, company need to spend 2% of the profit. And if anything, see, very clear. If there is some project going on, you are making school construction require 5 years. So there is some project going on. You know at the year end that school construction require 5 years. You need to keep money aside. Then you need to transfer it to a special bank account, and you will not use that touch that money. You will transfer it to a special bank account within 30 days. But you have to yet decide where the money is to be spent. You can keep that money with you and transfer it to a separate account within 6 months from the end of the financial year. And if you don't do this, then you will attract penalty. Company will attract penalty and officer will attract penalty. Company will attract 50,000 to 25 lakh and officer will attract 50,000 to 5 lakh, jail 3 years or anything. Check this, read this. See, if there is some project going on, you know that money will be required. You will keep a separate bank account within 30 days, you transfer it. And you are yet to decide which project you'll apply. To think we have given you 6 months time and then keep in a separate bank account. So this was about CSR. Now let us come to board and directors. Board and directors, very very clear. Okay. The who will appoint the first director? Appointment of director. My question is to you is Who will appoint the first director of the company? Please put in the comment section. Appointment of director. It is first director and second is subsequent director. First director and second is subsequent director. Understand? If it is first director, their name is mentioned, named in articles. I'll show you how. Named in articles. In articles, like we are natural person. We also require document, PAN card, Aadhaar card, driving license, passport, etc., etc. Election card. So, like we natural person require documents. Don't you think company also have documents? If Amitabh Bachchan go and ask in the bank, give me 1,000 crore, wait, we know you're Amitabh Bachchan, prove it on papers. Amitabh Bachchan also need to show his identity. So company also need to show his papers, that is MOA and AOA. In articles, they mention the name, that is the first director. But if articles name is not mentioned, then law is telling that those who all became the subscriber, who signed it, will automatically become the first director. Those who signed the memorandum and those who signed the articles will automatically become the first director. Name not mentioned. Name not mentioned. Then subscribers will become director. Subscribers will become director. Are you understanding this? Yes or no, friends? Are you understanding this? Yes or no? Are yes or no? Yes. And later on, then next first meeting, second general meeting, third general meeting, members will appoint the subsequent director. Member will vote and appoint. But first director is either named in the articles, and if not named in the articles, then the subscriber will become the director. I'll show you one of the articles form, and you will see the first director name there. Just hold on. This is a heavy form, so they require Adobe Reader to open this PDF. First First director. This is, see, I am showing you. Just hold on. Till the time it is opening, let me check with the first director, appointment of director. Wait. Just give me 1 minute time. Okay. See, appointment of director. Okay. First director is named in the articles, and if no, then the subscriber shall be deemed to be the director and continue until the general meeting takes place. Then every director appointed in the general meeting AGM. To become a director, you have to compulsory have one number, that is DIN, director identification number. Like you have a roll number in your classroom, right? So director is identified by DIN. If you put DIN, the whole history will come up, where the director were the directors, where he worked now presently, where he left the company, where he resigned. So that is a database management. Like in income tax, your identity is your PAN number, permanent account number, right? That is PAN. So like in the MCA records, if you want to get the records of director, that is a DIN number. To become a director, DIN is mandatory. DIN is one time number, lifetime number, and everywhere it is used. And whenever you are ready to become a director, first you should declare your DIN, and second that you are not disqualified. You are qualified to, you are eligible. You are not ineligible. So whenever who want to become a director shall furnish the DIN and should give a declaration that he is not disqualified. And once he is, you know, if he want to become director, he should file his consent letter that yes, I am willing to be appointed. He should give his consent letter to become a director and file this with the ROC within how many days? 30 days. Within how many days? 30 days. Do you understand this? Yes or no, friends? Yes or no, friends? Now, if any vacancy happens, if any director resign, okay, the company will fill the vacancy, appointing someone else. Okay, very very clear. And basically, one more thing I'll explain you in detail. Just hold on. See, this is AOA, Articles of Association. When you go and check down here, see, shares, okay, then you come to lien on shares, call on shares, transfer of shares, then you come down, transmission of share, forfeiture of share, alteration of capital, capitalization of profit, general meeting, buyback of share, proceedings, adjournment of meeting, voting rights, proxy, board of director, right? See this, under board, the first director shall be Jason Mandela, son of this, and Harshad Jaju Bhalerao. The first director, they are named in the articles, yes or no. They are named in the articles, yes or no. They are named in the articles, yes or no. Friends, are they mentioned in the articles, yes or no? Tell me. Yes, they are mentioned in the articles. If not mentioned in the articles, who will be the director? It will be the directors who are the subscribers of the company will become the director. Very, very clear. And further directors are appointed in every general meeting. And director should have DIN, director identification number, to become a director. Also, they should give a furnish the DIN to the company and letter that they are not disqualified, they are not ineligible. And basically, if I'm talking about, then they should give a written consent that they are ready to become the director, and the written consent should be filed with ROC that within 30 days from the date of appointment. Are you getting this? And see, understand here. Now, out of all the directors, suppose there are 15 directors, two-third director will be rotational directors. Rotational director, that is 10 director, and one-third director will be like permanent director who will continue the company, because they see everyone come and leave the company. No one will have a clear idea. So at least some permanent people and some rotational. Out of two-third, every year, one-third director will retire, then next one-third director, and then next one-third director, they will be appointed, or shareholder will vote on them whether to continue them or remove them. The next, I'll give an example. Wait, suppose there are 15 director, A, B, C, D, E, F, G, H, I, J, L, M, N, O, P. There are 15 directors. So like, we'll talk about two-third director, roughly I'm just taking example, will be rotational director, but all will not retire every year. First one-third, first one-third will retire, the next one-third will retire, the next one-third will retire. Getting my point? So who will retire first? They'll fight. You go first. You go first. Who is longest in the office? He is there for last 5 years. He is there for last 5 year, 5 year, and others are 4 years. So they will retire first. Who is longest in the office will retire first. They may be reappointed or they may be removed. If they are doing best, they will see performance is needed. If those who are performing better will continue, those who are not performing better will leave. In this way, understand here, very very clear. See, not less than two-third of the total number shall be determined by rotational, out of which one-third of such director are liable to retire by rotation. Who is longest in the office shall be retire first. Those who are there for longest in the office shall retire first. Sir, if there are many people who are longest in office, will determine by lot, will remove a chit and decide. If those who are same, they see on the same day, suppose example, these these six director, these six director are longest in the office. These six director are longest in the office. Then who will first three people? The first three people will be decided by a lot and a chit system. Are you able to get this? So this is the whole story. I'm repeating again. Who will appoint the first director? Tell me first in the comment section. Who will appoint the first director? Who will appoint the first director? Tell me, friends. It is the named in the articles. Generally, obviously, the promoter indirectly, but those who are named in the articles. But if article is silent, who will appoint the director? Subscriber will become the director, and in first, second, subsequent meeting, member will appoint the director. For becoming director, DIN is mandatory. And to become a director, first submit your DIN and a letter that you are not disqualified, and the letter that you're not disqualified. Now you are appointed. Now you will give a consent that yes, I am willing to appoint and file with ROC. Out of all the director, how many directors are rotational director? Out of all the director, what proportion is rotational director? Out of all the director, what proportion will be rotational director? Out of all director, two-third will be rotational director, but all two-third will not retire. Out of two-third, one-third will retire every year. Out of two-third, one-third will retire every year, and those who are longest in the office will retire first. Those who are longest in the office will retire first. Very, very clear. Those who are longest in the office will retire first. Wait. Oh. Yes. Are you listening? See, those who are longest in the office will retire first. Very, very clear. Now we are talking about board meeting. See, shareholders meeting, board of directors meeting. There is different thing. Okay, let us understand this, and let us understand what is the board. Who is board? Tell me one thing. Company investment, who pay invest money? Shareholder. Who run the company? See, company is an artificial person. Company cannot think. Company cannot have an idea. Company is artificial person. Company require natural person to run the company. So natural person who run the company are called as, individually called as director and collectively called as board. Individually called as director and collectively called as board or board of directors. Very, very clear. So who look after day-to-day functioning? The directors of the company. Let us understand. So see this. The company is an artificial person and it is managed by the human beings who are natural. The people who run is known as board of directors. Collectively are called as board, and director play a very important role for day-to-day functioning, and director is responsible for overall performance. Let us see the definition under section 2, subsection 10. Okay, let us come to section number 2, subsection 10. See, in the company law, either they will use the word board of director or board. In relation to company means collective body of directors of the company. All director together. Collective body of director will be called as board or board of directors. Collective body is called as board or board of directors. Let us see Reliance Industry website. Let us see Reliance Industry website. Reliance Industry Limited. Okay. Let us see the our company, innovation, investor, career, sustainability, our company, and in our company, let us see the board of directors. See the board of directors. Mukesh Ambani is the chairman and board of director. Neeta Ambani is again a director. Hital R. Meswani, Nikhil Meswani, okay. PMS Prasad, okay. KP Kapil, R.A. Mashlekar, all these. Deepak C. Jain, Raminder S. Gujral, Shumit Banerjee, Anuruddhati Bhattacharya, KV, and His Excellence, this is now FDI, done FDI, is also one of the independent director. Getting my point? So these are certain directors and board of directors. All the committee together is called as board of directors or board. Can you understand this? Do you understand this? Yes or no, friends? Tell me, in this whole board, how many people will be rotational? What proportion will be rotational directors? What proportion will be rotational director? Please tell. It is 2/3, not 1/3. See, out of the all the directors, suppose there are 12 directors, 2/3, 8 director will retire by rotation. And out of 8, every year, how much will retire? 1/3, 1/3, 1/3. These are like, on this there is a, we are having a watch. These people, and every year 1/3 director voting will be there, 1/3, 1/3, 1/3. 2/3 are rotational director. Out of rotational director, every year 1/3, 1/3 will retire by rotation. Very, very clear. So understand this. So what is my point here? What is board of director or board? It is a collective body of all the directors coming together, is called as a board. In board, there be natural person or only artificial person? Tell me. In board, there will be natural person or artificial person? Board consists of only individuals. Reliance Industry cannot have a, see, Tata Motor. Can Tata Sons become a director? No. Can in Jaguar Land Rover, can Tata Motor become director? No. No body corporate, no association or firm become a director. Only natural person become a director. How many minimum director required in a company? How many minimum director required in a company? Tell me. How many minimum director required in a company? See, understand here. Minimum, section 149. Minimum director 3 for public, 2 for private, and 1 for OPC. Section 149. 3 for public, 2 for private, and 1 for OPC. How many maximum director a company can appoint? 15. How many maximum director company can appoint? 15. I'll just show you how. See, these are the column. One column is minimum, another column is maximum. For private, for public, and for OPC. Private minimum 2, maximum 3, OPC 1, sorry, public 3 and 1, and maximum 15, 15, 15. So if we want to open more than 15, pass special resolution and take the permission of the members in general meeting. Pass special resolution and take the permission of members in general meeting. See, provided that a company may appoint more than 15 after passing special resolution. Very, very clear. So guys, understand here. See, you understand here. 3 director for public, 2 for private, and 1 for OPC. Maximum 15. If you want to appoint more than 15, then pass special resolution in the general meeting. Pass special resolution in the general meeting. Are you understand? And there is no limit in section 8 company. If directors are ready for charitable work, if they are ready to give their time for charitable work, good thing or a bad thing? Tell me. Is it a good thing or a bad thing if a director want to do the charity? Tell me. Yes or no? It's a good thing. So why we should limit? Can they appoint? Can they appoint 20, 30 directors? If 20, 30 directors are ready to focus in one company for charitable work, allowed or not allowed? Are they allowed? Yes or no? Allowed, there is no limit. Whenever there is a Section 8 company, there is no restriction of the maximum number of directors shall apply to Section 8 company. Very, very clear. And at least one director should be resident in India. At least one director should be resident in India. Resident means minimum 182 days in a year they stayed in India. See example. There are two friends, Rocky and Rami, and they want to start a company in India as Rocky RR Private Limited. Now they themselves appointed as a director, but they are NR, non-resident. They stay in USA. Not allowed. Appoint Mayur Agarwal as one of the resident director who stay in India for more than 182 days in India. That is the main criteria. At least one director should be a local director. Every company shall have at least one director who stayed in India for not less than 182 days in the previous calendar year. Guys, please read this. Okay. So guys, I am repeating. Understand here. What is the minimum director clause? 2 for private, 3 for public, 1 for OPC. What is the maximum director clause? 15 directors. Very clear. What is the maximum director clause? 15 director. Can you appoint more than 15? Yes, after passing special resolution in the general meeting. But 15 limit is not applicable to Section 8 company. And every director should be, at least one director should be resident in India, which who has stayed in India for not less than 182 days or more. Very, very clear. Now, let us come to certain definition, that is nominal capital, issued capital, subscribed capital, called up capital and paid up capital. Suppose I have made a company and I have mentioned in the memorandum that I will sell 10 lakh shares of 10 rupees each. I will raise 1 crore rupees. So this is mentioned, this is the maximum capital I'll raise. So this will be called as authorized capital. But today only I don't require 1 crore. I have made available to people 5 lakh shares of 10 each. So I'm making share available to the public. So that is what here it is called as issued capital. And issued capital means which is available for subscription. Which is available for subscription. People can apply for it. But really speaking, 4,90,000 share people have applied for, that is 49 lakh. So this is called as subscribed capital, which people have subscribed. Which people have subscribed. See, first thing is very, very clear. What is the maximum capital we have raised is 10 lakh into 10 rupees, that is 1 crore we'll raise. But we are making it available only 5 lakh share today. That is 50 lakh rupees we are raising. But people have applied for 4 lakh 90,000 share, that is subscribed. Now, Out of 4 lakh 90, we have called 6 rupees per share. 4 lakh 90, we require 6 rupees per share. Today we require only 6 rupees. Today, so we want 2 lakh 90, 29 lakh 40,000 rupees. That is called a capital, which is called for payment. But really speaking, 4 lakh 85,000 shares are being paid. Others have not paid the money. That is 4 lakh 85,000 shares into 6 rupees. That is, 29 lakh. People have paid, really credited to our bank account. That is paid our capital, which is credited to bank account. Again, I am repeating. I have registered the company with 10 lakh shares. It is called as authorized capital, nominal capital, maximum capital. But today I want to make available 5 lakh shares to the people. So I want to leave 5 lakh shares today, 5 lakh share I'll raise later on. So I am making available 5 lakh share, it is issued. Out of 5 lakh share, 4 lakh 90 people, 4 lakh 90 shares are people applied for. That is subscribe capital. But now, as on today, we don't want 10 rupees complete, we require 6 rupees only, that is called up. But really speaking, those people who have taken 4 lakh 85,000 share have paid money, 5,000 share they have not paid money. Actually, we have received 29 lakh 10,000. It is called as paid up capital. It is called as paid up capital. To see this, let us come to this. The capital which is authorized by the memorandum to be the maximum amount of share capital is authorized capital. The capital which is issued from time to time for subscription is issued capital. And the capital which is taken by the members is subscribed capital. The capital which is called for payment and the capital which is actually credited is basically the issued capital. Nominal, issued, subscribed, called up and paid up. Any query here, friends? See, very simple. Maximum registered with ROC. Maximum registered with ROC is authorized capital. Okay. Made available to public is issued capital. Public applied for it. Applied for it is subscribed capital. Company called money is called up capital. And public paid money, actually paid money, some may default, is paid up capital. Are you understanding? Tell me who all are there. Just ping me hi and tell me, are you listening? Are you having that patience to listen me? Tell me yes or no. Yes, Ashlita, Anisha, Hitesh, RN, Pavana, Harshita, Anaya Shetty, Navami. Very good. That patience and dedication is required and you are listening it. Continuously listening is a very big thing. Nisara, Triveni, Anuradha, Karthike, Renisha, Pujita. Okay. Very good. Navami, Suprita, Pavitra, Neha N, Shivani, Sakshi. Fantastic, fantastic. Okay. Yes, I'm coming to the last part of the Company Act which I want to cover, lifting of corporate bill. Telling me one thing, lifting of corporate bill. See, if Reliance Industry is selling defective goods, can you file a case on Mukesh Ambani? Tell me yes or no. If Reliance Industry is selling defective goods, can you file a case on Mukesh Ambani? No, separate legal entity. Company is separate, owners and directors are separate. If Mukesh Ambani is personally selling defective goods, can you file a case on Reliance Industry? Yes or no? If Mukesh Ambani is personally selling defective goods, can you file a case on the company? No, separate entity. This separation is called as corporate veil. This separate legal entity in the eyes of law is corporate veil, but this quality is given, this feature is given for growing company, for a betterment of the company, for making it ease for doing business. Do you understand this? This is called as corporate veil, so that company have its own life, company have its own existence, company have its own identity, company can run, company life and member life is not same. All these are given for betterment of the company, but certain people are using this corporate wheel and doing wrong things through company, which now law will tell, now separate legal entity is not there, company and the members are one and the same, company and the members are one and the same. They are using company to do fraud, they are using company to evade taxes, and now they are using the company form for their wrong things, which is now law will tell, wait, now company and members are not separate, they are one and the same. It is called as lift the corporate wheel or pierce the corporate wheel. See example, have you ever seen a puppet show? Puppet show, have you ever seen it? Puppet show. See this puppet show. Katputli we talk in Hindi and it is a puppet show in English. Okay, have you ever seen this? Just let me play one of the video. This is a puppet show. Suppose this puppet is dancing and the puppet person is behind the curtain. He is making that puppet dance, and that during dance he tell one of the audience, "Hey, mad person, mad person." Now that audience will come and hit this puppet or will hit the owner. Tell me, will hit the puppet or hit the owner? Tell me, what do you think? Hit the owner, but owner will tell, "I did not tell that." Puppet has said it. You are telling it and you are using that artificial person for a wrong intention. Same way, if directors and shareholder use the company for wrong intention, then who is liable? Company is liable or the director shareholder are liable? Who is liable? Company is liable or director shareholder are liable? Tell me, friends. Yes, it is the owner and the directors are liable. That is lifting of corporate wheel. Understand here. I'll give you an example. Hold on. See, one of the landmark cases, Guilford Motor Company versus Horney. I'll tell you. Suppose example, I joined TCS company, Tata Consultancy Services, and I joined a very big CS firm or CA firm. Okay, and now I leave that firm. So they have put a clause that Mayur Agarwal, you are leaving our job. So there is a condition that for 3 years you will not work with our clients. You will not work with our clients. Okay, so I have agreed to that. Now I want to grab their clients, but I cannot do. So I make a company, and through company I grab the clients. Tell me, to incorporate a company, I have done in the right intention or a wrong intention? To incorporate a company, I have done with the right intention or a wrong intention? I made a company to grab the clients. I have done it the right intention or wrong intention? What do you think? Yes, it's the wrong intention. So what I'm doing, what I'm really doing, I'm doing fraud. See, same happened with Guilford Motor Company versus Horne. Guilford Motor was employer, Horne was employee. Employee leave the job and there was a condition on the employee that you will not solicit our client. He made a company and through company solicited, entertained the client. Did Horne do a correct thing? Now in the court he is telling, sorry, I did not solicit. Company solicit. Company separate, I am separate. Can he give that excuse? Tell me friends, yes or no? Answer is no. Very, very clear. So understand here, under the same case, he has used the company for fraudulent intention. So this former employee, that is Horne, made a covenant condition not to solicit its customer. He formed a company which undertook solicitation. The company was stopped by the court to entertain the client. Same with way, you are using the company as an agent. RG Films, it was FG Films also. I'll give you example. RG Films or FG Films, one and the same. Understand here. See, suppose there is an American film company. American movies were banned in India. So this American film company did what? The president of American company formed another British company and put all the money there. He is the 100% owner of that company, and now they are using the British film company as an agent and they apply for a movie in India. Tell me, if British film company is made by American film company, and are they using it for genuine reason or are they using it as an agent to get their work done? Are they using it for a genuine reason or are they using it as an agent to work done? Government said that British film company is acting as agent for American film and American films are banned and so they are routing the movie through British film. We are not allow it. Will lift the wheel. Separate legal entities removed. If British film company is applying means the owner American company is applying and now will not allow you because you are using the company as agent for wrongful purpose which is not allowed. Very, very clear. Same way, Daimler company was, Dinshaw Manekji patent, and I'll give you more two case laws. Understand here. Wait. Horne, Guilford Motor versus Horne done. Then we have done with what? We have done with RG Films. Now we are coming towards Dinshaw Manekji patent case. What is that case? I'll tell you. Hold on. Dinshaw Manekji patent case. See, Dinshaw. Mr. Dinshaw was, suppose, example, earning. By investment, he earned interest income and dividend income. And he earned, suppose, example, 10 lakh rupees. Suppose, example, 10 lakh rupees. On 10 lakh, he need to pay tax. There were huge taxes. Dinshaw Banerjee Patel wanted to avoid tax. So what he did, see, what was the rule earlier? Up to 2.5 lakh, no tax. Then 2.5 lakh to 5 lakh, 10% tax. 5 lakh to 10 lakh, suppose example 20% tax. So Dinshaw Banerjee paid roughly 2 lakh tax. Now he formed 4 companies. He have given all his money to the 4 companies. Company invested in another companies, earned interest income, dividend income. Earned interest income, dividend income. Tell me, is the company doing any business? Not so. So every company earned 2.5 lakh, 2.5 lakh, 2.5 lakh and 2.5 lakh. Now they are telling up to 2.5 lakh, no tax, no tax, no tax, no tax, no tax. So now they did not pay the tax. But if these company return as a dividend, then Dinshaw have to pay the tax. So Dinshaw did not show it as a dividend. He showed that company has given him loan and the loan was never repaid by Dinshaw. The loan was never repaid by Dinshaw. Are you understanding this? Yes or no? Again, I am repeating. Mr. Dinshaw invested into various companies, earned interest income, dividend income, paid tax. Now, Mr. Dinshaw want to avoid tax. So, Mr. Dinshaw incorporated, registered 4 companies, put his money in the company. Company invested in another companies. Company invested in another companies and earned interest income, dividend income. So what he was earning alone is divided into 4 companies. What he was earning alone is divided into 4 companies. What he was earning 10 lakh is divided into 4 companies, 2.5 lakh, 2.5 lakh, 2.5 lakh, 2.5 lakh. Getting my point? So now company need not pay any tax because 2.5 lakh no tax. Now if they return to Dinshaw as a dividend, then tax will be paid. But Dinshaw has taken money as a loan. Now income tax got confused. Income tax is telling that first point, four companies are not doing any business except in. Okay. Second point, company is paying you money as a loan which you never repay. You have created these companies only for avoiding tax and tax evasion. We will not help you. The four company and you are one and the same. Let us add all the company income and your income and let us pay the tax. The company was made only with the intention to avoid tax. Dinshaw Manekji patent case. Are you understanding this? Dinshaw Manekji patent case which happened. So all these are certain cases where, see again, I'll take one more case. There are six. I'll be discussing four. Guilford Motor Company versus RG Films. See, Guilford Motor Company versus RG Films. Dinshaw Manekji patent. And one more thing. Employers versus the company. See what happened. There was a company. This company had almost 10 employees, then 15, 20. It also had a huge profit. Starting at 2 crore, 5 crore. If more profit, more bonus. So company made a subsidiary company and appointed new employees here. And now this company is earning 2.5 crore and this is earning 2.5 crore. Only to avoid bonus payment to the employees. See, bonus was applicable when you had more than 20 employees. So what they did, they appointed 20 employees here, 20 employees here. And they divided the profit also. Only to avoid the welfare of employee, they made a subsidiary company. Now, subsidiary company is made to avoid the welfare. Your intention is good or bad? Bad. So, law said that in this case, you avoided welfare by making a subsidiary company. We will not allow you. Both the companies are one and the same. We'll add up the profit and make the bonus payment. So, with this major part of company law is done. Okay, I hope you are understanding. Yes, so we are starting with now about contract and the law of relating to contracts. So with this, we'll understanding what is a contract. Understand here, friends. Contract means basically those understanding and those agreement whereby you can take the help of the court. If the any party breach the agreement, you have a right to approach a court. Very simple. If I buy a flat from the builder, if I buy a flat from a builder, then basically if builder do not give me the flat on time, if builder do not send up, give me the flat on time, such thing, can I go to the court and take the help? Yes or no? Yes. Similarly, if I buy a car and car is defective, can I file a case and take the action? Yes. But if I promise and to give birthday party to my friends and I don't give birthday party, so now they cannot file a case. So those understanding and those agreement whereby you can take a legal action, you can take a legal help, court will help you and to enforce the agreement, to apply the agreement, such agreements where court interference and court help is there, such understanding is a contract. Very clear. See, remove from your mind that contract is in writing on the stamp paper. If basically, if I'm talking about if everything is in writing, then small contracts will be very difficult. Like example, if I buy a ice cream of 10 rupees is also a contract. I understand it is a very small amount, but it is a contract because after consuming ice cream, if I am getting food poisoning, can I file a case against the ice cream shop or ice cream vendor? Yes, 100% yes. So guys, that is also a contract. If I'm buying 1 lakh rupees or one truck of ice cream is also a contract. See, practically people will not approach court for small amount. Practically people will not approach court for small amount contracts. That is very clear. But legally, can they approach? Yes, they can approach. But practically, they will not approach because it will take a lot of time and efforts. Okay. But that is also a contract where the court is ready to help you. See, if everything should be in writing, Then purchasing a Parle G will also be a difficult task. You need to SMS to the shopkeeper, give me Parle G. He will tell, okay, giving. Then you will Google Pay. So everything, hiring auto, you will tell, Bhaiya, please take me from location A to location B. He will tell, okay. But nowadays, with the help of technology, now everything is coming like an app, and the bill you also get, invoice you get. Like if I book Uber cab or Uber auto from destination A to destination B, that is in writing. I get a mail for that. If I pay 50 rupees, I get a receipt for 50 rupees. But that is not practically possible in every ways. So those agreement, there is an agreement between parties which which is an obligation, and there is enforceability by law. There is a enforceability by law. So I can write this way: agreement plus legal enforceability. Agreement plus legal enforceability is equal to contract. Agreement plus legal enforceability is equal to contract. So those agreement which there is legal action can be taken is contract. Very, very clear. Understand here. Are you understanding this? Yes or no, friends? Are you understanding this? So let us see the Bare Act. Let us see the Bare Law. And in Bare Act, we'll see Contract Act and what is the meaning written there. Okay. So this is Contract Act, and see Indian Contract Act 1872. Okay. So whereby let us come to section 2 subsection H. Those agreement which is enforceable by law. Court will tell you to take action. Court will help you is a contract. Very, very clear. Obviously, in those agreement, court will not help you. In those agreement, court will not help you is a void agreement. Is void. Court will not help you. Court will help you is valid, and court will not help you is void. Example, I promise to make a dead body alive, and you are ready to give me 20 lakh. You have already given the whole payment, 20 lakh rupees. Right, friends? You have given 20 lakh rupees, but I did not make a dead body alive. You approach a court, my lord, see, Mayur sir has promised to make a dead body alive. Please tell him to make the dead body alive. Mayur sir has promised to make the dead body alive. Please tell him to make the dead body alive. Are you understanding this? Now, court will help you or will not help you. What is the situation? Court will help you or will not help you. Obviously court will not help me. Such agreements which are not enforceable by law. See, understanding. Such agreements, first thing, those agreements which is enforceable by law. Enforceable by law is equal to contract or valid contract. But those agreement not enforceable by law, not enforceable by law is void agreement. Is void agreement. Are you understanding this? Are you understanding this? Those agreement not enforceable by law is void agreement, and those agreement enforceable by law is contract. Very, very clear. So understand here, agreement not enforceable by law is void, and agreement enforceable by law is contract. Are you understanding this? Yes or no? Yes or no? Yes or no? Yes or no? Correct. So those agreement where legal action can be taken is a contract, and those agreement where legal action cannot be taken is agreement. Are you clear? So agreement relating to social matters like giving birthday party, inviting on a dinner. Okay. So there is social matter, going for a walk in the evening. I called my friend, will you come for a walk in the evening? He said, yes, I'll be there at sharp 8 o'clock. 8 o'clock, I'm waiting for him. He's not there. Can I file a case? See, you promised to come by 8 o'clock, but you did not come. Can I file a case against him? No, that is social matter. Court will not interfere on these things. Suppose my cousin promised to show me movie. He promised that Sunday morning, afternoon 12 o'clock, we'll go for a movie. But Sunday afternoon he's not picking up my call. Can I file a case against him for not showing the movie? No. Answer is no. Very, very clear. So basically, those agreements which are those agreements which are of social matters, and those agreement between husband and a wife is basically not contract. So agreements which are not contract, let us understand. Agreements which are not contract, two things will come up. Two things will come up. Agreement relating to social matter, promise to go for a dinner, promise to go for movie, going for a walk, all these are legally binding or not legally binding? What do you think? Legally binding or not legally binding? What do you think, friends? Are legally binded or no legal binding? So no legal binding, it is social matter, and agreement relating to social matters and domestic arrangement between husband and a wife. Domestic arrangement between husband and wife. Understand here. There is a landmark case, that is Balfour versus Balfour. See what happened, and what happened. They Balfour versus Balfour. This husband and a wife, were working in Ceylon. That is Sri Lanka. And they went back to England. Example, for their vacations, because it was their hometown. Okay, so they were working in a Ceylon place in Sri Lanka. Roughly, I'm talking, and they are back to vacations at their hometown. But wife was not well, so already it was so many days they were in England. So husband said that you stay here, and I'll go back to work. Okay, you go back, I'll go back to work. I'll be sending you maintenance. I'll sending you some expenses. So wife said okay. Wife is staying there. Husband come back to Ceylon. Okay, but husband did not send the money for spending and living. Okay, which was over and above. Now tell me, wife filed a case against the husband. There was no contract between husband and a wife. Very clear, it is a domestic arrangement, and now wife cannot take a legal action as per contract. See, understand here. See, read this. Husband working in Ceylon had agreed in writing to pay a housekeeping allowance to the wife living in England. On receiving the information that she was unfaithful to him, he stopped the allowance. He was held to be entitled to do so. This was a mere domestic arrangement with no intention to create legal binding relationship, and therefore there was no contract. And therefore there was no contract. Balfour versus Balfour case 1919. Balfour versus Balfour case 1919. Are you understanding this? Yes or no? Balfour versus Balfour case 1919, and now the husband is not liable to pay the maintenance. Very, very clear. So with this, let us develop more things. For making contract, the first thing there should be offer. I should offer you something. You should offer me. There's the start of the contract. The first element to create a contract is offer, whereby under Contract Act, offer is defined under section 2A. Offer is defined under section 2A. When one person signifies his willingness and is expressing his willingness to do something or not to do something, to do something and not to do something, and when he signifies his willingness to another with the intention that the other person agree to it, assent to it, approve to it, such person is making proposal. Such person making proposal. I wish to sell my car to you. I come and signify my willingness to you that I want to sell my car. I wish to work with your company and not work with other company. So I am coming and telling that I wish to work with you and not with the other company. Please keep me at the job. So now I am telling that with the intention that you agree to it and we come into a contract. Now this person has said to made a proposal. So what is section 2A? Read this. When one person signifies to another his willingness to do something or abstain from doing anything, with what view, with what intention, with a view to obtain the assent of the other, such act or abstinence he is said to make a proposal. Such act or abstinence he is said to make a proposal. Again I am repeating. See, read it when you are also along with me in your respective whoever watching it. Okay, watching live. You have to read there loudly at your place from wherever you are watching the lecture. Okay. When one person signifies to another his willingness to do something or abstain from doing something with a view to obtain the assent of that other of such act abstinence, he is said to made a proposal. He is said to made a proposal. Understand here? Okay. So now, suppose example, I offer you to sell my car. I offer you that I want to sell my car to you for 5 lakh. I am offerer and you are offeree. Person making offer is offerer and the person to whom offer is made is offeree. Really speaking, in law earlier we used to use the word proposal, proposer, proposee, proposer, proposee. But same, it is same to offer, offerer, offeree, proposal, offer, proposal, offer. Do you understand? Now my question to you is, Amitabh Bachchan is offering to sell his BMW car to Jaya Bachchan. Who is offerer? Put in the comment section. Amitabh Bachchan is willing to sell his car to Jaya Bachchan. Who is offerer? Yes, Amitabh Bachchan. Correct. Neha correct. Neha, both Neha correct. Sudiksha, Harshit, Amitabh Bachchan. And who is offeree? Who is offeree? Jaya Bachchan? JB? Okay. That is Jaya Bachchan ji. Okay. So now there are certain things while you are going for offer. See, first thing, let us understand what we have done till now. First, what is offer? Offer is in section number 2A. Now, who is offerer? Who makes offer? And who is offeree? To whom offer is made? Very, very clear. Now, there are rules regarding offer. There are rules regarding offer. Let us discuss one by one. There are certain rules which we should know. Okay, that is regarding offer. Let us discuss one by one. Okay, first thing. Suppose I am selling oil. I am selling sunflower oil, sesame oil, groundnut oil, soya oil, different types of oil. And I put a board, oil at 100 rupees liter. Now tell me friends, I am giving an offer and I am telling 100 rupees liter, but the offer does not tell which oil this 100 rupees liter is. Whether it is a soya oil, sunflower oil, groundnut oil or sesame oil. So tell me friends, in a very clear fashion, in a very clear understanding, this offer is what? Clear or unclear? My question to you is, I am offering oil 100 rupees liter, anyone can buy it. Okay, so it is available. So my offer is clear or unclear? It is unclear. It is uncertain. Suppose example, Mahesh Bhatt comes with, just example out of just fun. Mahesh Bhatt comes with Katrina Kaif and Alia Bhatt at our place and tells to my father that example, I want your son for the marriage. I want one of the person for the marriage with your son. Now we are confused. He is telling about which? He is talking about Katrina or Alia Bhatt. Okay. Or I have 5 cars. Suppose example. red, green, blue, yellow. I'm telling I want to sell the car for 10 lakh rupees. Which car I'm talking about? Red, green, blue, yellow? I don't know. Clear cut. So this is uncertain. Whenever you are talking in the commercial world, talk very clear. Your offer must be very clear, definite, and not confusing. It should not be vague. It should not be confusing. It should be very clear and crystal clear when you are talking about. Okay. And very important thing. Understand, it can be either expressed or implied. It can be either what? It can be what? Either expressed or it can be implied. Sir, express means by words. Words can be oral or written. And implied is by conduct, action. Sir, example, see, when I am ordering that please deliver 5 kg wheat at my place, it is by words, oral. When I put a mail, to the company, please send 10 iPhones. It is, oral, and it is by words and it is written. Obviously, which is suggestible, oral or written? Oral or written? Tell me, what is better? Obviously, written. Obviously, written is better. But guys, can law compulsory make everything writing? No. Many people cannot read and write. Many people will find it difficult. Like an auto fellow may be educated or may not be educated. Okay. If he is not educated, it will be very difficult for him to forget everything in writing. He understands orally best. So for such people, like example, my friend is asking 1000 rupees. Okay, oral contract. He is asking 5 lakh rupees. Well, wait, come down. Let's get a stamp paper and sign the same. So when it is small amount, you go for oral, and when it is a big amount, you go for written. Both are allowed, but preferable is written. Preferable is written. And next, implied is by conduct. Example, when I go to a tea stall, he just keep tea. If we three people are standing, he'll keep 3 cups of tea. We pick up the tea and start drinking. There was no conversation. And he's put a board. Okay. So now we'll automatically pay 30 rupees for the tea. This is by conduct. Automatically, by behavior, by action. Coolie fellow. When you get down the railway station, he picks up your bag and now he's walking. You are walking behind him. So that is what implied contract, which is by conduct. So offer can be express offer, offer can be implied offer. Offer can be express, offer can be implied, offer can be by words, which is express, words can be oral or written. Words can be oral or written. Do you understand this? So with this, read this paragraph. See, offer must be certain, definite and not vague. An offer must be clear, definite, complete and final. It must not be vague. For example, a promise to pay increased prices for the horse if it prove lucky. What do you mean by prove lucky? I am ready to pay you more price if the horse prove lucky. What do you mean by prove lucky? It is very vague. Okay. So this is too vague and it is not binding. Similarly, offer can be express or implied. The communication of offer may be expressed, that is oral, or written, which is implied, or it can be implied by the conduct of the parties. Very clear. It must be communicated. See, I'll give you an example. Unless until you don't communicate, how the party will accept it? Example, I'll just give you one of the example. Suppose example, on my floor, there are 4 flats. This is a floor. Flat number A, B, C, D. We stay in flat number A. Okay. And we are shifted to the new place. Now, adjacent neighbor, we offer them, will you buy our flat? Because now you can remove this wall and make this flat a big one. Getting my point? So what is happening here? We offered our flat A to the neighbor who stays in B. C comes and tell, done, I am ready for the flat. Now, did I offer and did I communicate the offer to C? Tell me, yes or no? offer is being made to B, but C comes and tell done, we are ready to buy, and he's giving the cash. Offer must be communicated, then only acceptance will come. Offer is not communicated, will acceptance allowed? Can C accept the contract? Tell me yes or no. Can C accept the contract? Yes or no? Answer is no. Very, very clear. Guys, so understand here, what is the point? Offer must be communicated. An offer must be communicated to the offeree. Offer becomes effective only when it is communicated to the offeree so as to give him an opportunity to accept the same or reject the same. And a similar fashion, offer can be general offer or specific offer. Offer can be general or specific. Sir, how general, how specific? Example. This flat example only. We are staying in A flat and we offer to B. We are ready to sell the flat to A. We offer to sell the flat to A and C come and accept. Offer is made to B, only B can accept or reject it. Can C come and accept or reject? Is offer specific or general here? What do you think? Is offer specific or general? Yes, guys, it is specific. When it is made to a specific individual or group of individual. Example, there is a plot, okay, which belongs to A. Now, A offered this to a group in which they are friends B, C and D. When offer is made to a group B, C and D, it is specific offer. When offer is open to anyone, that whoever finds the lost dog will get a reward of 1 lakh. Whoever finds my lost dog will get a reward of 1 lakh rupees. Now tell me, this is what offer? Which offer? Specific offer or general offer? That is general offer. Anyone, it's a large public. When offer is made to the large public, it is general offer. It is general offer. So offer is majorly of two types. See, there can be more types, counter offer, cross offer, but that is not in your curriculum. Okay, that will come up. So offer can be specific offer and offer can be general offer. Specific offer to a particular person. To particular person. And general offer is open to all. Anyone can come and accept. Very, very clear. So now with this specific offer, general offer, this is done. Now when does offer come to an end? Example, I have offered you that, will you buy my car? Tell me your answer within 10 days. Now you did not communicate anything in 10 days. On the 11th day, offer will lapse. Offer will come to an end. Or I offered you that I want to sell my flat. Give your acceptance. Give your decision on email. You have communicated your decision on phone call. I have made an offer to you. Will you buy my flat for rupees, example, 50 lakh? Whatever your decision is, communicate on email. I want acceptance on email. You have accepted on a telephone call. Is it a valid acceptance or a wrong acceptance? Tell me. Is it a valid or invalid acceptance? Please comment. Yes, it is invalid. Now automatically my offer come to an end. I offered you, will you buy my car for 5 lakh? You said no, I don't want to buy. You rejected the offer. Now offer is lapsed or offer continue? Offer is lapsed. You simple, I am telling example again. I offered you to, will you buy my car for rupees 5 lakh? You have rejected it. Now offer will continue or offer will lapse? Offer will lapse. It will come to an end. Suppose example, Ramlal offered to sell his flat to Shamlal. Now Shamlal did not communicate anything, but Ramlal dies. ना रहेगा बास ना बजेगी बांसुरी. There is no offerer, there is no offer. Or Shamlal dies, there is no proposee, then no offer. Very clear. So any of the party dies, that is very, very clear. I again offer come to an end. I give you offer that will you buy my car for 5 lakh? You said I will buy your car for 5 lakh provided you give me accessories free. I said will you buy my car for 5 lakh? You are telling that I will buy your car provided you give me accessories free. Now you have made a new offer. I made an offer. Against that, you have made a new offer. Such new offer will be called as counter offer. Such new offer made by you with changes and modification is called as counter offer. Example, I go for a mobile shop, for a mobile shopping, and the store is telling that we are ready to sell the phone for 30,000. I said I will buy at 30,000 provided you give me headphones, earphones free. Then only I'll buy it. So now the shopkeeper has to decide whether he's ready or not ready. So when someone makes offer, against that new offer is made. Such new offer is made with modification and changes is called as counter offer. With the counter offer, what was the original offer comes to an end. Example, I said that will you buy my car for 5 lakh? You said I will buy it provided you give accessories free. So my offer come to an end and now there is a new offer by you, that is counter offer. That is a counter offer, and acceptor has failed to fulfill certain conditions. Acceptor have failed to fulfill certain conditions. Sir, what do you mean by that? Understand here. Acceptor have failed to make the fulfill the certain conditions. What are the conditions we are talking about? Understand here. Acceptor have failed to fulfill certain conditions. Suppose example, I said that I am ready to sell my flat provided you get two known people who will take your guarantee. Now you are ready to buy, but you do not get two known people who will give your guarantee. So offer will continue or offer will lapse. Again I am repeating. I am offering you, will you buy my flat for 50 lakh? And if you want to buy it, get two known people who will give your guarantee, who will assure your money. Now I have put a condition that you have to get two guarantors. You have to get two guarantors. Now what happened? You are ready to buy it, but you did not get the guarantors. You failed to fulfill my condition. You failed to fulfill my condition. Guys, now tell me, offer continue or offer lapse? What do you think? Yes, offer will lapse. So what are the cases? What are the cases where lapse of offer takes place? The first case is, if I'm talking about not accepted within reasonable time or specified time. You did not accept it within the time which was mentioned. Offeree rejects the offer. Okay. Then offeree fails to fulfill the condition. Fails to fulfill the condition which is required precedent of acceptance, before acceptance. Offeree did not accept within reasonable time. Oh, sorry, did not what accept within prescribed, or just hold on, did not accept in prescribed mode. What mode I said? Email, right? Same way, offeree makes counter offer and either offeree or offerer dies before acceptance. Okay, my question to you. If Ramlal offered Shamlal, will you buy my flat for 50 lakh? Shamlal said, I will buy it. After 3 months, I'll make the payment. and next day Shamlal dies. Is there a valid contract? Yes or no? Is there a valid contract? Yes or no? My question to you is, Ramlal offered Shamlal, will you buy my flat for 50 lakh? And Shamlal communicated, yes, I will buy it and pay the payment after 3 months. Now, next day Shamlal dies. Is there a valid contract? Yes, there was acceptance. Now, legal representative need to fulfill the contract. Now, legal representative will make the payment and buy the flat. Are you able to get this? So, yes, there is acceptance. If he dies before acceptance, then no contract. If he dies after acceptance, then there is a valid contract. Then there is a valid contract. Are you understanding this? Okay. Now let us come to acceptance. What is acceptance? When other party gives his assent, when other party gives his approval, when other party agrees to the offer, when other party give his consent, assent, then such party has approved or accepted the proposal, and now it has exchanged into promise. I promise to give car, you give promise to pay money. Okay, now it is into promise. So acceptance is defined under section 2, subsection B. Let us understand this. What is acceptance? Acceptance is when the person to whom proposal is made, the other party that is offering, signifies his assent in that regard. The proposal is said to be accepted, and now it converts into promise. I promise to give car, you promise to give money. Now it is converted into promise. Very, very clear understanding. Okay, so now that is section number 2B. There are certain rules regarding acceptance also. Understand this. Let me give you one by one rule. Okay, let us discuss that. Okay. Rules regarding acceptance. Rules regarding acceptance. Okay. So the understanding is that first rule, acceptance can also be what? Acceptance can be expressed or implied. What is expressed? By words, implied by conduct. Suppose example, my client mailed me, will you do the audit? I replied to the mail, yes, I will do. So that is express. And that is by words. Suppose at the tea stall, the tea vendor keep a cup of tea. I pick up the tea and start drinking. That is implied by conduct. I accept to pay for the tea. Are you understanding this? Then obviously it acceptance must be in prescribed mode. So what do you mean by prescribed mode? I said that. See, once there was a incident. I was called by one of the client. They were husband wife and doctors. Both were doctors and running a clinic. They said me, sir, you come and visit our place once a month and some amount will pay to you. Suppose example, we'll pay you 80,000 for a year. Plus come us and please come down and guide us in this regard. I said, okay, no worries. Now what happened in that case, understand. So now in that case, I have done the whole work for the whole year. Now while at the time of giving the fees, they said, sir, it was 60,000 rupees decided. Yes, sir, it was 80,000. Now I was in a dilemma what they are talking. But they were two people and I was one and all professionals. So majority wins. Next year they called us, sir, please come down and do the consultation. I put a mail, I offer you to provide the service at 1 lakh rupees. If you are willing, please communicate your decision on email. Please communicate your decision on email. That doctor called me, sir, please come down and work. We are okay with it. No, sir. Please give your acceptance on email. That is important. If you give your acceptance in any other mode, that is not a valid acceptance. That is not a valid acceptance. Getting my point? then that it must be in a particular mode. It must be in a particular mode. Very clear. Then acceptance must be absolute and what? Unqualified. What do you mean by absolute? Acha, question to you. Can acceptance be conditional acceptance? Yes or no? Please answer. Can acceptance be conditional acceptance? Yes or no? Put in the comment section. Those who are watching live, come on guys, you have to put. And those who are watching afterwards, then put in the comment section. Can acceptance be conditional acceptance? Some are telling yes, some are telling no. Answer is no. Example, I am ready to sell you car for 5 lakh. You said yes, I am ready to buy for 5 lakh, but I want accessories free. You put a condition. Now guys, it is you accepted for 5 lakh, but you want accessories free. Now this is acceptance or it is counter offer. It is acceptance or it is counter offer. What do you think? It is counter offer, right guys? So it is a counter offer. So acceptance is absolute. Yes. Yes, but I want accessories free is counter offer. Conditional acceptance leads to counter offer. Conditional acceptance leads to counter offer. Very, very clear. So you should basically what? Conditional acceptance lead to counter offer. Don't give conditional acceptance. If you give conditional acceptance, that is equivalent to counter offer. Then obviously it must be communicated. Mental acceptance inside, someone is telling you, will you buy my car? You are smiling. My smile is my acceptance. No, no. You must communicate your acceptance very clearly and within time. Okay. So that is very clear. Fourth point, acceptance must be communicated and acceptance must be within reasonable time. Time period. If they are telling, tell your decision within 10 days, then 10 days. Tell within 10 days. If you are telling on 15th day, understand here. Example, Shah Rukh Khan is being offered a film and said, please let us know your decision within 15 days. Shah Rukh Khan communicated decision after 4 months. They have already hired another actor for it. Already hired another actor for it. So that is basically what? Now Shah Rukh Khan acceptance is not valid because it is not within the time specified. Sir, if no time specified, then it must be within reasonable time. And what is reasonable time is decided by the court from background, situation to situation, it differs. In some case, it may be 1 month, some case it is 2 years, some case it is 6 months. Court will decide what is reasonable time. Did you communicate within reasonable time or not? Very, very clear. And a similar fashion, if I'm talking about very, very clear, can you give acceptance first and then there is offer? No. First, always there will be offer and then followed by acceptance. These are the certain rules regarding acceptance. Please read it for 1 minute. Any query here? Is everything fine? Okay. So acceptance must be expressed or maybe expressed or implied. Okay, can be expressed by words, implied by conduct. It must be given in that mode which is specified. Acceptance must be absolute, not without conditions. Acceptance must be communicated. Acceptance must be within reasonable time and it cannot proceed offer. Very, very clear. Now let us go with some concepts like nowadays lot of people deal on telephone. You are across some country and you are here and you deal over a telephone and you contract over a telephone. Yes or no, friends? Very commonly. See, on a telephone, it is obviously by words, but is it written or oral? It is obviously you discuss a lot of things, you negotiate over a phone. And tell me, like nowadays, you meet in person and negotiate, and you meet on a telephone and negotiate is almost the same. You discuss on a telephone or you in person meet and discuss is almost the same, but offer on a telephone and acceptance on a telephone is oral or written. It is oral, very, very clear. But it is very important that while accepting, you must be very clear, audible, and very clear communication. There must be there for acceptance. If while talking and you have accepted and the call has cut, nowadays a lot of range issue, the call has cut, then it is the responsibility of the acceptor to confirm with the other party what you have heard about, or was the communication clear, did you understand it. So whenever you are communicating on a phone, cross confirm it, cross check it whether the other party have listened to you or not. See, it may happen that call is dead, call is network issue is there, but whoever is communicating acceptance must get it confirmed that whether his acceptance was clear or not. That is very, very clear. Are you able to understand? And now if you cross confirm, sir, did you get my point? I'm ready to buy it. Yes, I'm ready to buy it. If you repeatedly ask it and there is a confirmation made, that amounts to a valid contract. That amounts to a valid contract. Let us read this. Let us read this. Contract over telephone are regarded the same as negotiation in actual presence of each other. Whether you are meeting one to one or you are on telephone is one and the same. In both the cases, there is oral offer is made and oral acceptance is expected. It is very important that acceptance must be audible, heard and understood by the offerer. It is very important that acceptance must be audible, heard and understood by the offerer. If telephone go dead during the conversation, telephone lines go dead and the offerer does not hear the offeree word, there is no contract at the moment. If the whole conversation is repeated and the offerer hears and understands the words of acceptance, the contract is complete. This happened in Kanhaiya Lal versus Dinesh Var Chandra. That is, this case. Very clear. So this was a short paragraph about what called as contract over telephone. Just read it faster. Okay, now let us proceed. So this was a short paragraph which is talking about, that is very clear, contract over telephone. I am repeating again. If phone goes dead, whose responsibility to cross confirm the acceptance? Tell me. If phone goes dead, it is whose responsibility to cross confirm the acceptance? Not offerer, offeree. Those who's communicating acceptance. How offerer knows it? Offer may think he has rejected. Okay, it is the responsibility of the offeree to cross confirm it and confirm with the offerer. Are you getting this, Anisha? Is this clear? So now let us proceed. Now there is a concept which is called as privity of contract. Now we are talking about privity of contract. Let us understand this. Let us understand this and let us clear this. Okay. Okay. Privity of contract. What do you mean by privity? Privacy. Suppose there is a contract between A and B. Can C file a case in this contract? Yes or no? If there is a contracting party A and B, can C take a legal action? Yes or no? Answer is no. That is basically, if there is a contract between Tata's and Reliance, can Mayur Agarwal go and take action against Reliance? Or can Mayur Agarwal go and take action against Tata's? No. Only the contracting party have a right and to take action. That is called as privity of contract. That is called as privity of contract. But guys, in certain cases, the contract is between A and B, but third party can take action. That is called as exception. That is called as exception to the privity of contract. Let us discuss one by one. Let us see this. First, stranger to the contract. Who is a stranger? Who is not a contracting party will be called as stranger. Who is not a contracting party will be called as stranger. Stranger to the contract cannot sue both under English law and Indian law for want of privity of contract. Let us take example. Dunlop Pneumatic Tire Company versus Selfridge Limited 1915 case. See what happened in this case. D supplied tires to X on the condition that any retailer to whom X resupplied the tire shall not sell them below D's price list. See what is happening. D supplied tire to X and to whosoever he is selling A, B, C, they should not sell below the price what is given by D. Suppose he is selling 1000 rupees per tire. Don't sell below 1000 rupees per tire. Now D sold to X, X sold to A. A is selling. A is selling for 900. A is selling for 900. Now D filed a case against A. Who will win the case? D sold to X and X sold to retailers ABC, and he is putting a condition on X that no one should sell below 1000 rupees. Now A is selling for 900 rupees. Who will win the case? What is the situation? Tell me. See, this condition was between D and X, and there is a separate contract between X and A. X and A. Understand? I am repeating again. There is one contract between D and X. There is another contract between X and A. So in this contract, X and A, can D interfere? Yes or no? Can D interfere? Yes or no? Answer is no. Privity of contract. See this. See, there was a contract between D and X and S. Okay, X and S. Now, in this situation, therefore, D could not obtain damages from S as D had not given any consideration for S to X, nor was the party between D and X. So, there is no relation. Very, very clear. So, in short, as per privity of contract, if the contract is between A and B, C cannot interfere. That is the whole situation. Now, consideration can be past, present, future. Consideration can be past, present, future. This you can get an idea from the definition. How? I'll show you the definition. Section 2, subsection D. See the sentence. Has done or abstain from doing, or does or abstains from doing, or promises to do or abstain from doing. has done or abstained from doing, or does or abstains from doing, promises to do or abstain from doing. This sentence is telling past tense, present tense, future tense. Are you getting this? Are you yes or no? Has done or abstain from doing, or does or abstain from doing, or promises to do or abstain from doing. It means that consideration can be past, present, future. I'll give an example. Already my cousin A is having 80,000 rupees cash which belongs to me. One day he got iPhone. I said, this iPhone I am keeping. Bole, then money. Bole, already you have my advance. Already I have given you advance 80,000. Correct. Some money is with you. So this is which consideration? It is a past consideration. It is past consideration. My cousin get the iPhone. I took the iPhone and paid him the cash immediately. That is present consideration. And I have taken the iPhone and I promised that I will pay after 3 months. That is future consideration. Are you getting my point? So consideration can, which is already advance given, is past. Money paid now is present. Will be paid is future. Consideration can be past, present, future. Are you getting this? Yes or no? Now, there are certain rules regarding consideration. See, is this clear? Can we write this way? Consideration can be past, present, and future. Okay. That is basically what? Past consideration. Second is present or executed consideration, and future or executory consideration. Okay, consideration can be past, present, future. Very, very clear. Do you understand this? Now, let us come to certain rules. What are the rules regarding consideration? First thing, I promise that I will bring stars from sky. Chand tare tod lao. Correct hai. Pay me 30 lakh rupees. Now, suppose example, Anisha is telling, sir, you are joking. I know you will not do it. Well, I can get it. I will write on a stamp paper and sign and give it to you. Well, sir, still I don't believe it. Well, okay, don't give me 30 lakh today. Give me 5 lakh today and remaining 25 lakh when I deliver the stars. Now tell me, oh, well, now this is possible. She has paid 5 lakh. I signed a stamp paper, but I did not obviously give the star. Anisha filed a case against me. Now tell me, is this consideration real or imaginary? Is this consideration real or imaginary? It is a consideration, real or imaginary? Yes, Harshit, it is imaginary and not real and not enforceable by law. Same way, if if there is one-sided contract, see, when you enter into contract, like you have joined coaching, so you promise to pay the fees and coaching provide you such services, right? So now obligation is one-sided or both the sided? Tell me. Obligation is one-sided or both the side? You decide to buy a flat from a builder. Builder is ready to give you the flat. It is builder's obligation. And your obligation is to pay the money. Obligation is one-sided or both the side? It is both the side. Very, very clear. So when in a contract, there is one side obligation. There is nothing in return other. See, every commercial world, consideration means give and take policy. I will do something for you, give me this. You do something for me, I will give you this. That is give and take policy. If it is one sided, obligation and nothing, other party is getting nothing, or the party is not getting anything, that is a valid contract or not a valid contract? Tell me, friends, that is a valid contract or not a valid contract? Valid contract or void? Tell me. My question to you is that, my question to you is that if it is one-sided obligation, he is not getting anything in return. In the commercial world, he is doing one-sided promise. It is a valid contract or not a valid contract? Simple, suppose example, one student approached me 2 days before exam. Please, sir, please help me and please give me an idea. Please, I was not well, I was hospitalized, but I want to give exam. I said, okay, come down. He is not taken admission, but out of just help and I want to teach him. So I said, come to my office for 5 hours. I'll teach you every day. I tried to complete 60%, 70%. He cleared exam, but he got less marks. Now he's filing a case against me. My lord, see, Mayur sir have taught me, I agree, but he has taught me only 60%. Now tell me, I did one, there was one side obligation to teach him, but did I get anything in return? Did I get anything in return? It was one-sided obligation? No. So can he file a case against me? It is not a commercial contract, right? It is not a commercial contract, right? Yes, that is a rule. An agreement which is made without consideration is void. No consideration, no contract. I taught one student free of cost, no consideration, no contract. Are you understanding this? No consideration, no contract. Very, very clear. See, every simple contract must be supported by valuable consideration. Otherwise, it is void, but there are certain exceptions. Everything in the commercial world should have a give and take policy. If it is only give policy, not take policy, then it is void. But there are certain exceptions where there is only give policy and not take policy. Are you understanding? Are you understanding this? Yes or no? Obviously. So it means it is mutual. Every party have to do something for each other. Mutual. I do something, you do something. It is mutuality. Each party must do or agree to do something for each other. If it is gratuitous, one-sided, then it is not a valid contract. Very, very clear. One more thing, consideration can be positive or negative. Positive means to do something. Negative means to stop doing something. Positive means to do something. Negative means to stop doing something. I'll give an example. I promise that I will work with you. Is a positive. I promise that if I work with you, I will not work with competitor. I will not work with the competitor. That is positive or negative? That is positive or negative? Tell me. That is positive or negative? Not do something. Yes, it is negative. When you see the definition also, when you see the definition also, I'll tell you how. When you see the definition also of consideration, okay. So in that definition also, that is section number 2, subsection D. Section number 2, subsection D. What is section number 2, subsection D? Okay. When at the desire of the promisor, see the word, has done or abstained from doing. To do something and not to do something. Or does or abstains from doing. To do something or not to do something. Or promises to do or abstain from doing. Positive or negative. Very, very clear. So here understand, very clear, consideration can be act or abstinence. Is a positive thing or negative thing. Again, tell me, can I sell 1 crore flat for rupees 5 lakh? Yes or no? Can I sell 1 crore flat for rupees 5 lakh? Yes or no? Anisha is telling no, sir. Neha is telling yes, sir. Neha CS. What about others? Swastik is telling yes. Yes, guys, law is not telling how much it should be. Law is telling something should be there. Something, see the definition. When you see the contract act and when you see the definition, see, has done or abstain from doing, or does or abstain from doing, or promises to do or abstain from doing something. Something means it should be something. It can be 5 lakh rupees. I can sell 1 crore rupees flat for 5 lakh, or I can sell 1 crore rupees for 5 crore. Law is not interfering in your negotiation. Law is telling it should be something. Then only will help you. If it is free of cost, then we are not liable. Okay. So it should be something. So it need not be sufficient. It need not be adequate. You can sell 1 crore flat for 5 lakh, or you can sell 1 crore flat for 5 crore. Very, very clear. So consideration need not be adequate. Also consideration some value, but it not be adequate. It need not be full return for the promise. Read this. Read this. It should be something. So guys, it need not be adequate. It can be anything. Very, very clear. Are you getting this? Again, I said, give me 10 lakh rupees, I will kidnap A. You have given me 10 lakh rupees, I did not kidnap A. You file a case against me in the court of law. You said, my lord, see, Mayur sir has done breach. He promised to kidnap A. Law will tell, my lord, first you go inside jail, then we'll talk. Tell me, for 10 lakh rupees, 5 lakh rupees, what is the consideration? Lawful from my side or unlawful? It is legal or illegal? It is legal or illegal? What do you think? Yes, guys, it is illegal. Understand? So consideration must be something which is lawful. And there is one more point which I'll explain. But before explaining this, let us write down important what all we have discussed. Rules regarding consideration. Rules regarding consideration. Rules regarding consideration. The first rule is no consideration. Then the court will not help. That is no contract. Do you agree to this? No consideration, no contract. But there are certain except certain there are exceptions are there where you can file a case. Then what? Consideration can be positive or negative. Consideration can be positive or negative. Consideration is mutuality. Both the parties must do something for each other. Must be real and not imaginary or illusionary. Okay. Must be very clear. Consideration need not be adequate. Need not be sufficient. Consideration must be lawful, and consideration must be something. Last point which I'll explain, don't worry, more than the promisers. I'll explain this point. Promisers existing obligation. Guys, understand here? No consideration, no contract, court will not help you. Consideration can be positive or negative. It is mutual, give and take. Real and not imaginary. Consideration need not be sufficient. Need must be lawful. And the last point I'll explain, but read all these rules. Okay, guys. I hope everything is clear till now. Are you understanding? Are you doing it? Are you reading it? Yes or no? Yes. What is the last point? I'll ask you a question. Suppose example. There is a ship coming all the way from US to India, and in this ship there is one captain and 18 sailors. Two sailors are on holiday. Out of 20, 18 are present and two are on holiday. Now ship is going through high tide and huge wave and it is under a threat. Captain called a meeting urgently and captain said, "My sailors, we have to fight for 3 days and let us safely reach the ship to India. 3 days we cannot sleep. We have to do the hard work and we have to save crores of goods. We have to save crores of worth ship and our lives as well. But I promise you to give the salary of two sailors who are on holiday. If you save the ship, I will distribute the salary of two sailors among you friends." All the sailors got motivated. They started working and they did not sleep for 72 hours. Only 1 hour of sleep in the whole 72 hours. But and they safely reached the ship to Indian port. They celebrated the victory. And now all the sailors are calling the captain to ask for the salary which he promised. Captain denied to give the salary because he is not having money. 18 sailors filed a case against the captain. Who will win the case? This is the question. Who will win the case? Please tell me. Yes, it is the sailors or the captain. Tell me, who will win the case? Harshit is telling sailors. Fatima is telling sailors. Other, those who are watching it live again, tell me. There is again sailor. See, many are telling sailor. Understand here, sailors are duty bound to save the ship. Sailors are duty bound to save the ship, whether they get the extra salary or don't get the extra salary. So they are asking extra salary for what work? What they have given in return? They have given in return to save the ship. That is their duty. Whether the captain promised them or do not promise them. But are they duty bound to save the ship? Tell me yes or no. Are they duty bound to save the ship? Yes or no? Answer is yes. So it is their responsibility. Can they ask extra money for it? See, if captain wish to give, can give. But can they force the captain to give the extra money? Answer is no. Understand. One more case I'll take. I hire an advocate for a case. I asked advocate, what are your fees? He said, I want 3 lakh rupees. I said, okay, done. I'll give you 3 lakh. And if you win the case, I'll give you 2 lakh. Now advocate is happy. 3 lakh fees and 2 lakh if he win the case. Now he worked harder. He helped me to win the case. But now what is happening here in this situation? Understand what is happening here. Ki I have paid him 3 lakh only. He is asking more 2 lakh. See, he is duty bound to win the case. Whether I give him 2 lakh or don't give 2 lakh. I have given him the fees to win the case. I wish to give more 2 lakh. I will give it. He cannot demand me legally. So that is for 2 lakh rupees. What is the he is done for me? Win the case. Are he was duty bound. So that cannot become a consideration to demand 2 lakh rupees. Sailor were duty bound to save the ship. They cannot demand the salary, extra salary for the same because they are duty bound. So what is the promisor's existing duty? What is the promisor's existing obligation? Is consideration or not a consideration? Tell me. Is consideration or not a consideration? Cannot be consideration. Cannot be consideration. Very, very clear. So these are the certain rule where there cannot be consideration. But we have talked about one rule. The one rule was no consideration, no contract. Are you getting this? No consideration, no contract, but there are certain exceptions. Exceptions means no consideration but still a contract. Exception means no consideration but still a contract. What is the exception? Understand? Exception means no consideration but still a contract. What do you mean by this? See, what is the general rule? No consideration, no contract means you cannot file a case. But exception, in case of exception, the opposite the rule, no consideration, still there is contract. No consideration, still there is contract. Do you understand this? No consideration, but still there is contract. There are certain exceptions. Are you listening? Are you there? Please tell me. Yes or no? Yes. So what are the exceptions? We'll talk one by one. What are the exceptions? We'll talk one by one and understand it. Just hold on. What are the exceptions? I'll talk. Okay. The first exception here is will. Contract made out of natural love and affection. Will contract. When anyone is like, he is deciding that after my death, my property should be given to my son, my daughter, my wife. That is will. So that will is one-sided. Is he getting anything in return? Tell me. That will is one-sided. Is he getting anything in return? Tell me. Yes or no? No, no, correct. So what are the exceptions? The first exception is contract out of natural love and affection. Guys, understand. Listen, here the example will come will, which should be in writing, which should be in writing and registered, which should be in writing and registered. The will contract is contract out of natural love and affection. Very, very clear. So what is my point here? Out of will contract, okay, understand here, contract out of natural love and affection, which is will, it is one-sided, but still, now if suppose father has written a will in favor of son, now others are claiming right in the property. Can the son tell that there is a valid contract and I will get the property, and can he fight for the property? Yes or no? Yes. Even though this is one-sided obligation by the father to the son, but still, even if father is not getting anything in return, but still there is a valid contract. Second, if I'm talking about completed gift, completed gift. If someone has gifted, do you gift in expectation of return? That I'll gift you a flat, give me Lamborghini car. No, gift is one-sided. Once gifted, it is a valid contract. The other party can keep the gift and you cannot take it back. Suppose example, one day my father is very happy. He gifted me gold chain. Now there is a small fight, political debate. He's angry. He said, give my gold chain back. One, it is gifted, you cannot take it back. It is a valid contract, even though it is one-sided, but there is still a valid contract. Then promise to pay time barred debt in writing. What do you mean by time barred debt? Tell me, friends. Those debt which is due for more than how many years? 3 years. Those debt which is due for more than 3 years, outstanding for more than 3 years, is called as time barred debt. Okay. And after 3 years, legally you cannot file a case and recover money. Legally you cannot file a case and recover money. Sir, why? There is a deadline. Court is not open for 20 years, 25 years. Your money is due from 1990 and now you go and file a case after 20, 25 years. Will the court entertain you? No, there is some deadline to go to the court. Once you leave that deadline, that 3 years deadline, now court will not help you. You cannot legally recover the money from the party. Do you understand this? Everything about this is written in Limitation Act 1963. Everything in this is written in Limitation Act 1963. For what time? What is the deadline? I'll show you. See, in the end you go, there is a schedule, and in the schedule, if you see this, there is a schedule whereby they have written, see, 3 years, 3 years, 3 years, just an idea, 3 years. For immovable property, it is 12 years. For immovable property, it is 12 years, but generally it is 3 years deadline to approach a court. Understand here. See, suppose example, my father, some money was due in 1995. Many people did not pay him the money. He's thought that let us not get disturbed, let us focus on the work. He did not take any recovery action. Now in 2020, 21 or 22, he is planning to file a case. Can he file a case and recover the money? Tell me yes or no. In 2020, 21, he want to file a case and recover money. Can he file a case and recover money? Yes or no? Tell me the answer. Come on, friends. Yes or no? Answer is no, because it is time barred debt. After 3 years, court will not help you legally. 1995 case, 1998, you should go to court. Why did you not come now? And after 25 years, you are telling court, help me. Court will not help you. Very clear. So, sir, certain loans are of 20 years. Then the due date will be 20 years plus 3 years. 3 years is counted from the due date. Are you understanding this? Now, still there are certain good people who are like, let me pay the money. Like example, I'll tell you. One of my friend's uncle has taken money from his father, but was not able to pay the money for 20 years. But after 20 years, he felt that let me clear the money because I want to clear my all my obligations and be free-minded. After 20 years, he himself come down and give a check in writing. So legally, he was not liable to pay the money, but now he himself is creating the obligation. Now legally, my friend cannot recover the money from his uncle, but now uncle himself is coming down and writing down in giving a check in writing and promising to pay all 20 years back debt. Now court and law was already have given you an excuse, but you yourself are now creating obligation. Now this obligation, even though it is one-sided, now even if it is one-sided, now there is a valid contract, you are liable for the check. If the check bounce, can you file the case against the uncle? Tell me. If the check bounce, can you file a case against the uncle? Tell me yes or no. Can you file a case? Uncle, there is a time bar debt. Uncle has promised in writing. Now legally he was not liable, but now he himself given in writing. Now there is a legal obligation. Yes, you can file a case and recover money. Yes, you can file a case. See, earlier he was not liable, but he himself has given in writing that he will pay the money. He himself has given in writing that he will pay the money. Now he is legally liable. Now he is legally liable to pay the money, even if it is one-sided obligation. He is liable. Very clear. Agent. Agent works for commission or without commission? Tell me. Agent works for commission or without commission? Agent works for commission or without commission? What is your answer? For commission. There are certain answers like for commission. What about others? See, they can work for commission or without commission. Who is agent? Who is representing someone else? Commercial agent will work for commission, but there are people who will not work for commission. Example, suppose example, my sister is in Mumbai, I am in Pune. She is having one flat in Pune. Now she has appointed me and given the rights, power of attorney in my name. Now I go and attend her society meeting. I pay maintenance. I collect rent. I appoint tenant. I enter into agreement with tenant. Everything. I am working like an agent. So I am doing all this. This is my obligation. But if I don't pay rent, I collect rent and don't pay to my sister, can she file a case against me? Yes. Even though it is one-sided obligation, I am not getting anything in return. Is anything I'm getting in return? No, in fact, I'm giving. I'm providing service. So I am agent. I'm working without commission. But still, there is a valid contract between me and my sister. And if I don't pay rent, she can file a case legally against me and recover the money. That is agency. Do you understand this? That is agency. And there is one more exception. There is one more exception. Promise to pay for past voluntary service. Before explaining this, tell me, will contract one-sided or two-sided obligation? Will, will, wasiyat one-sided or two-sided obligation? Tell me, will is one-sided or two-sided? One-sided. Valid contract, not valid contract. Valid or not valid? Yes, it is valid. Gift, one-sided obligation or both the side obligation? Gift is one-sided obligation or both the side obligation? One-sided. But still it is a valid contract. Time barred debt, you have no obligation. But you give in writing to pay time barred debt. Now it is one-sided and still it is valid contract. Agent can be both the side or one side. Both are enforceable. And promise to pay for past voluntary service. Example. Alia Bhatt met with an accident. I was going through that highway. I just call ambulance, put Alia Bhatt into ambulance, go to the hospital in a rush, call Mahesh Bhatt. And now doctor said that because of Mayur Agarwal, your daughter is safe. Mahesh Bhatt tell me, sir, thanks a lot. Thanks a lot. You have done a very big job. See what I've done. Voluntary service or involuntary service? Is it voluntary or involuntary? If it is done without any intention of money, if it is done without any intention of anything in return, that is voluntary service. If it is done with the intention of something in return, it is involuntary. So I have done voluntary service. So I was not expecting anything, money and something. Mahesh Bhatt tell me that you have done a very big thing. I have everything. I have car, bungalows, flats, everything. But I have only one daughter. And you have done a very big thing. I want to call you on Alia's birthday, Alia Bhatt's birthday, and gift you a car, BMW car. I said, no, sir, no problem, I'll be there. Now, on birthday, Mahesh Bhatt did not give me the car. See, what law is telling. Who has done a voluntary service never expected something. But now someone is creating some obligation on himself for any voluntary service received. Mahesh Bhatt is creating obligation, one-sided obligation himself, which was not needed, but now he has created. See, if he does not give the car, next time will I help any other needy person? If he does not give the car, next time will I think good deeds and good acts? No, I will think people just misuse us, right? So I never expected anything, but Mahesh Bhatt created an obligation which is one-sided obligation. Law is telling it is enforceable. Mahesh Bhatt need to give BMW car to me, and if he does not give, even if it is one-side contract, one-side consideration, but still I can file a case. It is promise for past voluntary service. Read this. Okay. Yes, friends. Any query here? So guys, see, will contract one-sided, gift contract one-sided, agent can be both the side or one-sided. Then promise to pay time bar debt. Time bar debt, there was no obligation, but you are still promising it one-sided. Then voluntary service, we never expected anything, but still you promise something. Now you are liable for the same. Very, very clear. Now, what is void agreement? Not enforceable by law. The agreement which is not enforceable by law is void agreement. I explain you this. See, what is a contract which ceases to be enforceable? Okay, when it ceases to be enforceable. See, this is not void agreement. This is, we'll change it. Let me come to the definition part. That is void contract. You need to cut this void contract. See, what is void agreement? Not enforceable. What is the difference between? See, I'll explain again. Wait. What is a contract or valid contract? Valid contract means agreement enforceable by law. Agreement enforceable by law is valid contract. Now, void agreement, where court will not help you. Agreement not enforceable, by law is void agreement. Agreement enforceable by law is void valid contract, and agreement not enforceable by law is void agreement. Very, very clear. Do you understand this? Do you understand this? Yes or no? Now my question is, what is void contract? Any student want to unmute and answer? What is void contract? Tell me, friends. What is void contract? Please answer faster. Yes. So I am coming to it. I am explaining you what is void contract. See, certain contracts which is okay, certain contract was enforceable initially, but later on something happened which removes the enforceability. I'll give an example. I promised Mr. Ramlal to supply 2 lakh rupees Chinese product every month for 12 months. So it is allowed. I supplied. After 4 months, government notification come down and government tells that Chinese product selling is not allowed. So initially it was enforceable. Later on, enforceability comes to an end. Legal enforceability comes to an end. It ceases to be enforceable. Legal enforceability is removed afterwards. Such contract which is a combination of both, initially enforceable, then not enforceable, it is void contract. It is void contract. I'll give an example. I contracted with the Pakistani to supply onions 5 rupees per kg for every month, 1 ton for 12 months. I supplied for 6 months. After 6 months, the India-Pakistan war is declared. After 6 months, India-Pakistan war is declared. Now, what is happening here? Understand. After 6 months, India-Pakistan war is declared. So, initially it was enforceable. Initially it was enforceable. Later on, the enforceability was removed. Now the court will not help you. First 6 months court will help you, but later on will not help you. Such is called as void contract. It, see, not enforceable at all, void agreement. Enforceable but later on cease to be enforceable. Later on cease to be enforceable is void contract. Let us check about section number 2J. See this. Contract which cease to be enforceable by law becomes void when it ceases to be enforceable. Contract which cease to be enforceable by law becomes void when it is ceased to be enforceable. Are you getting this? So it was enforceable in the beginning but not enforceable later on. It was enforceable at the start but later on enforceability is removed. Such is called as void contract. See, read this. Contract which cease to be enforceable by law become void when it is ceased to be enforceable. Then what is illegal? See, giving loan to minor, court will not help you to recover. That is void agreement. Giving loan to minor, court will not help you to recover. Suppose example, loan to minor, court will not help you to recover the money. That is void agreement. But if I give loan to terrorist, if I give loan to terrorist, court will not in fact help me. Court will not in fact help me. In fact, punish me. Void agreement, court will not help me to recover loan. In fact, it is punishable. It is punished. I will behind the bars. So such thing which is not, court will not help me, in fact punish me, is called as illegal agreement. Is called as which agreement? Illegal agreement. Those agreement where court will not help me, in fact court will punish me, is called as illegal agreement. Are you understanding this? Yes or no? Yes or no? So illegal agreement is one which is like void only, but no legal effects. And now obviously, in fact, anything who is helping in illegal, suppose example hai, Salman Khan provided his bungalow to Sanjay Dutt, 50,000 per month rent. Per month rent. Sanjay Dutt provided the same bungalow at 60,000 per month rent to a terrorist. Salman Khan provided bungalow to Sanjay Dutt and Sanjay Dutt provided to a terrorist. Now this is what? Illegal. Illegal. Court will not help Sanjay Dutt, in fact punish him. But anything which is supporting collateral to illegal is also illegal. Will punish Salman Khan also and Sanjay Dutt also. Anything which is supporting, say transaction collateral, will also become tainted with illegality and therefore cannot be enforced. Which is supporting to illegal. Supporting is between Salman and Sanjay Dutt. Example, this is also will become illegal because the main contract is illegal. Very, very clear. And next is voidable contract. Voidable contract. Let me give an example of voidable. See, if any contract, there is a force, mental force, physical force, there is a fraud and misrepresentation. 4 cases the contract is voidable. What are the 4 cases? First is fraud, second is misrepresentation, second is misrepresentation, third is mistake, fraud, misrepresentation, coercion and undue influence. Undue influence. In all these 4 cases, contract is voidable. So what do you mean by voidable? Suppose example, I'll take an example. Suppose this is beach and there is a whole river. River is there. Now this, they are going in a ship. There are 2 friends, Rami and Sammy. Now Rami at a gunpoint demanded gold of 1 crore for rupees 1 lakh. Now under a pressure, Sammy has given gold to save his life. Now Sammy wants back to India. Now is thinking what to do. If Sammy is like, let it be, I'll earn my money, why to fight? So okay. Or Sammy thinks, no, I will go to the court and fight for my rights. So Sammy have to decide what to do, whether to cancel it by filing a court case or don't cancel it and keep the contract valid. When one party have to decide, suppose Sammy and Sammy's wife is there, they both are threatened. one party or both the party have to decide whether to continue or cancel, and other party cannot decide what to do. Such contract where it can be avoided by the party, cancelled by the party, such contract will be called as voidable contract. Such contract will be called as voidable contract. Agreement which is enforceable by law at the option of one or more parties but not at the option of other party is voidable contract. Agreement which is enforceable by law at the option of one or more parties but not at the option of the other parties is called as voidable contract. Do you understand this? Where one party can decide to cancel it or continue it is voidable contract. Very, very clear. Again, see, these are certain flaws in a contract, mistakes in a contract. Certain contracts was enforceable, now enforceability is removed. Certain contracts are not enforceable and in fact punishable, that is illegal. Certain contracts, the party have to take a decision whether to continue or not is called as voidable. Very, very clear. Now there are certain things which are flaws in the capacity. See, every party cannot enter into contract. Every party cannot enter into contract. Who can enter into contract is mentioned in, basically is mentioned in section number 11. Every party cannot enter into contract. Who can enter into contract is mentioned in section number 11. As per section 11, every person is competent to contract if three things are there. He is major, he is sound-minded person, and he is not disqualified by law. See, everyone cannot enter into contract. Who can enter into contract? Three things need to be fulfilled. What are the three things? Suppose example, competent to contract. First thing is he should be major. Second thing is he should be sound-minded. And third thing is not disqualified by law. So it means if someone is a minor, someone is unsound mind who does not understand things and who is disqualified, law is not allowed him, disqualified by law, such people are not competent to contract. Such people are competent to contract. Very, very clear. So as per section 10, every person is competent. Read this sentence. As per section 10, every person is competent to contract who is of age of majority according to the law which he is subject to. There is a law which talks about who is major, who is minor. Which law talks about who is major, who is minor? Tell me. Which law talks about who is major, who is minor? Which law talks about who is major and who is minor? Tell me, friends. The law is Indian Majority Act. The law is Indian Majority. See, Indian Majority Act 1875, which talks about who is major and who is minor. Okay. Indian Majority Act 1875 talks about who is major, who is minor, who is sound-minded and who is not disqualified by law are allowed to enter into contract. In short, okay, see, read this. Every person is competent to contract who is of the age of majority according to the law which is subject to, who is sound-minded and who is not disqualified by law from contracting which is subject to is a contract. Okay, is competent. Okay. Now, what is unsound mind? Who is unsound-minded person? Okay. Those who are two things, who don't understand. I'll give an example. Suppose drunkard, he is in that mind. So, who is unsound minded? There are 2 points to be understood. Unsound mind. The first point is he is not capable of understanding terms of contract. He is not capable of understanding the terms of contract. See, he's not understanding. We are talking Mahabaleshwar property. He is thinking Kashmir property. We are telling him, we are talking about dog. He's telling that we are talking about cat. He is not understanding the terms of contract and not able to take rational judgment. Suppose example, I am selling a mobile of 10,000 for 50,000. He is ready to buy. He is not taking a rational judgment. Not able to take rational judgment. Not able to take rational judgment, such people will be called as unsound minded. See, there are two things. I'll just go to the Bare Act also. Okay. A person is said to be sound minded if at the time of making contract he is capable of understanding it and forming rational judgment. If he is not understanding and if he is not forming rational judgment, then he is unsound mind. Otherwise, he is sound mind. Read section 12. What I marked. Read it. Okay, let me proceed now. Let me proceed. Are you getting this? So this was about basically what called as. This was about the person. Okay. So whenever you enter into contract with a unsound person, the contract is void. You're not allowed. Court will not help you. Okay. But if suppose example, a drunkard, he is unsound for a certain time. When the day in the New Year party he have the drinks, the whole night is unsound mind. Next day is sound mind. So can he enter into contract when he is sound mind? Yes or no? Can he enter into contract when he is sound mind? Tell me yes or no. Yes, he can enter into contract. See, the person who is usually sound but occasionally unsound, like a drunkard who is usually sound but the day he drinks he is occasionally unsound, he cannot enter into contract when he is occasionally unsound. And similarly, a person who is usually unsound, sometimes sound, he can enter into contract when he is sound. Very clear. So with this, this topic ends. That is flaws in the capacity. Very very clear. Okay. So I hope you are understanding this. Are you connected? Yes or no? Okay. So we have seen about capacity. The party must be major. The party must be basically sound-minded, and the party must not be disqualified by law. Certain people are not allowed by law to enter into contract, like convicts who are behind the bar, who are inside the prison, are not allowed to enter into contract. Okay. but the person declared as insolvent now is not allowed to enter into contract. They are disqualified by law. They are major, they are sound, but law is debarring them or not allowing them to enter into contract. Very clear. So guys, this was about unsound mind. Okay, now let us talk about consent and free consent. Let me open a bare act and explain you how. What do you mean by consent and what do you mean by free consent? Okay, what is consent? When both the party agree upon, see, when two parties come to conclusion, when both decide a common thing, when both mind matches, both are thinking in the same line, then that is a consent. Then that is a consent. To become a contract, consent is one of the important element. Example, if I am talking about red car and you are talking about green car, are we thinking about the same thing and in the same fashion, same sense? Yes or no? Are we thinking about same thing in the same fashion and in the same sense? Yes or no? Answer is no. Answer is no. Very, very clear. To understand this, consent means both the party agree to the same thing in the same fashion and in the same manner. That is called as a consent. That is called as consent. So consent means agree upon the same thing in the same fashion. I am talking about red color car. You are talking about red color car. I am asking 5 lakh. You are ready to give 5 lakh. We are talking about the same thing in the same sense. Then only there is a consent among the parties. Matching of minds, meeting of the minds, everything they are thinking about the same thing in the same fashion is called as a consent. Two or more persons are said to consent when they agree upon the same thing in the same sense. When they agree upon the same thing in the same sense is called as consent. Very, very clear. Are you understanding this? So, consent must be there, but it should be not under pressure. It should be by will of the parties. So, when the consent approval is given at the will of the parties, that is free consent. That is free consent. For a contract, there must not be forceful consent. There should be free consent and not forceful consent. In the 5 cases, there are free consent: coercion, undue influence, fraud, misrepresentation, mistake. These are the 5 cases where there is a free consent. Free consent is absent. Okay. In the 5 cases, there is free consent absent, and apart from these 5 cases, free consent is there. Again, I am repeating. What do you mean by consent? Agreeing upon the same thing in the same sense. What do you mean by free consent? Agreeing upon the same thing in the same sense. Both parties are thinking in the same line. Both parties are thinking in the same fashion. Both parties are thinking in the same area. That is a consent. But if they are agreeing under a pressure and a force, then that is not free consent. To become a contract, there must be free consent. In the 5 cases, free consent is absent: coercion, undue influence, fraud, misrepresentation, mistake. Coercion, undue influence, fraud, misrepresentation, mistake. Understand this. So, what are these cases? Let me understand and let me give you a clear idea. In what cases there is free consent is absent? The very first thing is about the first thing is coercion. See, first, what is coercion? All you do which is not allowed under a law called as IPC, Indian Penal Code. See, Indian Penal Code is a common law which talks about crime, suicide, murdering someone, kidnapping someone, hitting someone. All these are mentioned in IPC, which is not allowed in IPC. You are doing that thing. You are suiciding. You are trying to hit someone, kill someone. Okay. Or you are threatening to do it. Okay, you are threatening to do it. Certain acts are not forbidden by IPC. You are doing that, or you are threatening to do that, or you are detaining someone property, or you are threatening to detain a property. Take into the custody the mobile phone and threaten them. Take into the custody their video clips. Take into custody their house and keep a lock and don't allow the entry. You are detaining their property or threatening their property, and now with this physical force you are forcing the other party to sign the contract. Such things are said to be coercion. Such things are said to be coercion. Understand this. I'll give you an example with a chart. Okay, hold on. Such things are said to be coercion. See, what is coercion? The act forbidden by IPC. Indian Penal Code, it is a criminal law forbidden by IPC. You are doing such act or threatening to do such act. To do such act. Same way, there is some property and you are taking in your custody their two-wheeler, four-wheeler car, hitting their car. You are detaining property or threatening to detain property. Threatening to detain property. So you detain a property or you threaten to detain property, you do any act not allowed in IPC or you threaten to do any act allowed in IPC, then such contract is said to be affected by coercion. That such contract is affected by coercion. Are you understanding this? So very simple. At a gunpoint, if A at the point of pistol asks B to sign a promissory note, now B will to save his life, so he does not avoid the agreement and give consent. Tell me, B is under the pressure of the gun signing the promissory note. He is giving free consent or no free consent. Tell me. He is giving free consent or no free consent. If A at the gunpoint tell B to sign a promissory note, B under a pressure signing this, so there is a free consent or no free consent. There is no free consent. There is no willful consent. It is a forceful consent. There is no willful consent. There is a forceful consent which is happening. Very, very clear. Do you understand this? Yes or no? Yes or no, friends? Okay. Now, tell me one thing. Suppose the contract is between A and B. Threat is coming from C. Can A file a case against B? There is a contract between A and B. Threat is coming from C. Can A file a case? Tell me yes or no. There is a contract between A and B. Threat is coming from C. Can A file a case? Yes or no? Tell me faster. Tell me yes or no. Contract is between A and B. Threat is coming from C. Can A file a case against B? Yes or no? Answer is yes. Threat can come from a stranger or threat can come from a contracting party. Suppose C is a friend of B. He is threatening to sell the property to B. C is a friend of B and he is threatening to sell the property to B. Now, this is also coercion. It can come from stranger or there is a contract between A and B is threatening to kill A's son. Threat is against stranger. Still you can file a case. Yes or no? Answer is yes. Coercion can come from stranger or can be against stranger. Coercion can be against person or can be against property. Still you can file a case. No worries about it. Law will try to help you. Very clear. To read this, if it may be pointed that coercion may proceed from any person and may be directed against any person. It can be against any person and can be directed against any person, even a stranger, and not against, and also can be against goods by unlawful detaining their goods. Are you understanding? Have you seen Three Idiots movie? In the Three Idiots, there is a lota scene, Astia in the lota, and that person was detaining, threatening that I will put that lota in the water. Okay, so now friends, that is what detaining the property. That is detaining the property. That is coercion under section 15. If there is a contract, there is a coercion, then there is no free consent and the contract is voidable. And the contract is voidable. Do you understand this? Yes or no? And the contract is voidable. Do you understand this? Yes or no? Okay. Similar way, if in a contract there is undue influence, what do you mean by undue influence? One party is able to control your mindset. One party is able to put a mental pressure on you, and because of which they are putting a mental pressure and forcing you to enter into contract. Suppose example, I am a Baba and you come to me, sir, please help us to clear exam, first level exam, entrance exam. Well, okay, do one thing. Keep my photo in your book, you will pass the exam. Now you kept my photo in the book and you pass the exam. Second time you come to me and ask, sir, please let us clear the second level exam. Very tough. Okay, I said, keep Alia Bhatt photo also in the book along with my photo. You will pass the exam. You kept the Alia Bhatt photo. Now you clear the exam. Third left time you come, sir, please, it is the final exam, help us. Please transfer your 1 BHK flat to me. You will pass the exam. Under influence, you transferred your 1 BHK flat to me and now you did not clear the exam. Now you come to know, oh my God, you are under influence and you have transferred the property. Can you file a case against me and recover the property? Yes, because I am dominant position. Whatever I tell you, listen, and I use my position to influence you and take the unfair advantage. I use my position to influence you and take the unfair advantage, which is called as undue influence. Which is called as undue influence. Are you understanding this? Yes or no, friends? Which is called as undue influence. Very, very clear. Yes or no? Are you understanding this? Hello? Are you listening? Correct. So in undue influence, there must be some relationship. Party must be known to each other. Stranger cannot influence. Stranger cannot influence you. The influence will come only you are into known among known parties. Okay, like doctor can influence patient, advocate can influence client. Okay, teacher can influence student. Okay, influence can be good as well as bad. If someone does a bad influence and take the benefit, that is called as undue influence, and this is called as a mental pressure, and you can file a case in the court of law. Understand this, where the relation which is among the parties are such that one party is in the position to dominate your decision, dominate your will, and uses the position to unfair advantage, such is called as undue influence. In undue influence, there must be a dominant position and the party must use the position to take the unfair advantage. Read this. Okay, so very clear. This is undue influence, which you have to understand it very well. Okay, so undue influence means one party is into dominating position and influencing the other party. See, five things which are undue influence, five things where there is no free consent: coercion, undue influence, fraud, misrepresentation, mistake. But whatever is given in the curriculum, we'll do that much. We have done coercion, we have done undue influence. Let us come to fraud. What exactly fraud means here? Let us understand this. What is a fraud? Very first thing, fraud means telling a lie. Fraud means telling a lie, false representation. Suppose example, this pen is made in example China. I tell this is made in Japan, and based on that you purchase the pen for 10,000 rupees. Now tell me, is it a fraud? Yes or not a fraud? Tell me. This pen is made in China. Example, it is not Chinese pen, but example. And I am telling you, I know that it is not made in China. I know that it is not made in China, and it is made in China. And I'm telling you a lie that it is made in Japan. Tell me, it is a fraud or not a fraud? Tell me, it is a fraud or not a fraud? Tell me, it is a fraud or not a fraud? Yes, it is a fraud. I know I'm intentionally telling a lie. I'm suggesting a fact which is not true, and I believe it is not true. I'm telling a fact that it is made in Japan, which is not true, which is made in China. And I also know that it is not true. It is a fraud, 100% yes. I know I promised that to my friends, I'll come for a movie, just example. I know I'll not go for the movie. I'm promising that I'll come for the movie, and on the date of movie, I keep switch off my phone. Tell me, I made a promise and I know that I will not fulfill it. It is a fraud or not a fraud? It is a fraud or not a fraud? Are you getting? I made a promise that I will not fulfill it. It is a fraud or not a fraud? I said to the client that I will get the work done in the evening, but I know for 5 days I'm not there only. It is a fraud or not a fraud? Yes, it is a fraud. You made a promise, you know that you will not fulfill it, that is also a fraud. Any contract to deceive other party, A promised to pay B, that go and do fraud with C, and I will pay you 10 lakh. The contract between A and B to deceive C, the contract between A and B to deceive C is a fraud or not a fraud? Yes, it is a fraud, because you're deceiving, putting the other party at a loss is also a fraud. Sometimes in various act they write this is fraud, this is fraud. If director don't take permission from the shareholder, is a fraud. Many times in the law it is specially declared that it is a fraud, then it is a fraud. Understand that. See, very clear. What are the various frauds? What are the various types of frauds? I'll explain it. Just hold on. What are the various types of fraud? Types of fraud. The first type is suggestion of fact, which is, I have suggested, I said that this is made in China, this is made in Japan, which is not true, which is wrong, and party making it also believes it is not true. Correct. He knows that it is not true. He's telling a false fraud thing. Correct. Second thing is like any act to deceive, other party. Are you getting? Means you are doing some wrong thing to the other party is also a fraud. You are doing, two people are trying to make put a loss at the other party to deceive the other party is also fraud. Then promise made without any intention of performing it. कस्में वादे निभाएंगे हम, बट हम कस्में वादे पूरे नहीं करेंगे, पता है. We'll do promise but will not do it. That is also fraud. Understanding this. See, first is telling a fact which is not true, and you also know it is not true. I said that I will sell this pen. I will sell this pen which is made in Japan, but it is not made in Japan. it is not made in Japan. So understand friends, this is again a fraud. Second is to deceive the other party. Two people are trying to put at a loss C and do a fraud with C is also a fraud between A and B. And I promise and I know no, I will not fulfill it. It happened. Once I called all of my friends, we are long time, let's meet up, let's catch up, let's go for a movie, what we are doing in our life, let's go for a movie on Saturday. Everyone took my dialogue seriously, and I was just telling that way. Now everyone got ready for the movie and they booked a ticket. They sent me the tickets. Please come down. I said yes, I will come, but I know Saturday I am going out with my family. I am made a promise that I will come for the movie, but I know I will not go for the movie. Is it a fraud? Yes or no? Is it a fraud? Yes or no, friends? Tell me. What do you think? Yes or no? Please comment. Nia is telling it is a fraud. I made a promise. I know I will not fulfill it. What about others? Anisha is telling yes, it is a fraud. Correct. Okay. Any act specially declared by law, specially declared by law as fraud. See, example I'll take. In Companies Act, it is written if you want to sell the substantial part of the company, factory, building, and everything, you need to take the permission of the shareholder in the meeting. And if you don't take the shareholder permission, then you have done a fraud. So is it a fraud? Yes or no? If directors sell the property without taking the shareholder's permission, it is a fraud or not a fraud? Tell me. It is a fraud or not a fraud? Yes, it is a fraud because in the law it is clearly mentioned that this thing is a fraud. And active concealment of facts. Active concealment, we are hiding something. Suppose example, small wood. I just stick and make a table and I paint it so that you don't see the small part of the wood. The waste wood, I have used it and I painted it so that you don't understand that it is a small wood being joined together. Tell me, I have hidden something actively. Is it a fraud or not a fraud? What do you think? I have hidden something actively. It is a fraud or not a fraud? I have hidden something actively. Is a fraud or not a fraud? Tell me. Yes, it is a fraud. Very clear. So all these things are written in the Bare Act as well. Let me show you. This is Bare Act. In the Bare Act, when you go, you see this fraud. See, there are fraud means suggestion of a fact which is not true and the other party also don't believe it is true. Active concealment of fact, promise made without any intention of performing it, any act to deceive the other party, and any other act or omission which is declared especially in the law as fraud. Please read this. Please read this, the same thing, types of fraud. 1 minute I'll give you. Okay, I think so you're understanding. Should I continue? Okay. So now let us understand this is various types of fraud. Are you getting this? Any query here? Telling a fact which is not true and I know it is not true. Hiding something, actively hiding something. I made a promise, I know I will not fulfill it. I am doing something which is deceiving, putting a loss at the other party and other things. Very clear. So for a fraud, what are the important elements? The first thing is false representation. I am telling you that it is made in Japan. Is it a true representation or false representation? Tell me. And representation is small thing or of the facts which is impacting the decision, and the other party believed on that representation, purchased the goods. Other party believing this representation, purchased the goods, and now the other party is deceived. Very very clear. So there is a false representation of fact. It's not giving opinion, you're talking with the facts, and it is done with the intention. Is it done innocently or intentionally? Intentionally. I know I'm doing intentionally, and the representation must be actually induce the other party to enter into contract and so deceive him. The representation must be so that the other party enter into contract and take the, so he is at a loss. Now this pen which is made in China worth rupees 3,000, he purchased believing it that it is made in Japan for 8,000. Now he is deceived, he is at a loss. Very very clear. So it is a fraud. Now the other party with whom fraud is done, can he go and file a case and cancel the contract? Yes or no? Tell me friends in the comment section. If other party with whom the fraud is done, can he go and file a case and cancel the contract? Yes or no? Yes. So can we tell it is a voidable contract? The party with whom the fraud is done have to decide whether to continue or cancel. When the other party have to decide, then that is equivalent to voidable contract. Then that is equivalent to voidable contract. My question to you, a very simple question. See, example, I am selling my mobile phone to you guys, and I'm selling this phone. I know the phone camera is not working, and I know if camera is not working, it is worth 10,000 only, and if it is working, then it is worth 20,000. I know the camera is not working. You asked me, sir, what is the price of this mobile phone? I said 20,000. You were looking excited to buy. I said 20,000. I'm happy that I got a bakra to sell my mobile phone. Are you getting this? So I'm silent. I did not tell anything that the camera is working, not working. You purchased mobile phone by giving 20,000. After 4 days, you took a selfie, but the selfie cannot be taken. Now you check there is some problem with the camera. You come to me. Well, sir, do you know the camera is not working? Yes, I was aware. So now you're telling, sir, you did not tell me the camera is not working. So well, that is, if I tell you not buy only. So you filed a case of fraud against me. Who will win the case? Buyer or seller? Again I am repeating. I am aware that my phone camera is not working. Now I did not tell anything to you about this. I am silent. I did not tell it. You asked me what is the price. I said 20,000. You purchased the phone for 20,000. After 4 days, you come to know the camera is not working. Once you come back, now you are fighting with me. I said I was aware about the camera not working. You filed a case against me for fraud. Who will win the case? Buyer or seller? Tell me. What is the answer? Buyer or seller? One answer is buyer. What about this? Just guesswork. Others are telling buyer. Fatima telling buyer. Sakshi telling buyer. Harshit telling buyer. Neha is telling buyer. Are you getting this? Okay. Answer is seller will win the case. Did seller tell anything wrong? He did not tell only. If seller has said, see the camera is working and it is not working, it is a fraud. He did not tell anything. Seller is silent. Seller need not talk everything. It is also the responsibility of buyer to check and take. It is the responsibility of buyer to check and take. So seller is silent of the facts. He did not tell anything. Silence does not amount to fraud. Silent is silent about camera. He did not tell anything. Silence does not amount to fraud. See the rule. Mere silence as to fact which is likely to affect your decision is not fraud. Silence does not amount to fraud. I have not done fraud because I did not tell only anything. And you as a buyer also have a responsibility to check and take the phone. Do you understand this? So what is the point? What is the point here? Generally the rule is silence does not amount to fraud. But there are exception. What do you mean by exception? Exception is in some cases silence will amount to fraud. I'll give an example. Silence will amount to fraud. So what is the rule? General rule is that silence does not amount to fraud. But exception is that silence amounts to fraud. In which cases silence amounts to fraud? There are two cases where silence amounts to fraud. Okay. There are two cases where silence amounts to fraud. First, where there is trust and confidence, where it is duty to speak, like marriage. Suppose A is a divorcee and A is going to marry B. B did not ask whether you are divorcee or a fresher. A did not tell. A is silent. Where there is a trust and confidence contract, does it amounts to fraud? Yes or no? Is it your duty to speak? Is it your duty to tell that I am a divorcee? This happened, or no, there is no duty? Tell me. Yes, it is our duty to speak because it is a contract where it is trust and confidence. So in that case, whenever you are dealing with your relatives and friends, whenever you are dealing with your family, you are selling the property to your parents or parents is selling property to you. Is it a duty to speak or you need to hide facts? It is a duty to speak. Whenever you are taking insurance contract, me fide, utmost good faith. They ask you whether you drink, you smoke, or any diabetes, BP. They ask you a lot of medical background. And based on what you disclose, they give you the policy. Later on, they discover that you did not tell, you did not disclose that you have a BP, blood pressure. So you have done a fraud or not done a fraud? You have done a fraud. In certain cases, there is your duty to speak. You need not keep silence. If you are silent, then everything will be like a fraud. Do you understand this? So my point is like in there are certain cases where it is duty to speak. Duty to speak, that is trust confidence contract. Like the first is whenever is a property contract, contract of sale of land, contract of sale of land, it is your duty to speak, right? Property related matters, family arrangements or marriage arrangements. Okay, it is your duty whenever it is family related matters, duty to speak, family arrangement. Okay, insurance contract, it is your duty to speak. Insurance contract, duty to speak. And if I'm talking about company prospectus, suppose example, I'll take a point. In the prospectus, the first year the profit was 100 crore, second year it is 80 crore, third year 60 crore, fourth year 40 crore, and fifth year 20 crore. Understand here? 20 crore. So company did not tell this. Company tell that average profit for 5 years is 60 crore. This is right, but they did not disclose these data. In the prospectus, it is their duty to disclose each and everything. Disclose this, and if they don't disclose it, they are silent, it amounts to fraud. So in case of company prospectus, it is your duty to speak. Do you understand this? Yes or no? It is your duty to speak. So friends, I'll just write down in word because my writing is international. I'll just come to this. Tell me, silence amounts to fraud or does not amount to fraud generally? If seller did not tell everything, is it amount to fraud or does not amount to fraud? Silence does not amounts to fraud generally, but there are exception. First, there is duty to speak in trust and faith contracts. Like example, insurance contract, you need to disclose everything. Family arrangements, family related matter, you need to disclose everything. Then company's prospectus, you need to disclose everything. Do you understand this? Company's prospectus, you need to disclose everything. Contract for sale of land, you have to disclose everything. And second, where silence is equivalent to speech. Silence is equivalent to speech. Very, very clear. Let me give you an idea. What does it mean? Silence is equivalent to speech. Silence is equivalent to speech means, suppose you come to me and you ask, sir, I want to buy a mobile phone. I said 20,000. Bole, okay, sir. Now you take phone, you come back, sir, is the voice clarity good, sir? Like, yes, beta. So many questions you ask. Yes, it is good. Then you come down. You go back, come down. Sir, one more. Sir, battery life. Like, yes, beta, it is good. Now you go back. Again come back. Sir, last question. I am very angry. No, if you don't tell also, I'll assume it. Sir, camera is good now. Sir, if you don't tell means it is good. I am smiling. Where I did not tell something, still I tell something. Where I'm silent, but still I'm giving a message. Yes or no? I'm silent, smiling, but now you're okay. Now you take a selfie. The camera is not working. You come to me. Plus, the camera is not working. Yes, it is not working. But you said that camera is not working. I did not tell only. I was silent. Sir, your silence is only telling that camera is not working. Where silence is equivalent to speech. कुछ नहीं बोलकर भी बहुत कुछ बोल देना. By not telling only, you're telling a lot of things. Is it a fraud? Yes or no? Yes, it is a fraud. Are you getting this? So these are certain things where you have to disclose everything. Very, very clear. Now let us proceed with further. Coercion is done. Undue influence is done. Now let us come to, whenever you are making contract, there should be some, see, to make contract, you require offer, you require acceptance, you require consideration, you require capacity, you require free consent, you require lawful object. All these things are written under section 10. I'll show you Bare Act, section number 10. I'll take to section number 10. See, all agreements are contract if they are made by free consent, if they are made by parties competent to contract, if they are made by lawful consideration and lawful object. Understand this. To make a contract, your object intention should be lawful. Example, giving loan to minor for education, valid, necessary contract. But giving fund to terrorist is unlawful intention. Giving flat on rent, no problem. But giving flat on rent to terrorist, your object is unlawful. So whenever you are doing contract, your purpose, intention, object behind the contract should be lawful. Your intention, purpose behind the contract should be lawful. Do you understand this? Yes or no? Are you listening? So in which cases your object is unlawful? 5 cases. As per section 23, let us go to section 23. Your 5 cases, your object is unlawful. Sir, your purpose is unlawful. See these 5 cases. I'll mark this. First, second, third, fourth, 5. These 5 cases, see, same thing is written in your text, in your module as well. These 5 cases, your object is unlawful. Example, certain things are banned by law. Dowry is banned by law and you are contracting for dowry. Is it lawful or contract or unlawful contract? Child marriage is banned by law. You are doing child marriage. You are contracting for child marriage. Is it lawful or unlawful? Tell me, friends. Yes, it is unlawful. Certain things are forbidden by law, banned by law, and you are doing that. Certain things you are doing against law. As per law, time barred debt is 3 years, and you are writing in contract, time barred debt will be 2 years for our case. Are you defeating the provision of law? Are you defeating the provision of law? Yes. certain things it is fraudulent. Example, ABC enter into contract for bank robbery. ABC decide that whatever bank robbery we get the cash will divide in one third, one third, one third. ABC undertake bank robbery and now they are running after bank robbery. Police is behind them. A have whole cash. A is running at one side. B is running in one direction. C is running in one direction. Doom machale. Now B and C are trying to contact A, but A is not contactable. B and C approach a court telling that, my lord, we have done a contract for bank robbery by which we will divide the whole money in three parts, but A has done breach. Are your intention, A, B, C intention is what? Fraudulent intention or good intention? A, B, C intention is what? Fraudulent intention or good intention? Tell me, friends. ABC intention is what? Fraudulent or good intention? Yes, it is fraudulent. Will court help you? No, because your object, purpose, intention is unlawful. Object, purpose, intention is unlawful. So, what is forbidden by law? You're doing that. What is written in law? You're doing against the law. You are doing something which is with fraudulent intention. You are doing injury to person or property. Example, you are one of the editor in Times of India. I call you and tell that write an article against Mr. Ramlal. I want to get his defamation. I want his to be insulted. You tell no, we cannot do that. There should be valid evidence. I tell that I'll pay you 20 lakh rupees. Write an article. You said okay, done. I have given you 10 lakh and remaining 10 lakh will be given after the article. I paid you 10 lakh and you have written article against Ramlal, defaming him, insulting him. His reputation is being tarnished. Now you are calling me for remaining 10 lakh. I did not pay you 10 lakh. You approach court asking for 10 lakh. Will court help you? Is your intention right or wrong? Is your intention right or wrong? Tell me, friends. Yes, the intention is wrong and now it is opposed to public policy. Now it is opposed to public policy which is happening place. Yes or no? Yes or no, friends? Are you getting this? So when you injure any person or any property, that is also opposed to public policy, and certain things which are immoral and against society, dowry, parental rights, parents are not allowed to meet, exploiting someone's personal life, personal liberty, all these are forbidden by law, all these are unlawful object. So 5 cases where it is unlawful object, I am repeating again, 5 cases are which is forbidden by law, you're doing that, or which defeats the provision of law, you're doing that, or it is fraudulent, or it is injury to person or property, or injury to person or property, or which is opposed to public policy. I am writing in a hurry. Opposed to public policy. Are you getting this? These are the 5 cases where it is unlawful object under section 23. Now let us see what are the examples which are opposed to public policy. First, agreement in restraint of parental right. Suppose example, there is a maid working at my place. She require loan. I said, okay, I'll give you loan, but on one condition that you will not meet your kids for lifetime. Under a pressure and under need of money, she agreed and signed. She will not meet the kids. But after taking loan, she is meeting her kids. Example. So now what has happened? I filed a case against that servant or employee that she is meeting her kids which she agreed not to meet the kids. Such agreements stopping the parental rights. Such agreement which is stopping the parental rights, depriving the parental rights, depriving parents from the custody of the child is good for the society or bad for the society? Tell me. Good or bad for society? Yes, it is bad for society, very, very clear, and it is opposed to public policy, very, very clear. Suppose example, Alia Bhatt wants to marry me. Example, I'm already married. Okay. Example, Alia Bhatt wants to marry me. Mahesh Bhatt offered Alia Bhatt that I will give you 5 bungalows, 3 BMW car, and 5 crore FD. Don't marry Mayur Agarwal. Alia Bhatt signed the contract, taken bungalow, FD, and car, but still she marries me. Mahesh Bhatt filed a case against Alia Bhatt. Who will win the case? Please comment. Please comment, guys. Those who are watching live or recorded, whatever may be. Yes, Alia Bhatt will win the case because you cannot stop anyone from marrying to a particular person or basically stopping anyone from marrying only. Such agreements are not allowed. Everyone have a right to marry the person they like or they want to marry to whom. Do you understand? Basically, such agreements stopping someone from not marrying at all or partial restriction. Do you not marry this person or this community? Not allowed. Socially, under a peer pressure, we are forced. But legally, no one can stop you from marrying the person you like to. And Alia Bhatt will win the case that is opposed to public policy. Marriage brokerage, dowry. Giving dowry for the marriage is good for society or against society? Is good for society or against society? It is against society, which is not allowed. Suppose example, Rakhi promised to marry. Suppose example, Harshad. Okay, example. And Harshad said, okay, I'll marry you provided you give me 3 bungalows. Rakhi signed a contract that after marriage she will give 3 bungalows because she is married. After marriage, Rakhi did not give bungalow. Can Harshad file a case for dowry? Yes or no? Answer is no. And next is agreement in restraint of personal liberty, personal freedom. Example, if my staff is requiring loan, example, I have given loan on the condition that you have to work lifetime with me and you have to pay 80% per annum interest. Don't you think I am taking his personal liberty, freedom? Yes or no? Yes. Such contract which is taking or depriving the personal liberty and freedom is also opposed to public policy and agreement in restraint of trade. No one can stop anyone from doing lawful business profession. If you want to become prime minister, you can become prime minister. If you want to do become a celebrity, become a celebrity. If you want to become a sports person, become. No one can stop you from doing anything. Like example, I am teaching law. If you think you want to teach law, you can also teach law, no worries. But if I give you money that I'll pay you 40 lakh, don't teach law. By contract, even if I pay you 40 lakh, but still you can teach law. No one can stop anyone from doing lawful business, lawful profession, and lawful occupation. Are you understanding? So, what are the agreements? What are the agreements opposed to public policy? First, agreement in restraint, stopping of parental rights. Agreement in restraint, stopping of personal liberty and freedom. Agreement in restraint of trade, occupation, profession. Restraint of trade. You can do any business, no one can stop you from doing it. Agreement in restraint of marriage. You can marry anyone you want to. Agreement in that is not agreement in marriage brokerage. Courage contract. That is like dowry. Okay, read this. Please read it. Okay, so these are the things which are opposed to public policy. Friends, any query which are against society and against public policy. Any query here? Please tell. Where this was promised rupees 200 in consideration of procuring a wife for defendant. The promise was held like a agent contract. Okay. Dowry or agent, one and the same. Where you get someone, okay, someone is not up to the mark and someone is telling you, get my marriage done, I'll pay you 1 crore. Okay, such things are also marriage brokerage. Correct. Let us proceed. Now, what is wagering agreement? Betting agreement. That India wins the match, I'll pay you 10,000. If India don't win the match, you'll pay me 10,000. Such agreement, betting contract, is allowed or not allowed? Tell me, allowed or not allowed? Wager means to bet. If it rains in the evening, I'll pay you 1 lakh. If it doesn't rain, you pay me 1 lakh. Allowed or not allowed? Not allowed. It is void. In fact, sometimes illegal also. To read this, the literal meaning of the word wager is to bet. Wagering agreement are nothing but ordinary betting agreement. A and B enter into an agreement that England's cricket team, if wins the test match, A will pay 100 and if it loses, B will pay 2A. This agreement is nothing can be recovered with by minimum. This is wagering agreement and nothing can be recovered by winning party. See, it happened. My friend agreed to give me a party. We lose the bet. But if he does not give a party, can I file a case against him because there is a betting agreement? Tell me yes or no. No, I cannot. Even if I win the bet, I cannot file a case and recover. See, so what is the situation in Mumbai? That is basically Maharashtra. Basically, betting is illegal in Maharashtra and other state it is void. There is a difference. See, if I bet in Maharashtra and I win, but other party don't give me money, I file a case against him. Court will not help me. In fact, punish me. Court will not help me. In fact, punish me. So it is illegal. But in other states, suppose in I bet in Rajasthan and I win the bet, but I did not get the money, I file a case. Court will not help me, but will not punish me. So basically, in Maharashtra or Mumbai, it is illegal, but it is void in the other state, except Mumbai. Okay, read this. In Mumbai, the wagering agreement has been declared illegal by the Avoiding Wagers Amendment Act 1865. Therefore, in Mumbai, a wagering agreement becomes illegal, is void not only between the immediate party but also to the collateral. I'll give an example. Understand here. Suppose example, A is giving money to B, go and bet on his behalf. I'll give you 10 lakh rupees to go and bet in a casino somewhere. And B said that he will bet with C. Okay. Now what happened? Simple. A promised that he will pay 10 lakh, go and bet on his behalf. B put his own money and lose 10 lakh rupees in the bet with C. This has happened in Mumbai. So tell me, the contract between B and C is what? Illegal. Now, this is illegal. Are you understanding? Repeating again. A said that go B, go and bet. I will pay you 10 lakh. Afterwards, bet on my behalf. Go and bet. Now B go and bet with C, but B loses whole amount and pay to C 10 lakh. Now B want to recover it from A. A did not pay the money. B filed a case against A. Who will win the case? B want to recover the loss from A. A did not pay the money. B filed a case against A. Who will win the case? Tell me. Yes, answer is A will, in fact, both will not win. The anything which is collateral to illegal is also illegal. In fact, B cannot recover money. In fact, both will be punished. Anything which is supporting to illegal is also illegal. Anything which is supporting to illegal is also illegal. Anything which is supporting to illegal is also tainted, not allowed. Very, very clear. Do you understand this? So read this. Let us take an example. A bets with B and loses. Applies to C for a loan. Now what happened? A has done a betting with B and he loses money. He takes loan from C. He take loan and give it to B. A bets with B, okay, bet with B and loses. He take loan from C and give that bet money to B. Okay, now what has happened? Who pays B in settlement of A's loss? C cannot recover from A. This money is paid in respect of wagering, which is illegal in Mumbai. Can C recover money from A? Tell me yes or no. Can C recover money from A? Yes or no? Tell me friends. Can C recover money from A? Yes or no? Answer is no. Anything which is supporting to illegal is also illegal. Anything which is supporting to illegal is also illegal. But anything which is supporting to void, anything which is supporting to void is valid. Any collateral to void is valid and any collateral to illegal is also illegal. Anything which is supporting to illegal is also illegal. I'm writing a sentence. Understand? Collateral to illegal agreement is also illegal and collateral to void agreement is valid. Read this. I'm giving 1 minute time. Read this. Okay, guys. So anything. So my question to you: if I promised my friend to give, understand, I'm asking, I promised my friend to give 10 lakh rupees, go and bet on my behalf. My friend go and lose in the bet. He paid his money from his own pocket. Now he want to recover from me. In Mumbai, this is happening. So tell me, the contract between me and my friend is void or illegal? It is also illegal. But if my friend go and bet in Delhi and I promise to pay him the money, don't worry, go and bet. He loses a bet in Delhi, but can he recover from me? Yes or no? Yes, because collateral to void. Delhi, it is betting is void. Collateral to void is valid. Collateral to void is valid. Understand here what I'm trying to tell. Suppose Mayur sir promised to, give friend money, go and bet, and friend go and bet with A. Okay, correct. Friend go and bet with A. Now what has happened? Now this is happening in Delhi. So this is void, but this will be valid. My friend can recover money from me. But if it is Mumbai, then this is illegal. My friend cannot recover money from me. So this was the whole story about betting which happened take place. Do you understand this? So understand here, what is my point? But in some commercial transaction like stock market, you bet, you think that the share price will increase. You buy today at lower price and sell it higher price. Tell me, okay, is it betting? No. But in exceptional cases also there is some betting happening taking place. So there are certain things. Now, certain agreements are officially declared to be void. Let us see this. Certain agreements, agreement void. Certain agreement, there is list of agreement. See void agreements. There is list of agreements, section 24, section 25. Okay, all these and the bare act you see are void agreements, very clearly written as void. Certain agreements are declared to be void if the contract is entered by unsound mind, minor or disqualified by law. Is it valid or void? Tell me. Is it valid or void? Tell me. Is it valid or void? Okay, same way it is void. If you contract with a minor, court will not help you. If you contract with unsound mind, court will not help you. If you contract with disqualified party, court will not help you. It is void. Very, very clear. If it is mutual mistake means both the party had a mistake. Suppose example, what is it is also called as bilateral mistake. Understand here. So what is bilateral mistake? Suppose A and B are dealing in a plane. They are going for in a 5 hour journey plane. In the plane they deal that A will sell all the rice in his godown in Delhi to B. But once the plane landed, they come to know the godown is met with a fire, goods are destroyed. Both were not aware. Goods are destroyed completely. Now tell me, both party are at a mistake. Both don't know that goods are destroyed. So tell me, will the contract continue or it will be void? Tell me, friends. Both the party are at mistake. Yes, Harshit, we are very active, very good. Sakshi, Harshit, Neha. Okay, tell me. So contract. Both the party were not aware that goods are destroyed. So tell me, will the contract continue or contract will be void? Contract will be void, which is called as mutual mistake. Or it is unlawful consideration object. Contract is valid or void? Contract is void, or it is made without consideration. No consideration, no contract. There are certain exceptions. Or 26, see they are giving the list 24, 25, 26 lines, everything they are giving in a list as per the bare law. Suppose you are stopping anyone from marriage, valid or void? Void. You are stopping anyone from doing lawful business, valid or void? Void. You are stopping anyone from taking legal action, going to the legal court, valid or void? It is void. Understand here? Okay. So basically there are many contracts. Uncertain. Example, I am telling that I want to buy a beautiful house. Is it beautiful house? Meaning is certain or uncertain? I am telling that whatever you think fit, give me the price. Is it certain, uncertain? Whatever is your capacity, give me that much money. Certain, uncertain, uncertain. So when the meaning is uncertain, it is also void. It is also void. When it is wagering, it is void. And you agree in the future, it is void. And to do impossible act, I am telling bringing stars from sky. I'll promise to bring stars from sky. I am promising that I will make dead body alive. Is it valid or void? It is void. So this is the list where the contract will be void, will be considered as void. Let me explain you. See, let us make a list of void agreements. First, mutual mistake. Mutual mistake of fact. It is valid or void? Tell me. Mutual mistake of fact. Valid or void? What is happening? It is void. Okay. Contract by incompetent party. Section 20. देखिए, mutual mistake, contract by incompetent party 11, Mutual mistake of fact, section 20. Okay, similar way, unlawful object and unlawful consideration, section 23. Unlawful object, your intention is wrong, that is section 23. The contract will be void again. Okay, then contract made without consideration. No consideration, no contract. We have done this, or we have discussed the exception also, right? So no consideration, no contract. We are going in the line order, section 25. Agreement in restraint of marriage. Agreement in restraint of marriage. You're stopping anyone from marrying. See this. 25, 26. Restraint of marriage. Okay. So that is again there. Okay. Agreement in restraint of marriage is again void. Then agreement in restraint of trade. You're stopping anyone from doing business. Agreement in restraint of trade. That is section number 27. Stopping from doing lawful business. Are you understanding, friends? Are you listening to me? Yes or no? All these cases code will not help you. These are the list, lot of lists there, right? Same way, agreement in relation of legal proceeding. You're stopping from taking legal action in restraint of legal proceeding. I'll take example. Suppose example, I have given loan to Anisha and Anisha promised that she will not file a case against me. She signed a contract. Now, suppose example, I have taken loan from Anisha and Anisha promised that she will not file a case against me. Now, Anisha, I did not pay the money. Anisha filed a case against me. I am arguing in the court of law that, my lord, Anisha agreed in the contract that she will not take a legal action. My lord, Anisha agreed in the contract that she will not take legal action. Now, can I stop Anisha from taking legal action? Answer is no. Anisha still can file a case and recover the money. Anisha can file a case and recover money. That is section 28. Okay, very clear. Then in a similar fashion, uncertain agreement. Uncertain agreement. Uncertain agreement. Okay, that is meaning is not certain. Give me beautiful house, give me whatever you can pay. That uncertain agreement, it is void. Wagering agreement, betting contracts, court will not help you. In Mumbai it is illegal, but otherwise it is void. That is section 30. And where you agree in the future, you promise today that you will enter into contract in the future. No, agreement to agree in future. And last is basically impossible agreement to make dead body alive and everything, section 31. All this is a list where it is a void agreement. Please read this. Yes, guys. So this was the list where it is void agreements and you just need to read it. Don't worry about it. Are you understanding? Are you listening to me? Tell me, should we develop further? Yes. So very good. What is contingent contract? See, contingent contract means like insurance contract. Insurance contract is good. Indemnity contract, guarantee contract. If something happened, if you die, if you meet with accident, we'll pay you the loss, we'll pay you the money. So such contracts are valid. Contingent contract is a contract whereby certain things are valid and like you are allowed. If something happens, if something happen or do not happen, okay. So something happen or does not happen, so that is a contingent contract. If you meet with, suppose you are traveling to USA and in 1 month we give you insurance, travel insurance. If anything happened to your luggage and passport and yourself, we'll pay you the compensation. If nothing happened, we don't pay you the compensation. So that is a contingent contract which is basically there. So they go. Contingent contract is a contract to do something or not to do something. If some event collateral to such contract does happen or does not happen. Very clear. For example, A contracts to B 10 bales of cotton for 20,000 rupees. If the ship by which they are returning safely, if the ship returns safely, will pay you the transport charge or goods. So that is a contingent contract which is allowed. Now, what is quasi contract? Very, very important. Quasi contract. See, example. I promised to buy a car from showroom and showroom promised to give me the car. I'll pay them the money. This contract, in this contract, there is obligation on me to pay 10 lakh rupees. And the showroom have an obligation to deliver the car. I have a right to take the car and showroom have a right to collect the money. The obligation and the rights are created by parties. The obligation and the rights in the normal contract are created by parties. But in quasi contract, party don't create obligation. Certain obligations are created by law. Law is telling that you are obliged, you have to do this. When the obligation and the duties which are created by law, it is a quasi contract. And when the obligation and duties are created by parties, it is a normal contract. When the obligations and the duties are created by law, it is quasi contract. And when the obligation and duties are created by parties, it is a normal contract. Do you understand this? Are yes or no, friends? Tell me yes or no. Yes or no? Again, I'm repeating. Example: if you find on when you are walking in your society, you find a gold chain. Can you keep the gold chain or you need to return to the true owner? I am repeating again. If you, while walking in a society, you get a gold chain, can you keep the gold chain with yourself or you need to return to the true owner? That is a question to you. You need to return it. But this is your obligation. This obligation is decided by your ethics or is decided by law. You need to return to the true owner. Is this obligation to return is decided by you and the true owner or it is decided by law? It is decided by law. See, some people may ethically keep it, return it, or some people unethically keep it. But by law, you need to return it to the true owner. Such obligation which is created by law is called as quasi contract. Quasi contract is under section 68 to 72, is under section 68 to 72 is there. Okay, I'll give you example. See this. These are the obligations which are created by law. Such obligations which are created by law under 5 sections are called as quasi contract. So what is the difference between quasi contract and normal contract? In quasi contract, there is no offer, there is no acceptance. True owner did not give you offer, please return my chain, and you did not accept it. But in normal contract, there is offer, acceptance, capacity, free consent. Okay. In quasi contract, obligations are created by law, and in normal contract, obligations are created by parties. Are you able to get this? In quasi contract, there is obligation is created by law, and normal contract obligation is created by parties. Quasi contract is like a duty that you need to return the gold chain, and quasi contract believe on the principle that you cannot enrich at the expense of another. You cannot take the benefit of others mistake, you cannot take the benefit of others mistake, and you cannot enrich yourself. That is a quasi contract. I am repeating again. See example: Suppose there is a vendor who sells fruits. One of the vendor delivered 2 dozens of mangoes at my place. He ring a bell. When I opened the door, there was no one standing, but there was a mango box which contained 2 dozens of mango. I announced, "Who is it? Who is it?" No one is coming. I took the mangoes inside my house. I started consuming the mangoes. Picnic spot. In the evening, the vendor come down. "Sir, we delivered the mangoes wrongly to you. We have the evidence. See, this is the photograph, and in camera we are seeing you taking it. Please return the mangoes." I said, "Sorry, I've already consumed." So he's telling, "Okay, pay the money." I'm telling, "Why I'll pay the money? It's your mistake." But why did you consume? It is not your mangoes. By law, I cannot take the benefit of others' mistake. I need to pay the money. This obligation is created by law, which is called as quasi contract. Which is called as quasi contract. Are you understanding this? Are you yes or no? Are you listening? Are you understanding? Come on, comment. Yes. Hitesh, Anisha, Neha CS, Pujita, Fatima. Very good. Fantastic. Okay. Now continue with this. So this was about quasi contract. Now what do you mean by discharge? When you enter into contract, like I enter into contract with the academy that I will teach. That is my obligation. And they will pay a remuneration. That is their obligation. When we enter into contract, we parties create rights and obligation. When the rights and obligation come to an end, when the rights and obligation come to an end, it is called as discharge of contract. When the rights and obligation come to an end, it is called as discharge of contract. Do you understand this? When the rights and obligation come to an end, it is called as discharge of contract. Discharge means termination, end of the rights and obligation. Very, very clear. So discharge means a contract is said to be discharged when the rights and the obligation are extinguished, come to an end. So there are various discharge methods. There are 6 discharge methods: performance, mutual agreement, lapse, operation of law, impossibility, and breach. I'll explain you, don't worry about it. Okay. See, understand here. Performance. I promised to deliver you car and you promised to make the payment. I delivered the car, you made the payment, we both party perform. Now the contract continue or contract discharge. I promised to deliver the car, you promised to make the payment, you made the payment, I delivered the car, the contract continue or contract discharge. Contract is discharged by performance by both the parties. Contract is discharged by performance of both the parties. Mutual agreement. I agree to sell my car for 5 lakh, you agree to buy it for 5 lakh. But the day I thought it's my first car, I have a different attachment with my car, I should not sell it. And you also thought, let us buy a new car. Why to take a second-hand car? I called you, sir, one request. I don't want to buy your car. You said, sir, it's in my mind. I don't want to buy your car. Both the party mutually ended the obligations and the right. Now tell me, contract continue or contract discharge? Contract continue or contract discharge? Tell me, friends. Yes, correct, Anisha. It will be discharged by mutual agreement. Suppose I have given you loan in 2015. You promised to make the payment in 2016. Now it is 2021-22 going on. 2021-22 going on, and I did not take any action. Already that money is time barred debt. After 3 years, it's 17, 18, 19. Now can I recover money from you or cannot recover money from you? I can recover money from you or cannot recover money from you. I cannot recover money from you because it is lapse of time, it is time barred debt. Now the contract is discharge. Contract is discharge. By law is telling that if any party die, law is telling that if any party die or become insolvent, contract will be discharged, means discharge. Law is telling that if any party die or become insolvent, contract will be discharged. So discharged. By law, certain things are discharged. By breach, I promise to take your car. and you promise to pay 5 lakh. I am not ready, I am promised to give the car and you promise to make payment. You are not making the payment. I said, okay, I will not give the car. You breach the contract. I said, okay, I will not also give the car. Tell me, friends, is the contract discharged between us? Yes or no? Do I need to deliver the car? Do I need to deliver the car? Yes or no? Answer is no. Very clear, because there is a breach and there is impossibility. Suppose, example, Shah Rukh Khan promised to do stage show on Christmas Day. One day before he is admitted in hospital, example. Now he is into ICU. Possible to perform or impossible to perform? Possible to perform or impossible to perform? Tell me, friends. Possible or impossible? Impossible. So, or I promise to deliver you a Chinese product. After 3 months, government notification come that Chinese product cannot be sold. Now, possible to perform or impossible to perform? What do you think? Possible or impossible? Yes, it is impossible. Now the contract will be discharged. So the contract are discharged by 6 methods. Performance, both the party complete the obligation. Mutual agreement, both the party cancel the obligation. Lapse of time, it becomes time barred debt. You need not recover the money. By law, if anyone dies or become insolvent, contract discharge. Impossibility, now it is not possible to perform. And breach, the other party did not complete the obligation. Read these 6 methods. Okay, so I hope you are understood with this. This is very clear and you are getting a clear idea about it. So these are the various methods where discharge will take place, but in this, breach is given in detail. Discharge by breach is given in detail, and we're talking about this breach and what are the remedies. What are the remedies in breach? What are the remedies for breach? Okay, let us understand this. What do you mean by breach? Breach means party refused to perform or party failed to perform. Example, I committed that I will pay you 1 crore and take your flat, but I failed to give you 1 crore. I failed to give you 1 crore. Very, very clear. Or I don't want to give you 1 crore. I don't want to buy your, my performance is defective. I do not perform. I don't offer for performance. I did not offer that I will give you 1 crore. Now I have done breach. I failed to perform or refuse to perform. That is breach. Very, very clear. Understand this. I'll give you example. Breach of contract. Breach of contract. Failed to perform or refuse to perform. Refuse to perform. Very, very clear. You fail to perform or refuse to perform. Breach are of two types. Actual breach actual breach, and second type, ignore my international writing, and anticipatory breach. Breach are of two types, actual breach and anticipatory breach. So what are these two types? See, example, painter is being appointed and he will come down on 10th November to paint the whole office. On 10th November, he do not come, or on 10th November, he called and said, I will not come down. When due date is there, on that day he is denying performance, is actual breach. He promised that he will come on 10th November. On 1st November, he called and tell that, sorry, I am unable to come. On 1st November, in advance, he is telling that is anticipatory breach. So when breach take place on due date, it is actual breach, and with breach takes place before due date is which breach? Anticipatory breach. If breach takes place on due date, it is actual breach, and it takes place before due date, that is anticipatory breach. In this, I have two options. That painter who was planning to come on 10, he on 1st November he informed that he will not come. So I'll tell, okay, leave, I'll appoint another painter. So can I cancel the contract? Yes, I can cancel the contract. I can resend the contract. Very, very clear. I can cancel the contract or I can resend the contract. Very clear, friends. Yes or no? Do you understand this? Are yes or no? Tell me, tell me. I can cancel it or I can resend it, to be very clear. Okay. So up now understand here, same way, or I can tell no, no, don't do this way. We trusted you. Now we don't have any other person. You have only come. We'll wait for you. So we have another option. Wait till due date. Wait till due date. Either we can cancel it immediately or we can wait till the due date. So we have two options. Very clear, guys. So they have written the same way. Course of action for anticipatory breach. What do you mean by anticipatory breach? That breach which takes place before due date is anticipatory breach, and the breach which takes place on the due date is actual breach. Anticipatory breach, there are two things: cancel the contract or wait till the due date. Cancel the contract or wait till the due date. Do you understand this? So either he can cancel it or wait till the due date. These are the two options which are available. Do you understand this? Yes or no? Let us take certain example. See the landmark case. Okay, the landmark case is A hired B in April to act as a courier commencing employment from 1st June, but wrote to B in May that he is cancelling the contract. Now B can file a case for breach immediately after repetition. Okay, see what happened. He appointed in April one employee from 1st June. Now in May he is telling that he will not appoint. He is cancelling the appointment. That is called as which breach? That is called as basically anticipatory breach. Same way, A hired B ship to carry the cargo from Russia. Later on, B repudiated the contract. A delayed taking action, hoping that he would change his mind. What A is doing? Waiting. He hired a ship. They delayed. They did not. They cancel it. Okay. Now he is hoping that he will change the mind before performance. War broke. Now let's see what is happening. I'll tell you. Wait. Just hold on. Example. Now you are waiting till the due date. There are two things. Example. Shah Rukh Khan promised that he will perform on Christmas 3 dances and will charge 10 crore in the event. Okay. So now what is happening in this case? Shah Rukh Khan promised that he will dance on 25th December. On 1st December, Shah Rukh Khan said to the event company that he will not do the show. He will not do the show. So which breach it is? Tell me, friends. Which breach it is? 25th December, Shah Rukh Khan promised that he will perform. On 1st December, he denied performance. Which breach it is? Actual breach or anticipatory breach? Actual breach or anticipatory breach? It is anticipatory breach, correct, Preksha? Okay. Now, what event company have an option? They'll tell, okay, sir, you not coming, we also not make the payment. We appoint Akshay Kumar to come and dance. Or they'll tell, no, no, sir, don't do this. Based on your popularity, we have taken the booking also. We believe that you will come. Now, 25th, before 25th December, on 15th December, there is COVID guidelines that there is a COVID guidelines that no social gathering and no public gathering allowed. Now Shah Rukh can tell, sir, now see what can I do? Even if I'm ready, now government is not allowing. There is supervening impossibility. There is an impossibility. So there is a change of law. So now it may happen that promiser, who is promiser? Shah Rukh Khan can take advantage of impossibility. He can tell that, see, government is only not allowing now. What is my mistake? Or now Shah Rukh Khan is like, okay, done. I'm ready to come on 25th. Now event companies deny, not allowed. Promiser is ready to perform. Event companies denying, not allowed. Now event company need to take his acceptance. Very clear. Now promiser ready to perform. Now promisee cannot deny performance. Very clear. So guys, this is what are the remedies available. What are the remedies? See, first thing, the remedy. If I promise to deliver the car, I don't deliver the car. Can you claim a damage from me? Yes or no? If I promise to deliver the car, I don't deliver the car. Can you claim damage from me? Yes or no? Yes. Very clear. Suppose example, from a gold shop, I promised to buy 10-gram gold for rupees 50,000. Now the gold shop did not give the gold. I took gold from another shop 55,000. There is a loss of 5,000. I have to pay extra because the market price increased. A ready to buy gold from B, but B did not deliver it. Now A is taking the gold from C for 55,000. He need to pay extra 5,000. Can he claim damage from B? Yes. But in every situation, damage is not a remedy. In every case, damage is not a remedy. Example, my ancestral property is with Anisha. Example, I called Anisha that please sell my ancestral property. I am ready to pay any amount. Anisha is telling, give me 5 crore. Okay, done. We signed the contract. I have given 5 crore. Now, Anisha is denying to give the property, breach the contract, telling take this money back, take interest, take damage. Well, no, don't give me damage. Damage is not the solution. I want the property only. I will go in the court and tell that buying another property will not serve my purpose. I want only that property. I want the promiser to complete the promise, fulfill the promise. Getting the contract performed is called as suit for specific performance. Getting the contract performed is called as suit for specific performance, and stopping is called as injunction. So what is stopping? I'll give example. Example, A is working with TCS and he promised that he will not work with the competitor. Now A is working in TCS from morning 8 to 3 o'clock, and in the evening 6 to night 2 p.m. he is working with Tech Mahindra. Can TCS file a case against A and stop him from working with Tech Mahindra? Can TCS file a case against A and stop him from working with Tech Mahindra? Yes or no, friends? A is working with Tata Consultancy Services and he promised that Tata Consultancy Services will give you 35 lakhs. Don't work with the competitor. Now A is working with TCS and parallelly working with the competitor Tech Mahindra. Can TCS file a case and stop A from working? Yes or no? Tell me, friends, yes or no? Please comment. Can TCS? Sneha K is telling yes, sir. What about others? I am repeating my question. If TCS have contracted with A that he will not work with the competitor. A will not work with the competitor. A is working with the competitor. Can TCS stop A from working with competitor? Yes. Stopping is called as injunction. Stopping is called as injunction. Stopping is called as injunction, and getting things performed. Getting performed is called as specific performance. Getting performed is called as specific performance, and stopping is called as injunction. Stopping is called as injunction. Getting performed is specific performance. Taking the losses is damage. And what is quantum merit? Quantum merit means as much as earned. I'll give you example. As much as earned. Very, very clear. Example. Now, example. A is a singer. He is ready to sing in a restaurant. He is ready to sing in a restaurant in a week, twice, 2 days per week, and he will work for 6 months. Okay. Now he have sing for, and per day he'll get 1,500. Okay. Now A has sing for 2 days. Now restaurant is denying contract with him. So there is a breach. So can A recover at least money for 2 days? That is 1,500 into 2 days, 3,000 rupees. Yes or no? Can A recover money from, that is singer, at least 3,000 rupees? Yes, that is quantum merit. Recovering the money as much as you delivered is called as quantum merit. Are you understanding this? So now this was about your contract. Now we are coming towards indemnity. Then we are trying to complete guarantee, and then we are coming towards some part of agency, which major part I'll try to complete up, but not complete. Major thing is done for the contract, but now I'm coming towards guarantee contract. Let us come towards guarantee contract and understand. See, what is guarantee? Many things happen. In guarantee, there are three parties. In guarantee, there are three parties. What are the three parties? I'll tell you. In guarantee, there are three parties. Suppose example A. Example, Amitabh Bachchan. I'll give you a brief idea about what is indemnity, guarantee, and agency. Suppose example. Are you listening? Are you there? Who all are present? Just put your name faster. Let me know who all are present. Yes, Pavana, Anisha, Ashlita, Fatima, Nisara, Hitesh. Okay. There is A. Okay. There is A. Amitabh Bachchan. Okay. And Amitabh Bachchan. And there is, suppose example, another one. Amitabh Bachchan. So Rakhi is joining Amitabh Bachchan's firm. So Rakhi is joining Amitabh Bachchan firm. Amitabh Bachchan is not sure to appoint Rakhi or not in Amitabh Bachchan company. So Salman Khan give guarantee that he take the performance guarantee. Rakhi will do it. If Rakhi does not do properly, I am liable. So there are three parties. One is the creditor to whom guarantee is given. Rakhi is the debtor for whom guarantee is given, and who gives the guarantee is a surety. Who gives guarantee is a surety. Another example. Another example I'll take. Suppose Anil Ambani. Anil Ambani is in need of 1,000 crore from State Bank. Okay, Anil Ambani is in need of 1,000 crore from State Bank, SBI. Okay, but State Bank is not sure. Mukesh Ambani tells that give money. If he does not pay, I will pay. So there are three parties. One is debtor for whom guarantee is given. Okay. State Bank is the creditor to whom guarantee is given, and who gives guarantee is surety. So first Anil Ambani is liable to pay the money. If he does not pay, then only Mukesh Ambani will pay the money. So who is first liable? Who is primarily liable? Is it a debtor or surety? Who is primarily liable? Is it a debtor or surety? Friends, tell me. It is the debtor who is first liable, primarily liable, and if debtor makes a default, then only surety is liable. It is secondary liability. This is secondary liability. Do you get this? Do you understand this? So that is guarantee contract. So in a guarantee contract, what is happening? Contract to perform the promise or discharge the liability of a third party in case of default. If he default, he will complete the promise, he will fulfill the debts and the liabilities. If he default, then he will perform. This is guarantee. And in guarantee, there are three parties. One is surety, who gives guarantee. One is debtor, to whom guarantee is given. And one is creditor, to whom guarantee is given. Surety, debtor and creditor. See, very simple. It can be either oral contract, written contract, but in English law, it must be written contract. Let us see what is the example. A has given loan to B and C promises to A that if B does not repay the loan, C will do it. See what has happened. A has given loan to B. So now he is a creditor. He is a debtor. And C promises to A that if he does not pay, he will pay. So this is guarantee contract. Very, very clear. So now in this guarantee contract, what are the scenario? This is guarantee contract. Now let us understand what is indemnity contract. What is indemnity contract? See, in indemnity contract, there are not three parties. There are only two parties. That is, first party is indemnifier and second party is indemnity holder. Example, insurance contract is indemnity contract. See, in indemnity contract, party promises to compensate the loss. If you suffer loss, take loss from me. Party compensate to suffer loss, whether loss is done by you or done by someone else. Example I'll take. Car insurance. A is owing a BMW car and he has taken a car insurance from ICICI Lombard. Now, what has happened? A banked the car against a tree, will pay the loss. A, A car is banked by B, this will be a loss. So there is a understanding between two parties. One is indemnifier who will make good the losses, that is insurance company, indemnifier, and second is indemnity holder, that indemnifier will pay the loss to A, that is indemnity contract. Very, very clear. So let us read this, let us understand this. A contract of indemnity is a contract by which one party promises to save the other party from loss caused by his conduct or by someone else. Caused by his conduct or by someone else is called as indemnity contract. Do you understand this? Yes or no? Please read this. I'm waiting for you guys. Waiting for your comments. Okay. Now I am coming back. So what is the difference between indemnity and guarantee? What is the difference between indemnity and guarantee? Understand here. See, indemnity and guarantee, the very first difference is in indemnity there are two parties and in guarantee there are three parties. Is it right? Let me make an example. In indemnity there are how many parties? Two parties, indemnifier and indemnity holder. But in guarantee there are three parties, that is surety, debtor and creditor. Do you understand? Let me make this, I'll make a new, just hold on. Sorry. Indemnity and guarantee. Okay, let me make a column and let us discuss this one by one. So indemnity and guarantee. In indemnity there are how many parties? Two parties. Indemnifier and indemnity holder, there are three parties. Okay, now if we compare it again, if we compare this again, we are talking about liability. See, if I bang my car or someone else bang my car, first I need to recover from the third party, or I can directly recover from the insurance company. Tell me. My question is, some third party bang my car. Do I need to recover loss first from him, or can I directly recover from the insurance company? Tell me. I can directly recover from insurance company even if I take actions against third party or don't take action against third party. Directly, that is indemnifier is primarily liable. Indemnifier, insurance company, is primarily liable. I need not fight with him. I can directly compensate the loss from the insurance company. I need not fight with the third party. Very, very clear. So here, indemnifier is primarily liable. Okay, liable. But in guarantee contract, who is primarily liable? Surety or debtor? Who is first liable? Surety or debtor? Tell me. Who is first liable? Surety or debtor? Yes, it is the debtor. Debtor is primarily liable. And now if debtor does not pay, then you can recover money from surety. Acha, can insurance company file a case who banged my car? Can insurance company file a case on third party who banged my car? Tell me yes or no. No. They cannot fight with them. I can fight, but they cannot fight. But can surety in case of Mukesh Ambani can file a case against Anil Ambani and recover money? Again I am repeating. See, there are two situations. There is A who is having a BMW car and he has taken ICICI insurance. B come and bang the car. Now A can directly recover. A can directly recover from the insurance company. A can directly recover from the insurance company, right friends? So they are primarily liable. Primarily liable. Now Anil Ambani, okay, Anil Ambani has taken loan from State Bank of India and Mukesh Ambani has given guarantee to State Bank. Now, who is primarily liable? Debtor. Primarily liable. Now he does not pay the money. Can the bank recover money from Mukesh Ambani? Yes. Can Mukesh Ambani file a case and recover money from Anil Ambani? Can Mukesh Ambani file a case if he pays State Bank 1000 crore? Can he recover money from Anil Ambani? Yes or no? Tell me, friends. Yes. But can ICICI Lombard recover from B? No. They cannot file a case on third party, but he can file a case on third party and recover the same. Mukesh Ambani can file a case on Anil Ambani, but ICICI Lombard cannot file a case on third party who banged the car. Very, very clear. Understand this. So basically, here indemnifier cannot take action against third party, but surety can take action against debtor. Same way, what is the object? Compensate loss. What is the main object here? to compensate the loss. And what is the main object here? Guarantee that performance will take place. We are sure, guarantee that performance and money you will get. Performance will take place. So these are the major difference between, that is basically indemnity, guarantee. Now there is a part which is agency. See, when in real life you become a big businessman, you cannot be present on every situation and in every transaction. You do lakhs of transaction, but you cannot be a part of lakhs of transaction. So you appoint someone to enter on your behalf the various transactions. So you appoint someone to enter on your behalf the various transactions. Are you getting this? So you enter on your behalf the various transactions. Okay. So when you appoint someone to enter on your behalf the various transactions, that is called as agency. You are principal and the others are agent. Imagine, can Mukesh Ambani run everywhere? Can he go and enter into business with everyone? No, not possible. So Mukesh Ambani will appoint various representatives who will deal on behalf of Mukesh Ambani. That arrangement is called as agency, and basically Mukesh Ambani will become principal and the person who is being appointed is called as agent. Very, very clear. So see, agent is a person who is employed to bring his principal into contractual relationship with the third party. Agent is mere a connecting link between the principal and the third party. But during the period agent is acting principal, he is clothed with the capacity of principal. He is like a principal. Now, how you create agency? There are various ways you create agency. Understand here. I'll give a chart for this. Creation of agency. First is express. By words you create agency. Like my sister, she has signed a power of attorney, and on her behalf I give flat on rent. On her behalf I collect rent. On her behalf I go in the society meeting. On her behalf I pay maintenance. So there is express agency which is by words. Words can be oral or written. Oral or written, friends. See, like you are going downstairs somewhere, so your parents shall go and get the grocery. We have called the grocery fellow, just collect the bag. On their behalf you are collecting, and you have oral agency where you written contract is not required. Are you getting this? So this is by express. Express is basically by words. See this, express is by words. It can be oral or written. So see, contract by agency may be oral or written. Usually written is power of attorney, which gives authority on behalf of principal, and everything is written. Okay. Now there is implied, and there is next is basically agency by necessity. Okay. There is implied and there is agency by ratification. I'll explain. Don't worry. I'll explain. So what is ratification? See, I sold my father's property and then I took the permission. First I acted agent and then I took the permission. I took the consent afterwards. I took the permission afterwards. When the consent to act as agent is taken afterwards, when the approval is taken later on, is called as agency by ratification. Are you getting this? Example, my staff made the payment and then later on made the payment on my behalf, 10,000 rupees. And when I come to office, sir, we made the payment. You should have asked me. Sorry, sir, there was some, we made the payment. We were not aware. Okay, okay, it's fine. So they took the consent afterwards, later on. That is called as agency by ratification. And you took the consent to act as agent in the beginning. That is express agency. Are you understanding this? Are you listening? Yes or no, friends? See, when the person has no authority to act as agent, the principal is not bound by his act, but the principal may approve it, ratify the agent transaction. In this way, it comes into picture agency by ratification. See, do I have the authority to sell my father's property? Yes or no? Do I have the authority to sell my father's property without asking him? Yes or no? No, but I sold the property and now my father said, okay, now you have done it. It's fine. I approve it. My father has given the authority later on. Such arrangement is called as agency by ratification. Agency by ratification. And now I am coming towards implied agency. That is first, wife as agent. Can the wife go and take the necessaries and make husband liable for the necessaries? Can he go? Can she go and take buy the necessaries, like grocery and everything, and make husband liable? Yes or no? Yes, there is implied authority that wife can bind the husband. Okay, there is implied authority that wife can bind the husband. Yes or no? Are yes or no? Yes. Second, agency by necessity. Agency by necessity. Suppose example, we have we have purchased 10 horses from Delhi to Pune. It is coming in railway, but we were not able to reach and collect our horses on time. We delayed by 2 days. So don't you think it is the responsibility of railway department to look after the horses and their food and everything? Later on, they can collect money from us, but don't you think they should look after the horses and provide food to them? Yes, railway is working like agency by necessity. Agency by necessity. And third is agency by estoppel. Agency by estoppel. So what is agency by estoppel? See, example. Example. The car belongs to my brother. And he's telling the whole world, my own brother, my Mayur Agarwal is the owner, Mayur Agarwal is the owner, Mayur Agarwal is the owner. People believe that I am the owner of the car. Example. Now, on that belief, I sold the car to Ramlal. Ramlal, now my brother is denying, no, he is not the owner. Now, Ramlal will tell, wait, you cannot deny what you said before. Estoppel. You said that Mayur Agarwal is the owner. On that belief, you purchased the car from him. Now you are denying that. You are not allowed to deny it. Such, under this situation, I become agent by estoppel, where someone believed that I am the agent. My brother made a representation that I am the agent. Based on that, other purchased the car from me. Now he cannot deny it. Such situation is agency by estoppel. So guys, with this a major part of contract we have done. I hope you are understanding it. Tell me friends, yes or no? So now we are starting with a very important topic, a topic which is the base of law. A topic which is not only in ET level but also will be in detail when you come to executive level. The topic is Indian Constitution or Constitution of India. Very clear guys. This is the base of law. The mother of every law is Indian Constitution. The highest superior thing in country is the Indian Constitution, and everything comes below the Indian Constitution. There are three pillars of every Indian Constitution or the country, and the Indian Constitution have majorly three. In fact, in sometimes I talk about four pillars, but yes, three pillars are there. So, what are the three pillars of Indian Constitution? I'll just discussing that. Okay, so I'll give you an idea about what are the three pillars of our Indian Constitution. Just hold on. So, first thing, suppose this is Indian Constitution. Okay, now this is Indian Constitution whereby the three pillars are, the first pillar is basically legislation. The second pillar is executive and the third pillar is judiciary. Okay, these are the three pillars. What does legislation do? They are lawmakers. They make law for the country. Okay, and the law is made by Lok Sabha and Rajya Sabha. The law is made by Lok Sabha and Rajya Sabha. Very, very clear. Let us understand this. Rajya Sabha. Okay. That is basically House of People. and Council of States. Executive is various ministries who implement the law. Various ministries who implement the law. Police commissioner, they check whether income tax commissioner, they check whether you are following the law or not. And when people are not happy or people think that the law meaning was not correct, interpretation was wrong, they will approach judiciary, that is courts, where the courts will interpret the law. The courts will interpret the law. Example, like Ministry of Finance, and under ministry there is a Department of Income Tax. Income tax is telling that Geo should pay a tax of 10,000 crore. Geo is telling we are liable only for 3,000 crore as per the calculation and as per the law. Then income tax and Geo are not happy with each other. They will approach judiciary and get a clear idea okay, what should be the scenario. So these are the three pillars of Indian Constitution: legislation, executive, and judiciary. Legislation are lawmakers, executive are law implementers, and judiciary is basically law. Basically, we'll talk about judiciary is law interpreter. Very clear. So if you understand this, see what is happening in the Indian Constitution. In part 2, they are talking about who is citizen. In part 3, when it comes to part 3, they are talking about your rights and as well as your duties. Okay, under 51. Okay, part 4a. Okay, and basically, if I'm talking about under part 4, it is your DPSPs. So, what are the major things you have to do? Part 3 is majorly applicable and part 4 is majorly applicable. Part 3 is basically what are your rights. Part 4 is what are the directions while making law. What are the principles to be followed while making law. And part 4a is about your duties towards the country. And then we are talking about President, Lok Sabha, Rajya Sabha and things. Very, very clear. So let us first understand basically part number 2, under which who is a citizen of the country, who is the citizen of the country and who are considered as a citizen of our part. Very, very clear. So basically citizenship is talked about in article number 5. See, this is something unique. See, in every act we use section, but in constitution is superior. So we will not use section number, we will use article number, which is called dhara in Hindi. Okay, article 370, dhara 370. Getting my point? So guys, this is called articles, whereby in Indian constitution they are said to be basically what? They are said to be articles in Indian constitution, and in the act it is basically the articles. Very, very clear. Now, who is citizen? Article number 5. Those who are born in the territory of India, or whose parents were born in the territory of India, or who is residing in India for not less than 5 years when Indian constitution commenced. Whenever Indian constitution came, okay, obviously Republic Day, okay, so Indian constitution came, okay, and before that 5 years, who come to India and stayed in India for more than 5 years are Indian citizens, are citizen of India. Very, very clear, guys. So understand here, the first thing is that who was born in the territory of India, or either of their parents were born in the territory of India, or basically who has been ordinarily resident for not less than 5 years preceding the commencement of the act or the constitution, will be considered as citizen of India. Who are born in India, who parents were born in the territory of India, and who came into India and stayed for minimum 5 years before the commencement of constitution will be considered as the citizen. Now let us come to directly part 3, because that much is only there. And in the part 3, what are your rights? The rights, fundamental rights. First, article number 12. First, article number 12, they are talking about what is a state. What is a state? Okay. So whenever the state word comes up, see, as per article 12, what do you mean by the word state? Definition. Can you see this? Bear in this bear, article number 12 is defining what? Is defining what? State. Let me show you this. See this definition. In this part, whenever they are telling the state should, so what do you mean by state? State means government of India, state government, local bodies, okay, local bodies and authorities within the territory of India and those who are under the control of government. All these things like central government, state government, local bodies and all the entities which are under the control of the government like government company will also be called as state. Again, I am repeating, as per Article 12, Government of India, government and legislative assemblies, local bodies and the which are under the control of the government will be considered as state. Very, very clear. Now, let us come to Article number 14. What do you mean by equality before law and equal protection of law? See, equality before law. Law will not do any bias thing. Rich will be giving more privileges, poor are not given privileges. Celebrity is given a privilege and others are not given privilege. Whether it is a celebrity, politician, poor, rich, anyone, law is will treat them equal. Therefore, that Anda Kanun we talk about. The law will not do any biasness. Law will protect and law will, treat each and everyone. If it is poor, same punishment. Rich, same punishment. Whether celebrity, they will not be behind, they will not be at home, they will be kept in jail if required. And we have seen India, Sanjay Dutt, Salman Khan, and everyone. I'm not pinpointing particularly, right? So what is my point? Law will treat equally and not give any privilege. That is equality before law. But when it is equal protection of law, see, whether arrest, in a arrest, example, okay, suppose Kassab was arrested, but till the crime was proved and the court order about decision taken, he was given the same privilege. No one should hit him, kill him. He should get food, he should get stay. That was basically because of Indian Constitution. Equal protection of law, whether he is a part of India or not a part of India. We will protect all people right and therefore it is here it will secure all the persons right within the territory of the jurisdiction of Union of India. Very clear. So whether it is a foreigner or Indian, whether it is anyone who stay in India, we will protect every people's right. That is equal protection of law. Very, very clear. Whether it is artificial person, whether it is a company, whether citizen, non-citizen, everything will be the same. That is equal protection of law under Article 14. Then I am coming to 15. Don't discriminate people. Don't discriminate based on religion, race, caste, sex, place of birth, or any of them. Suppose you come, okay, suppose you are men, you are getting more privileges. You are the other is woman, no privileges. Or old and child, same treatment should be done. No discrimination. No Hinduism, no Islamism, Christianity. Everyone is equal in the eyes of law. Constitution is telling that don't discriminate against any citizen. Who will not discriminate? State. The state should not discriminate any citizens on the ground of religion, race, caste, place of birth, and any of them. Similarly, don't discriminate. Okay, you cannot put an entry restriction like only rich can come to mall, poor cannot come to mall. Okay, only this caste can come, this caste cannot come. Can you put a restriction on anyone to access the shop, public restaurants, hotel, and public entertainment, or any tanks, well, road? Only rich people can go from this road, poor cannot come from this road. Such discriminations are not allowed under Article 15.1 and 15.2, but there are exceptions. Can the state make special provisions for women and children for their upliftment? Tell me yes or no. The state can make special provisions for women and children. Similarly, the state can make special privileges for scheduled caste, scheduled tribe, and socially backward and economically backward the citizens who are. Similarly, if I am talking about the state can make provision for educational, okay, provision for scheduled caste, scheduled tribe so that they get private education and whatever may be they get a good education so they can make privileges, and similar fashion they can make special provision for who is economically weaker to uplift them All these are exceptions under Article 15, 3, 4, 5, 6. Are you understanding this? Same way, let us come to 16. Whenever it is a government job, whenever there is a government job, suppose if you are this caste, will give you government job, will make you police commissioner. If you are this caste, you will not make it. Such discrimination based on religion, race, caste, place of birth is allowed or not allowed? Tell me, friends. In case of government job, whenever there is a public employment, such things are not allowed under Article 16. Under Article 16, everyone should get equal opportunities in the matters relating to employment or appointment of office under the state. But also there should not be any description based on religion, race, caste, place of birth, etc. But there are certain exceptions. There are certain exceptions. You have to understand this. Can they tell if we require this qualification only, those will can apply? See, can they give qualification based criteria? Okay, if you are minimum graduate, then only you'll get a government job. Allowed or not allowed? Based on qualification, can they discriminate? Yes or no, friends? Tell me. Based on qualification, can they discriminate? Yes or no? Yes. Based on qualification, they can discriminate. Similarly, are you able to get this? Based on seniority, can they promote? Okay, if those who are senior will be promoted first, those who are junior will not be promoted. Can they do that? Yes, 100% yes. Based on, based on, again, see, based on what I'm trying to tell here, ki if you belong to particular territory, suppose there is a Maharashtra government and they are telling we'll provide job first to all residing in Maharashtra, can that be a criteria? Yes, that can be a criteria to do so. Are you able to understand this? Yes or no? Correct. So this was about this. Then untouchabilities. This is something very bad. See, some people cannot touch the, cannot drink water from tanks. If they touch it, that tap was considered to be, something which is very bad, a curse to everyone. They were boycotted from the society. Such untouchabilities are said to be abolished and no one can continue under Article 17. Abolition of titles. See, what do you mean by titles? Means Raja Sahib, discrimination among people. Britishers did the same. They give the various title to king, queen, and other few people, and other, there was a differences created in the society. Such things is not allowed. Any British titles, any outsider's title, foreign title cannot be used in India just to create a differentiation among society. Like many people were called as Sir, Raja, Raj Bahadur, Rai Sahib, etc. etc. These titles which is trying to create a certain class of persons which are superior, regarded to be superior, will not be allowed. It will create inequality. Everyone is equal. But something, a title like military title, colonel, lieutenant, or educational title, like example, doctor, this CA, this CS, this educational title are allowed or not allowed? Allowed. Okay, so academic and military titles are basically allowed. You are based on your performance keeping that title, but otherwise any title from any foreign state is not allowed. So that is article number 18. That is article number 18. See, any title which is creating inequality among the society is not allowed. And basically, if I'm talking about any title which is creating inequality is not allowed, but military based and academic based titles are allowed. Same way. Now, Article 19 is, see, all our rights. Article 19 is guaranteed fundamental rights. Article 19 is your guaranteed rights which should be protected. Confirm rights. Okay. So what is guaranteed rights? Confirm rights? I'll explain. See, freedom of speech and expression. Are you allowed to keep your opinion in the country? Are you allowed to give suggestions? Yes or no? Or you are not allowed? You are allowed, completely allowed. That is your freedom of speech and expression. And therefore, many times, any politician talk anything. They misuse this freedom of speech and expression. They, like example, I should not talk about, but yes, sometime a politician may talk rubbish, and they're telling it is our freedom of speech and expression. Not allowed. Can you assemble peacefully without arms, like candle march? You do, okay, candle march, you gather for some protest, but it should be peaceful protest with some, without arms and ammunition. Obviously you are not taking rod, knives, okay. So candle march take place many times in the country. You see this, such photographs will tell you this is peaceful protest which is happening, and under the law it is completely allowed, which is there. Are you able to get this? No government can stop you from doing these things. No government can stop you from doing these things. Are you listening, friends? Are you there? Please tell me. Are you there? Okay. Then, forming unions for your welfare. Can you come together and form a union? Yes. Move freely throughout the territory of India. Can you travel to any part of the country? Can anyone stop you from the same? Answer is no. Can you settle in any part of the country? Can you reside and take home in any part of the country? Yes. Can you practice any profession you want to? Everyone have a right. If they want to become prime minister, they can become prime minister. If they want to do acting, they want to become celebrity, they can become celebrity. They can do each everything, believe me. So no one can stop them from doing so. So basically, these are your guaranteed fundamental rights. First is freedom of speech. Second is assemble peacefully and without arms. Third is form association. Fourth is move freely in the any part of the country. Fifth is reside and settle in any part of the territory. Next is practice any profession or carry on any occupation, trade or business. Very, very clear. So these are the various fundamental rights. Okay. So understand here. Let us see in the same fashion. Okay. Next is what? Restriction on freedom of speech. See, this freedom of speech is given, but there are certain restrictions. If your speech is creating violence in the society, creating riots in the society, dangal ho jayega, not allowed. Your speech is spoiling the two country relationship, not allowed. Your speech is, against the security of India, like you are talking about where military is posted and what are your secrets, military secrets, that is not allowed. Press, media cannot report that. They can report only after war, but they cannot disclose it before. Your speech is okay, which is not decent, and it is not moral. Okay, if it is immoral, then that is not allowed. Your speech is like you're taking the help of the court. That court is telling Modi ji is chore, example. Now, so Rahul Gandhi said that. He's using the court name and telling Supreme Court is also telling this. So that is something wrong. Supreme Court did not tell it. Your speech is defaming someone. You have given a speech. Chokidar chor hai. You're telling Prime Minister chor. You're defaming our country and the person. So such speeches are not allowed. See, if it is impacting India's sovereignty, integrity, if it is impacting security of the country, if it is impacting the friendly relation with the foreign state, if it is impacting public order, decency and morality, if it is defaming someone or you are using the contempt of court, such speech are restricted. Very, very clear. So now let us come to the next article. Article number 19 is guaranteed rights. Article number 19 is guaranteed rights. Article number 21 is protection of life and personal liberty. Can anyone personal liberty can be stopped? Even Kasab, he have a right till he was declared criminal. He had the right that to live, have food, good stay. He had a security guard everywhere. Do you understand this? Everyone have a right of protection of life. Not only protection, you'll get food and everything, but you also have a liberty, freedom in the life to develop. That is article number 21. And also Article 21 is telling that live with respect. No one can insult you. Only not live, but live with respect. And like noise pollution, someone is doing noise pollution which is impacting your freedom and impacting your personal life, is against article number 21. Very, very clear. Then article 21A, that is right to education. In India, every child from 6 year till 14 year should get compulsory and free education. So obviously government have made government schools. This is a different story that we people go to private school, but it doesn't mean those who cannot afford are getting free and compulsory education from 6 year till 14 years. Okay. Then right against exploitation, there are two things. Right against exploitation, there are two things. Okay, understand here. Right against exploitation, we'll be talking about two things. If someone is selling human beings, like you are selling human being, trafficking in human beings and beggars and making them beg and collect money, and you are exploiting them, forced labor, they are forced to work 24 hours, you are exploiting them, allowed or not allowed? Tell me friends, what do you think? Allowed or not allowed? Answer is not allowed. 100% not allowed. Similarly, child labor means those who are below 14 years can be employed to work or cannot be employed to work. No, it is child labor. There is a law which punish you. Article 24 is telling child labor not allowed. Article 23 is telling that you cannot exploit the human beings. Then 25, 26, 27, 28 deals with religion. 25, 26, 27, 28 deals with religion. See, can you practice any religion? Can you practice any religion you want to? Suppose I am Hindu, I want to follow Christianity. Or I am Christian, I want to follow Hinduism. Can I change the religion and follow what I want to? Yes. Can I manage religious affairs? Can I conduct, Aarti, Puja, whatever I want to do? Or religious activity? Can I do that? Yes, it's my right. Okay, and those organizations running religious activity are need not pay taxes. They are not being charged that much. Okay, and you can attend any religious workshop. You can attend any religious instructions that is allowed. So basically, Article 25 is telling follow any religion. 26 is manage religious affairs. 27 is they are the payment of taxes, not them for religious institutions, and follow any workshop, any gathering relating to any prayers which I want to under Article 28. So, if your rights are being infringed, your rights are being contravened, your rights are being deprived, what is the remedy? Remedy is you can approach directly to Supreme Court. Remedy is you can approach directly to Supreme Court. Article 32 is giving remedy, whereby there is a remedy, and if your guaranteed rights are being impacted, you can directly raise the matter with the highest court of the land. You need not fight with the district court. You can directly approach Supreme Court for your protection of the guaranteed rights. Under Article 32, Supreme Court can take action and get your rights implemented. Now I am coming to the part 3. Part 3 is not rights. Part 3 is DPSPs. What is DPSPs? Directive Principles of State Policy. Part 3 is, DPSPs, Directive Principles of State Policy. I'll show you this. Hold on. Are you listening? Are you connected? Are you there? Part 3 is DPSPs, Directive Principles of State Policy. DPSPs. I'm waiting for your comments. Yes. What is DPSPs? It starts from Article 36. See, for these DPSPs, the Constitution is telling the state, please follow these guidelines while making law. Please follow these guidelines. Please follow these principles while making law. But you cannot take action to enforce DPSPs. But the state should keep in mind while making law the directions to be followed in case of DPSPs. Do you understand this? So one thing is very clear. DPSPs, suppose there is in the article written, cow slaughtering is not allowed. Can I go and file a case? In DPSP it is written, cow slaughtering should be stopped. Now can I go and file a case by using reference to article? No. But if in the article it is written protection of personal liberty and protection of life, okay, now someone is infringing my liberty and my protection of life. Can I go to the court? Yes. So you cannot go to the court taking into the guidelines of DPSPs. It is just a guidelines which are given to the state while making law. It is the guidelines given to the state while making law. So now article number 36. Article number 36. See, what is state for DPSPs? State policy. State has the same meaning as in part 3. Guys, part 3 state was state government. Do you remember article 12? So article 36 is that for this part, state means the same as given in article number 12. State means the same as given in article number 12. Are you understanding? That is called as DPSPs, Directive Principles of State Policies. So one by one, article 36 is telling that state means the same as given in article number 12. Now let us develop this. What is article number 37? See, article 37 that is telling that can you approach court for DPSPs? Yes or no? Is it enforceable in the court or not enforceable in the court? Please comment. Waiting for a comment. Yes, right, not enforceable. Perfect. Correct commenting going on. So now I'm going forward. Let us understand. DPSPs. DPSPs, basically if I'm talking about, that is article number 37, application of principles contained in this part. Let us understand this. Application of principles contained in this part. State shall not be enforceable by any court, but the principle laid down are nevertheless important, right? So these are the just a guideline. Now what is 38? Every state should try to see social order. Everyone is living peacefully. There is no inequality. Everyone is having good facility, good status. Everyone is getting, like enhancing life to grow. Everyone is getting justice. Everyone is getting political justice, economic justice, social justice under article number 38. Do you understand this? The state should secure social order for the promotion of welfare of the people. The state should work for the welfare of the people. Article 39 is telling that treat men, women equally. Treat men, women equally and see that the resources of the country are used for common goods, not for personal goods. Resources should be used for electricity, food should be given to everyone, common purpose and not for personal purpose. Very, very clear. There should be equal pay between men and women. If men is working 10 hours, woman is working 10 hours, you are giving 15,000 to men and 12,000 to women, not allowed. Equal pay between men and women should take place, and the concentration of wealth in few hands should not be there. Rich becoming rich, not. Everyone should get the benefits and they should work for a common purpose detriment. So these are article number 39. You should work for the health and the strength of the workers and children is not being abused, and childhood and youth are protected against exploitation. Are you understanding this? So article 39 is talking about many things. Treat men, women equally, pay equally to the men and women. Okay, don't concentrate wealth in the hands of few people, work for a common goal. Okay, and health and the strength of the worker and children should not be misused, and children and youth should not be exploited. These are many things said in article number 39. When we come to 39A, see, Law is helping everyone, court is helping everyone, but can a poor afford court? If poor is being exploited, court is open to him, but can he really, do we really apply for the cases? Yes or no? Do we really file a case in the court of law? Answer is no. Why? Because there is a huge legal matter, you require a lot of money, patience, time, and the poor is not having that. So this is ultimately he is not getting justice. This is ultimately he is not getting justice. As per article 39A, to get justice, give them free legal assistance, give them advocate, give them consultation, provide them free legal aid, so that the poor who is economically backward and disabled are getting justice. Then only it will make a sense. Otherwise, poor will be exploited. Provide them free legal aid and help, and for because they are economically weaker and disabled, and therefore as per article 39A, it is equal justice and free legal aid need to be given. That is article 39A. 40, see, villages, we need to appoint panchayat, village panchayat. They will be self independent, so that the things are done at a small scale, groundwork at a faster rate. See, everything cannot be dependent on government. What, where all government will look after? Country is so big, so big population in our country. So let the the villages have panchayat who are self independent, and they can do everything. Article 41 is telling that everyone have a right to work, education, and public assistance. Secure the right of work. Everyone have a right to do what they want to. Take the respective education and public assistance in case of unemployment and age. If they are berozgar, if they are not getting job, they are old age, then guys, they apply to the government, will try to get some assistance for you, help for you. Getting my point? Same way, 42 is telling that provide human working conditions. See, you are giving work, but worker is not getting water to drink. Worker is not getting a place to sit. Worker is not getting a canteen to have food. He is not getting a washroom to have cleanliness. So, are you giving him no ventilation? He is not getting a proper table to work. Tell me, is there a human condition or inhuman condition? All these are inhuman conditions for work, and so you should provide good working conditions and maternity relief. Those who are pregnant, who are expecting a kid, should be given some relief, holiday, and relaxation, so that the health is good and everything is fine. Very clear. Now, give living wages to the worker. See, one is giving wages and one is giving living wages. Give that, don't give a wage that they cut to cut, they have food and they are sleeping. Give them some living wages which increase their standard of living, which increase their standard of living, and which enhances their standard of living. Do you understand this? Do you understand this? Yes or no? Are you listening? Who are there? Please tell. Anisha A, Pujita, Neha CS, Pavana. Okay, so give them good wages so that they are getting a good living conditions. Similarly, okay, let workers also give their opinion in the management. Let everyone grow the industries and establishment. Let them also be a take a part into the management. So they create unions, and the union head go and represent. Have a uniform civil code, one nation, one law. This is a debatable topic. I should not talk this, but best example, if a Hindu is taking a divorce, there is a different method, and a Muslim or Islam, you are taking a divorce, there is a different method. We don't want religion-based things. We want one nation, one rule, whatever may be. So that is called as uniform civil code, and on this India is fighting a lot. Okay, they are trying to create a uniform code everywhere. Okay, same way, free and compulsory education. It is your right as well, and it is a direction also. It is your fundamental right as well as your direction. Free and compulsory education up to 14 years of age is mandatory. Then promote ST, SC and other weaker section and economically weaker section. Give them education and economic interest for their welfare. Article number 46. Duty of the state to level the nutrition level and standard of living and improve public health. COVID, we have seen government done a lot, vaccination, this, that, yes or no. Why are doing it? Because public health is important. Okay, and their nutrition level is important. So provide everything, whatever possible, so that their level of nutrition, standard of living, and public health will increase as per Article 47. So the raise the level of nutrition, raise the level of standard of living, and improve public health so that their standard of living increases under Article 47. Are you understanding this? Yes or no? Yes, 47. 48. Do things for agriculture and animal husbandry. Okay, develop the good cattle, goat, cow, everything which is good cattle we require. Develop modern methods in agriculture, scientific methods, and improve the breeds and prohibit the slaughtering of cow and calves and other things. Okay, so try to get modernization in agriculture, scientific method in agriculture, and improve animal husbandry, improve their breed, and stop the slaughtering of cow. Same way, 48A. 48A, protect, safeguard forest, wildlife, and improve the environment. Protect and improve the environment and safeguard the forest and wildlife. Very, very clear. 48A. 49. Protect all the monuments, Taj Mahal, Qutub Minar, Lal Killa, correct, and which are of national importance is obligatory upon the state. Every government, every state should protect the monuments. So it is our representation. 49 is telling that, and 50 is telling that judiciary system should be separated from executive, and that is there. We have a separate judiciary system, courts and executive. The officers are different who are running income tax department, police department. They are separate. Executive is separate, and judiciary is separate. Then try to promote international peace and security. Have good relation with various countries. Modi ji is doing that. Okay. Obviously, our security is important, but at the same time, international peace. We don't want world war. We don't want war. We want peace. International peace is important, and security is important under Article 51. So all these from 36 to 51 are DPSPs. From 36 to 51 are DPSPs. But when it is DPSPs, now 51A is about your duties towards the country. When you have a right, you also have a duty. So fundamental duties, see, right was in part 3, then your DPSP is in part 4, and duties are in part 4A. Okay, right, if your right is infringed, you can approach court, higher Supreme Court. Okay, but DPSPs you cannot approach court, it is the guidelines. Okay, but now we are coming towards fundamental duties under Article 51A. Fundamental duties under Article 51A. Do you understand this? So let us come to one by one the duties which we are talking about. Are you understanding this? So what are the duties of our towards us? First duty is respect the idols, national flag and national anthem. Whenever there is a national anthem going on, stand up and respect. Respect the national flag. Respect the idols and the institutions which are running this. Okay. Cherish and follow the noble idols who have been fighting for national freedom. Bhagat Singh. Okay. Cherish them, follow them, respect them. Okay. Try to protect India's unity. There are many people are doing tukde tukde gang. They are trying to do fight among our country. They are spoiling our country. They are spoiling our unity. We all Indians are one. Try to protect the sovereignty, unity, and integrity of India, and to defend the country. And whenever called upon, see, whenever there is a war and the country needs you, and they tell you, please come down, we require you, you have to go. You must go. See, at least in our country, there is no compulsory you have to join army. Other countries, if you want government job, first 3 years, first serve in army, then only you can get a government job. Getting my point? So first, respect the national flag, national anthem. Cherish and follow the noble idols. Okay. Protect the sovereignty, unity, and integrity of India. Defend the country. Defend the country whenever called upon. Whenever called upon. try to get common brotherhood spirit. Hindu, Muslim, Christian, all are one. Don't fight. Get the brotherhood spirit and cherish our culture. See, Western culture, Indian culture, our culture is very beautiful. Respect that. A woman wearing a sari is unique culture. We have it. Whenever some elder is coming, we touch their feet is a very good culture. Respect it. Saying namaste is a very good culture. In COVID, foreigner also said namaste. Getting my point? So our culture is also unique. Protect it. I'm not telling others are bad. They are also good. But why not protect our culture? At the same time, improve, protect and improve national natural environment, forest, lake, river. There is a river, you throw plastic, you throw something. No, you protect that. It should be very clean. Best. Whenever you're going in a forest, don't throw things here and there. Okay. Develop humanism and spirit of inquiry and reforms. Scientific temper. Think logically what is happening. Don't just see what you see in social media. Have your own thought process. Have your own way of inquiry. Protect the public property. Bus stand, people throw stones, hit the buses, and it is public property. Tax is being paid, and with that tax money, we're making that asset and work for the excellence of individuals. So these are certain duties which we have to do. See, respect national flag anthem, respect the national struggle who has done for our freedom. Okay, then protect, simple, protect the our culture. Okay, then protect all the national environment. Similarly, develop sense of inquiry and protect public properties, work for the best of human excellence. These are the various things which are basically the happening in the same scenario. Okay, read this. Okay. I hope you are clear. So we are done with duties, we are done with rights, we are done with DPSPs. Are you listening, friends? Are you connected? Please tell me yes or no. Yes, perfect. So now we are developing the further discussions and we are coming towards Parliament. See, Parliament consists of what? Parliament consists of the head. Parliament consists of the head is president and then followed by the Lok Sabha and Rajya Sabha. Okay. Lok Sabha is called as House of People, House of People, and Rajya Sabha is called as Council of States, House of People, and it is called as Council of States. Very clear. Let us see the website. Okay. Let us see the website. Lok Sabha. loksabha.nic.in. This is Lok Sabha, which is Parliament, Lok Sabha, House of People. The speaker is Shri Om Birla. Okay. followed by Rajya Sabha .nic.in. That is, Rajya Sabha is Council of States, which is there under the same. Okay, that is, Rajya Sabha is called as Council of States. Okay, and we have the Supreme, that is President of India. Yes, Ramnath Kovindji is the President of India. Welcome to the website of the President of India. Okay, this is the website, official website of the President of India, who is there. Okay, and he is the superior person in the country. He is the superior person in the country. Very, very clear. Okay, so now let us understand this, how this happens. See, first thing, Parliament. There shall be a parliament for the union which consists of president and two houses, that is Council of States and House of People. Council of States is Rajya Sabha, House of People is Lok Sabha, whereby president is elected by whom? Who elects president? All the members of Lok Sabha, Rajya Sabha and all the members of legislative states and legislative council and legislative assembly all together vote and appoint one president. So basically, president is appointed by elected members of both houses of parliament, and also the elected members of the state government, that is legislative assembly. Elected member of legislative assembly. Now let us understand one by one, what does can president do? See, before that, our country is a federal country or unitary country. What do you mean by federal? Powers are distributed. And what do you mean by unitary? What do you mean by federal? Powers are distributed. And what do you mean by unitary? Unitary means power is at one place. So our country is federal. It is powers are among some powers with state government, some powers with central government, some powers with local body. But in certain cases, it is unitary. So it is both. Our constitution is basically federal, but with certain unitary features. Okay. So now federal means what? There is dual government. There is distribution of power. Obviously, constitution is supreme, and as per constitution, power is distributed. Under constitution, there are three lists: list 1, list 2 and list 3. List 1, list 2, list 3 divide the powers among all the things, and there is separate independent judiciary system, and there is, this constitution is very rigid to amend, so it is very difficult to amend. No one can amend it so easily. Therefore we are following which system? Federal system. Dual government, distribution of power, supremacy of constitution, independence of judiciary, and written constitution with a rigid process. But in certain cases, it is unitary. Unitary means what? Unitary means exclusive power with the top. Like Chief Justice can be appointed by President. High Court judges can be appointed by President. Okay. Then in certain state matters, Parliament will decide. Okay. Then state government is dependent upon funding from the President. From the central. Okay. Then central government can direct the state government in certain cases. Seeing this point, don't you think the powers are concentrated at one place? Seeing these points, don't you think the powers are concentrated at one place? Yes or no? Seeing this point, don't you think the powers are concentrated at one place? Yes or no? Yes, because president is appointing judiciary system, chief justice, judges of high court. Then what is happening here? Okay, making law is done by central government. Law making majorly is done by central government. Then certain special circumstances, parliament can make law related to state matters. Certain special circumstances, parliament can make law in state matters. Then can the central government give direction to state? Yes. And state government is dependent upon central for funding. In this way, the whole is the unitary as well as federal. So in certain cases we are federal and in certain cases we are following unitary system. Now let us come to Lok Sabha and Rajya Sabha. Now let us come to Lok Sabha and Rajya Sabha. What is happening in Lok Sabha? What is Rajya Sabha and everything? Okay. So now this is Rajya Sabha. See, Rajya Sabha consists of 250 members maximum. Out of 250 members, 238 are appointed by every state and union territories, and 12 are nominated by president. The president nominates them on arts, science, sports, education, law. Based on that, president appoints 12 members, and this these are basically all the state representative are sent in the Rajya Sabha. All the state representative are sent in Rajya Sabha, which is called as Council of States. Which is called as Council of States. Let me explain you this. How many members are there? 250. Out of 250, 238 are appointed by states and union territory, and 12 are appointed by the President of India. 12 are nominated by President of India. President nominate them based on arts, sports, okay, etc. etc. There are many grounds. Okay, I'll give you the list. Mary Com. Do you know Mary Com? Must have heard about Mary Com. Mary Com is being elected by President based on sports. See, current members must changes. Mahesh Jetmalani based on law, Sonal Mansingh arts, Ram Shakal social worker, Rakesh Sinha literature, Rupa Ganguly art, Swapan Das Gupta journalism, Sambhaji Raje social worker, Suresh Gopi, Subramaniam Swamy, Ranjan Gogoi and Maricom. Presently there are 11. President can appoint 12 maximum. Okay. So these are the people who are nominated by the president based on this. So see, in Rajya Sabha there are 12 members nominated by president and not more than 238 members appointed by state and union territories. Members nominated by president are based on literature, science, arts and social service. They are elected by the elected members of the legislative assembly. They are elected by the elected members of legislative assembly of the state. Very, very clear. So this was about Rajya Sabha. Please read this. Any query here? Are you understanding? Yes or no? Okay, now let us proceed. So with this was Rajya Sabha. Now we'll talk about Lok Sabha. Lok in Hindi is people, house of people. So Lok Sabha is again like 552 members. Out of 552, 530 are elected not by state, means by people of the state, and 20 by people of Union Territory, and two members is Anglo-Indian community will be appointed by the president. So the total in Lok Sabha is 552. 530 are elected by people of state. Then 20 is appointed by people of Union Territory, and two are Anglo-Indian community president will appoint them. Okay, so this is what Lok Sabha is composed of representative chosen by direct election on the basis of adult. The maximum strength is allowed is 552. 530 is elected by state, 20 by union territories, and 2 by Anglo-Indian community. Very, very clear. Under this Lok Sabha, there is separate active ministers who are actually they are called as cabinet ministers. And this is, see, every 552 don't have all the work. They come and decision making part, but who are active in the work, who are, see, in a, it's like a sleeping partner and a active partner. Do you understand? Sleeping partner just come take decisions and go, but active partner look after day to day working of the government. So that people, that ministers who are looking after day to day working of the government are called as council ministers or council of ministers. So the council of minister directly report to the president. The head of the council of minister is the prime minister. The head of the council of minister is the prime minister, and basically basically prime minister is being appointed, okay, by the president, and then the prime minister can suggest the president who should be in a team, who should be in a cricket match, okay, and the total maximum members in council of ministers cannot exceed 15% of the all the people. See, understand? God bless. Sorry. See, 15% of all the people in the Lok Sabha. Suppose maximum is 550. So if I am talking about, they cannot exceed more than 550 to 15%. Let me take a calculator. My maths is weak. 83. Almost 82 people is allowed in Council of Ministers. So basically, the total numbers cannot, and they enjoy under the Council of Ministers still the president want to, but everyone is responsible to the Lok Sabha. They are accountable to the Lok Sabha. They need to to the Lok Sabha, and these ministers take oath in the presence of the president. These ministers take oath and in the presence of the president. Like if I'm talking about Narendra Modi taking oath in presence of president. God bless everyone. Sorry. Prime Minister Narendra Modi taking oath. President will be standing next to him and seeing that he's taking the oath. Are you getting this? Are you understanding this? Yes or no? Okay. So this was about Council of Ministers. Now we are talking about state government level. At central government, there is Lok Sabha, Rajya Sabha, and head is president. State level head is governor. State level head is governor, and in state level there is legislative council and legislative assembly. Legislative council and legislative assembly. The head is the governor. Obviously, governor is appointed by president, and there is legislative council and legislative assembly. Right, guys? But believe me, both is not there in every state. Okay, the two houses in every state, there will be legislative assembly. But where the state is big, where the population is big, there would be both the houses, that is legislative council and legislative assembly. Okay. So now what is my point? In the following state, there is both legislative council and assembly. Andhra Pradesh, Bihar, Madhya Pradesh, Maharashtra, Karnataka, Tamil Nadu, Telangana, Uttar Pradesh. But in one state, that is basically what called as one state, that is called as that other states, there will be only one thing, that is legislative assembly. Very, very clear. Again repeating. So these states, there are both, that is council as well as assembly, but other state there is only legislative assembly. So what is the term? For how many years they will continue? For 5 years in every state. And again, there is reappointment. Okay. How many members in legislative assembly and how many members in legislative council? Let us discuss that. See, understand, at state level there is legislative, there is legislative council, and there is legislative assembly. In assembly, it is maximum and minimum. Okay, maximum 500 and minimum how much is 60. Minimum how much is 60 for assembly. And what about council? When it comes to council, minimum is, or maximum is how much, and minimum is how much? Minimum is 40 and maximum is one third of the total strength in legislative assembly. One third of the total strength in legislative assembly is the case of legislative council and assembly. Who is the head of the state legislative assembly and council? Is the governor. The head is the governor, which is appointed by the president, and he hold office till the president is telling. But see, in one state there cannot be two, three governors. In one state like Maharashtra or in Gujarat, there cannot be four governors. But one governor can govern 4, 5 states. One governor can govern 4, 5 states. So there shall be governor for each state, but the same person can be appointed for 2, 3 states. But in one state there will be one governor only, and he's having the same powers like president. He's having the same powers like president. Now we are coming towards the judiciary system. The highest judiciary system in the country is Supreme Court. Which is the highest judiciary system, beta? Supreme Court, then High Court, and then District Court, in which civil and criminal courts are different. High Court can take both civil and criminal matters. Supreme Court can take both the criminal and civil matters, but District Court, there will be separate court for civil court, and there is a separate, that is criminal court. Do you understand this? So what was the story before independence? Before independence, there was no Supreme Court. There was no Supreme Court. The highest court was Privy Council. The highest court was Privy Council. Do you understand this? The highest court was Privy Council, okay, which was the highest authority. Then appeals from High Court. See what used to happen earlier, before independence. I'll tell you. This is before independence. Before independence. See what happened before independence. Before independence, the highest High Court, then you appeal to Federal Court. Federal Court followed by, okay, Federal Court followed by Privy Council. Privy Council was the highest. But now in India, High Court and directly there is Supreme Court. So Supreme Court is working like both Privy Council and Federal Court. Supreme Court is working like both Privy Council and basically what called as Federal Court. Do you understand this? Yes or no, friends? Yes or no, friends? Tell me yes or no. But earlier, before independence, was there High Court? Yes or no? Was there High Court? Yes or no? Tell me. Yes, there was High Court. To be very clear, before independence there was High Court, but after independence also there is also High Court. Therefore, Bombay High Court. Now the place is Mumbai, but still the name is Bombay High Court. Madras High Court. Now the place is Chennai, but it is still Madras High Court. It was all before, right, guys? So see this. The Privy Council was the highest authority for British India. Appeals from High Court later was in Federal Court and then Privy Council. Supreme Court in the sense has inherent the jurisdiction of both Privy Council and Federal Court. Supreme Court has inherited the jurisdiction of both Privy Council and Federal Court. The jurisdiction of Supreme Court under Constitution is much more than the two previous courts. See, these two previous court has less power, but now Supreme Court have a lot of power as compared to this. No. So what is Supreme Court? Supreme Court have three powers. It is the highest court. Second, it can pass order. When they pass order, they give order. That's called as writ, and they advise the president. So there are three things. It is the highest court. They pass writ and they advise the president also. Read this. Read this. Okay, understanding this. So this is about High Court, Supreme Court, which is having the high. It is the highest court which passes writ and they advise the president as well. Now, what was about High Court before Constitution? Before Constitution come into picture, High Court was there or not there? Yes, it was there. Some High Court existed before Constitution. High Court in British India was established under the Indian High Court Act 1861. But after constitution also some new high courts are being created, and basically such high courts are there which are seeing all the matters, income tax matters, which are seeing regular courts. Some high court like Bombay High Court, Calcutta, Delhi have civil matters which look after civil trial also, and they also pass it. Now let us come up with the subordinate court. Let us come up with the subordinate court. In subordinate court, the matters like civil wrong, which is private wrong, will look after civil court, and which is public wrong will be looked in criminal courts. In criminal courts, there is magistrate and court of sessions. Court of session is high. See, court have a lot of hierarchy. It is not only there are three courts: High Court, Supreme Court, and District Court, under which there are so many hierarchies we don't know. That's a very clear thing. So basically, there is Court of Sessions and Magistrate, in which magistrate means executive magistrate and judicial magistrate. See, what do you mean by executive magistrate and judicial magistrate? I'll explain. See, executive magistrate means, okay, executive magistrate means which is for immediate public order. Like someone want to do morcha, and someone believes that it will lead to riots. They want to stop the morcha and the peace march or whatever may be. So they will go to the executive magistrate and immediately pass the order. Tell them to pass the order because the public tranquility or the public peace should not be disturbed. So this decision is taken by executive magistrate. But once the crime is done, once wrong is done, now to take a decision in that, that is justice magistrate or judicial magistrate, in which there is second class and first class. See, like it may happen that first class can declare 10 years jail. Second class, example I'm taking, may declare 6 years jail. So power is being distributed. Power is being distributed, and then court of sessions can trial all the offense and have the power to offense any sentence, even death sentence. But before giving death sentence, they will take the high court permission. Before this, they will take the high court permission. Are you understanding this? So in criminal matters, I'll explain you again. Criminal courts are there, which have two things. One is what? One is magistrate and one is court of sessions. Which is superior? Court of session. All of they can declare death sentence, they can tell a lifetime imprisonment, but magistrate cannot declare more. Okay, they are having little less scope. In magistrate there is executive and justice magistrate. Executive is for public order decision, and once the crime is done, then that is justice. And in justice there is second class and first class. In justice there is second class and first class which is taking place. Are you understanding? Okay friends, so these are certain codes which you understand very well. And then there are different big cities. There are in big cities the magistrate is called as metropolitan magistrate. Cities like, Ahmedabad, Delhi, they are metropolitan magistrate. And in other big cities there are also session court, that is city session court. Court of sessions will be called as, see, magistrate will be called in city as metropolitan magistrate, and court of sessions will be called as city sessions. Court of session will be called as city sessions. I hope you are understanding this. Let me connect my charger. Yes. Again, I am repeating. Criminal matters are looked in magistrate and court of session. Which is superior in this? Please comment in the comment section. Which is superior? Which is superior? Which is superior? Superior is court of session. But in big cities, court of session is called as city session court. Okay. And magistrate cannot declare all type, like death sentence. Magistrate cannot declare. Like lifetime imprisonment, magistrate cannot declare. Court of session can declare. Okay. Magistrate, there are two types, executive and justice. In big cities, it is called as metropolitan magistrate. In big cities, it is called as metropolitan magistrate. And magistrate are of two types, that is executive and justice. Executive is like public order, public peace need to be maintained. And once the time is done, then decision is taken in justice. And again, there are two types, first class and second class. Nowadays, there is a special courts, special tribunal. Like for company law, there will be tribunal called as National Company Law Tribunal. For environmental law, we cannot delay decisions. We need to take faster decision. We have created separate court which is called as National Green Tribunal. I'll just show you how. If I put NCLT, so in NCLT, I'll show you the website. This is NCLT. This will look after company law and it is a code for company law. Then, if I'm talking about NGT, National Green Tribunal, okay, greentribunal.gov, this is taking decision regarding environmental law. So these are the courts which are focusing only on one area. See what happens in district court, all matter come down. So decision making is delayed 20 or 30 years. We cannot delay the decision. So where there is importance, we have created special courts which are called as tribunal and which will take faster decision, which is called as special tribunal. So there are labor law tribunal, custom tribunal, there are basically direct tax tribunal, income tax tribunal, okay, competition law tribunals which are there, which is taking faster decisions, guys. And anything, any power to pass a writ, a remedy, you can approach a high court under article 226 and you can approach Supreme Court under article 32. For any remedy, can you approach high court? Yes. For any remedy, can you approach high court? Yes. Can you approach Supreme Court? Yes. You can approach high court under article 226 and you can approach Supreme Court under article 32. So guys, now I am coming towards various writs which are passed by the various courts. Are you listening? Are you present? Tell me yes or no. There are various writs which are passed by the court. Are you listening to me? Yes or no? Waiting for your comments. Yes, you're there. So guys, with this, there are 5 writs you need to understand. Writ of habeas corpus, writ of certiorari, writ of prohibition, writ of mandamus, and writ of quo warranto. Again, I'm repeating. What is writ? Order passed by the High Court and Supreme Court is called as writ. What are the various writs? Habeas corpus, certiorari, prohibition, quo warranto, and writ of prohibition. These are the 5 types of writs which you need to understand. Are you getting this? So one by one, I'll be talking about the writs which are being passed by the Indian Constitution. Basically, High Court, not Indian Constitution, High Court and Supreme Court. Habeas corpus. Habeas corpus means if someone is being detained by police, by government, by state without any reason, without any lawful justification, don't you think his fundamental right of freedom, personal liberty, protection of life is being infringed? If someone is being detained in police is arresting someone and keeping inside jail for 5 days without any reason just to harass, tell me, don't you think that person is right is being infringed? Yes or no? Tell me, comment yes or no. Yes. So that person, to protect himself where he is being detained by the authority, will approach High Court or can directly approach Supreme Court and apply for habeas corpus. And court will ask the detaining authority what grounds you are arrested him, on what grounds you have detained him. If there is no genuine reason, court will tell the detaining authority to release him immediately. You cannot keep him into the custody. Such is called as habeas corpus. Such is called as habeas corpus. Do you understand this? Such will be called as habeas corpus. The best example is Arnav Goswami. Arnav Goswami, the head of the Republic Bharat India, okay, that news channel, he was detained and now he was inside the jail with, against the case which was shut down and clean sheet was given. So police put him behind the bars. He approached High Court telling that, please High Court, I am being detained without any reason. I'm being bodily stopped. My legal right is affected. It is my fundamental right to live with freedom. How can they put me behind the bars? Now, High Court heard both the parties, and High Court said that please release him. You cannot arrest him. There is no reason to arrest him. That is basically habeas corpus. I'll show you how what happened. Okay. The applicant may be prisoner himself or any person acting on his behalf to safeguard his liberty. Okay. An appeal to Supreme Court may also lie. If it is rejected by High Court, you can go to Supreme Court. And if they disobey the writ, then there is a punishment by the court. If the retaining authority don't listen it. Okay. When a prima facie for issue of writ has been, the court will issue a rule upon relevant authority to show cause why the writ should not be issued. Tell us why it should not be free. And if there is no answer, then writ of habeas corpus will be passed. Now, what is mandamus? Mandamus means to command, to get things done. Mandamus means to get things done. If they are not doing it, getting the public duty performed is mandamus. Getting the public duty performed is mandamus. Mandamus is issued against public authority. And generally, if suppose example, okay, this is happening and it is a legal right and getting things done. Suppose example, the lower court is not taking the case. Can the higher court tell us, please take the case, you need to pass the order. Okay. Or the public authority is not doing. Suppose Ganga Safai Abhiyan is not done, is not completed. So now someone filed a writ of mandamus. Court is asking the public authority why the project is delayed. Complete the project. Getting the project done is called as mandamus. Getting the work done by the public authority is mandamus. Getting things done is called as mandamus. Are you understanding and listening to me? Yes or no? Are you listening to me? Yes or no, friends? Yes. So now this is mandamus. Now prohibition. Stopping things done. See, if lower court is not working properly, they are violating, they are not giving principle of justice. Okay, stopping them and taking the case at higher court and Supreme Court. Come, see, getting things done is mandamus, stopping things done is prohibition. Command is mandamus, inactivity is prohibition. Are you understanding this? So now, can they pass a matter? Okay, and can they pass the order of prohibition and stop the inferior court to take the case because they are not. A writ of prohibition is issued to an inferior court, preventing the inferior court from the jurisdiction which is not legally vested to. Suppose that court is not allowed to take the case and still they are taking the case. Can you pass a writ and stop the court? Yes or no? Yes, that is called as prohibition. Can they pass an order against the police? Generally, it is against the court. Okay, but can they stop the police who are not allowed to open the case and they are working it? Yes. So that is prohibition. And if I am talking about the certiorari, what do you mean by certiorari? Okay, see, if the lower court has not given principle of natural justice, if the lower court has contravened principle of natural justice, if the lower court has done some error, if the lower court have exceeded their powers and then pass a decision, now can the higher court and the Supreme Court, High Court and the Supreme Court pass certiorari and cancel the decision and take a decision? Yes or no? If lower court is exceeded their jurisdiction, exceeded their power, if lower court has denied principle of natural justice, not given opportunity of telling, if lower court has done some error, can Supreme Court pass writ of certiorari under Article 32 and High Court pass writ of certiorari under Article 226? Yes or no, friends? Yes or no, friends? Please tell me. So what is all these? I'll tell you. Wait. See, habeas, spelling mistake may take place. Habeas corpus. I'll put a word file. Wait, I'll give a summary. Habeas corpus is to stop illegal detention without any reason there, which is being without any reason, and free person from such detention. Right, friends? That is habeas corpus. Now, mandamus, to command, to get public duty performed by inferior courts and public authority, to get work done if they are not doing. That is mandamus. Mandamus is getting work done. Prohibition means it commands inactivity. It commands inactivity to stop inferior court to exceed its jurisdiction. To stop the one. Okay. Now what is certiorari? Spelling mistake may take place. Just hold on. Certiorari is CERTIOR. CERTIORAR. Certiorari. Certiorari is to what? Certiorari is to slash decision of lower court and take decision because of the following reason. Because there is error which is apparent clear error, or they denied principle of natural justice. Okay, they denied principle of natural justice. Similarly, if I'm talking about in certiorari, they have exceeded their jurisdiction. So that is certiorari. Very, very clear. So habeas corpus, mandamus, prohibition, and certiorari. And last is basically co-warrant. See, this is summary. One line, you'll understand everything. See, habeas corpus is to free the person who is being illegally detained. Mandamus is government is not doing something, public authority is not doing something, order them to complete the work. Prohibition is stopping something which they should not do. Some court is not having the power to take the case, they are taking the case. And certiorari is the court has taken a decision which is something wrong. Okay, which is something wrong, and therefore taking an action. And co-warranto, I'll explain co-warranto. Read this first. So now let us come to the co-warrant. See, co-warranto means challenging the officer or challenging the person on what grounds he is holding that office. If someone should not is not eligible to hold as a as a police commissioner post, and is being taken that position, so asking him on what grounds you are holding that public authority, you are holding that chair, questioning him on his eligibility and ineligibility, and if he is ineligible, removing that person from the position is called as co-warranto. Is called as co-warranto. Example. Suppose example. Rahul Gandhi is telling that he is a member of parliament, but he did not take any part in the election. Suppose example, he is not nominated by president. There is no grounds. Example, or he proved that I have the majority. So prove the majority. A court will ask, please tell on what grounds you are sitting in the parliament, inside the parliament. We challenge your decision. You challenge your position. And now, if he proves it, it's fine. If he doesn't prove it, then he is removed from the office. Such removal is called as co-warranto. Such removal is called as co-warranto. Inquiry. It is an inquiry of the person who is claiming to an office and a position which he is not. Inquiry about the position of a person in an office or position which he is claiming. This is about all the list about the writs which are being discussed. Now ulta we are doing, we should talk first preamble and then we come to the further discussions. But we have not talked about the preamble of the constitution. Let us discuss the preamble of the constitution. So with this, a quick revision which we have done, and we have done 4 topics out of 5. Only there is a small topic, that is CS legislation. We'll be just going through that in brief, just go through, but that topic you need to do it. Otherwise, I've done a major part. See, what is preamble? We all people come together and decide as on 26th November 1949 that we resolve and make this constitution. We make this as superior, that is sovereign, socialist for the people, secular, all religion is the head. We are not giving any particular religion as the official religion. We follow every religion. Democratic republic for the people, appointed by the people, so that every citizen get justice, social justice, economic justice, political justice. Every people get freedom, liberty of thought, expression, belief they want to believe. Equality, everyone is equal, and fraternity, that brotherhood and the lovely relation. We want to secure justice to every citizen. We want to secure liberty, freedom of every person. We want everyone equal and fraternity, that is dignity and the respect. And now with this, we are making this as the sovereign, superior. This is the superior. Every other thing is secondary. This is the preamble of the constitution, which is in the bare constitution also. I'll show you. Constitution of India, and see this preamble, preface, not preamble, whereby it is talking about everything. Okay, just hold on. Preamble. We, the people of India, have solemnly resolved to constitute India to be a which country? India is the government will be the top socialist country, secular country, democratic country, republic country. Democratic country means no one will lead alone. It is a democracy. Everyone have a right, and the government will be appointed by public, for the people, by the people, of the people. And by this, we want what exactly? We want justice to all the citizens. We want liberty to all the citizens, equality among all the citizens, and fraternity to all the citizens. Justice, everyone should get economic justice, political justice, social justice, liberty of thought, expression, freedom. They want to worship, they want to do, and equality of status and opportunity, and promote all fraternity. A good brotherhood relationship among every citizen of India. That is basically called as the preamble. Now there is a small topic which is basically, now if I'm coming towards the next topic, which is elements of CS company legislation, which is talking about you. So we'll just talk about ICSI. See, ICSI Institute, ICSI is headed by, the management administration is done by Ministry of Corporate Affairs. See this, under the jurisdiction of Ministry of Corporate Affairs. Okay, and it is created by Act, Company Secretaries Act. Company Secretaries Act. Okay, 1900 and something, 1980, I guess. Let me check. mca.gov.in. This ministry is the head of for ICSI, and there is an act which we follow. Okay, where there is an act which we follow. There are various acts, LLP Act. So there is Company Secretaries Act. There is Company Secretaries Act 1980. Under this act, this ICSI is being established. ICSI have roughly, see this, you have to use the updated one. In your book it is not updated. So about ICSI, when we click, roughly there are how many members? 65,000 members, and roughly there are 2.5 lakh students of ICSI, with the headquarters at New Delhi, 4 regional offices at New Delhi, Chennai, Kolkata, and 72 chapter offices. 72 chapter offices. ICSI believe, what is the vision statement? What is the vision, motto, and mission? The vision statement is to become the global leaders in corporate governance. Corporate governance means corporate communications. Okay. And how will become that mission? We will develop high caliber professional like you guys. Okay. We'll develop high caliber professional like you guys. And what motto we follow, what slogan we follow, what rules we follow. Speak the truth and abide by every law. Speak the truth and abide by every law. Satyavad and dharmachar. Satyavad and dharmachar. This is a motto. Okay. So understand here. See, first thing, it is a statutory body which is established under Company Secretaries Act 1980. It is managed by MCA, and it is providing top education to CS and best quality standard to members. There are almost 65,000 members and 250,000 students. Headquarters is in Delhi and 4 regional offices at Delhi, Chennai, Kolkata, Mumbai, and there are 72 chapters across the country. There are 72 branches across the country. If you see this vision statement to become a global leaders in corporate governance, and mission statement, if you see, to develop a high caliber professionals and speak the truth and abide by the law, this is the motto. We want every CS to have integrity, complete package, personality, communication, knowledge, trustworthy. Okay, that is reliable. We want them reliable. People should think, if I'm going to CS, they are he'll do by, he is responsible. Ethics, follow the right. Ownership, be responsible. And stakeholder centric. We want 5 qualities from you. Integrity is a complete package in you. Ethics, you should have the rightness. Reliable person, you are a reliable person, people trust you. You are ownership, you are taking the responsibility. And you are stakeholder centric. Very, very clear. So let with this, what is CS? CS is defined, company secretary is defined under Company Secretaries Act and is defined under Companies Act. Let us see the Company Secretaries Act, section 2, subsection 1, sub clause C. CS Act 1980. Under Company Secretaries Act, do you see this? Company Secretaries Act, if I'm going to section number 2, section 2, clause 1, C. Who is CS? Those who are the member of ICSI will allowed to be called as CS. Those who become the member, the day you clear your exam and all your training, you will apply for membership form. You will give membership fees. Institute will give you membership. The day you become member, now you can use the word CS in front of your name. So as per section 21C, CS, company secretary, means a person who is the member of the institute. Company secretary means a person who is the member of the institute. Read this. Right, guys? So this was a definition as per CS Act. Let us see Companies Act. Let us see Companies Act. I'm opening Companies Act, and under Companies Act, let me see whenever they use the word secretary or company secretary. Let me see section number 2. Section number 2. Whenever they use the word company secretary or secretary, it means one and the same. Let us see what they are trying to tell. Under Companies Act, you are identified, right, guys? So let me come to this. Section 2, subsection 24. Company secretary or secretary means CS as defined under 21C of CS Act and who is appointed to perform the function of CS under this Act. So this Act is referring to which Act? This Companies Act is telling it has the same meaning what is there in Company Secretaries Act. It has the same meaning as what is there in Company Secretaries Act. Do you understand this? Yes or no? So CS means the same as per the scenario. Very, very clear. And now CS is also considered to be the key managerial person, very important person. Under Companies Act, when you see key managerial person, very important person, that is the head of the company, an important position. Let me show you the Section 2, subsection 51. Key managerial person means CEO of the company, managing directors, company secretary is also the key managerial person. Whole time director, CFO, and such other officer will be key person, very important person. So, company secretary is also the is recognized key managerial person who need to appoint key managerial person. All the listed companies and the companies, public company having turnover more than paid up capital more than 10 crore. Who need to appoint KMP? I'll tell you. KMP is appointed by the listed company and those public company which is having paid up capital more than 10 crore is called need to appoint the whole time KMP. So guys, this topic is very small topic you can do on your own. It's a learning topic. With this, it was a fantastic journey of 10-12 hours with you. I enjoyed this quick marathon and a quick revision, whatever word I'm talking about. Definitely, your feedback matters a lot. You can ping me your feedback on my number, okay, WhatsApp number 80876320076, or ping below the video description and in the comment section so that I come to know. I have done whatever best I can cover up in the 10-12 hours journey. But yes, obviously it's not 100%, but yes, majority things are done. Okay, so it was a great session. All the very best for coming examination. Don't forget my name, that is CA Mayur Agarwal. Keep on learning, keep on rocking, do best, all the very best for your coming examination.